Good morning, everybody. Happy Monday to you all. Welcome back. Day 29. I have a strong suspicion, guys, that Bev has it in her mind that this is going to be the last week of evidence, that after this week, the jury will get the case. And part of the reason I think that is because of all the things I think that we look at Bev, we question Bev. What are her motivations? What is she thinking? What's driving her? Is she corrupt? Is she biased? Is she, what is she? To me, the real front and center characteristic of Bev that drives why I think we've probably got just a week of trial left is laziness. I think Bev just doesn't really like to work all that much. So I think that's part of it. The sooner she can get it done, the happier she's going to be. But we also know she's had some kind of schedule in her mind based on these communications that she's given to the jury throughout the course of everything. Guys, we're ahead of schedule. We're totally on track. No big deal. Nothing at all. Just implies, at least in her mind, that she's got an ending point. I'm guessing it's the end. I'm guessing it's the end of this week. It's just a guess. Just a guess, but makes some sense, doesn't it? We had the estimate last week from Karen's team that defense would be finished by Tuesday, end of day Tuesday. That would give Hank 2 days in rebuttal. And then Friday, we close, we instruct the jury, we hand them the case, and that's that. And then we go have normal lives and so forth until a verdict comes back. Of course, no, we all sit here on pins and needles because then you're full on into the limbo part of the case. Not waiting for the jury to come back. I think I might do a poll. I think it might be about time to do a poll here. We haven't done one for a while, but I am a little bit curious to see what your guys' thoughts are about how we're gonna end up here. What kind of verdict are we gonna get? I am still leaning on the side of a hung jury. All right, I got the poll up today because why not? Let's start Monday with a little bit of a poll. See what you guys are thinking, guys. I know it seems hard to watch this trial. Is again, those of us that have watched this before, it's really hard to separate. Really hard to separate what's happened in this trial from what happened in the first time. And I can't really put myself in a mind state where the jury has never met Brian Albert. The jury has never met Brian Higgins. The jury has never met Trooper Paul. The jury has never met Michael Proctor. Jury has never met all the collaterals, the Matt McCabe, the Julie Albert, etc. It's so hard for me to put myself in that mindset. And so I do wonder if the defense is being mindful of the fact that this jury has much more limited knowledge this time around. I mean, of course, the defense is running the case. I assume they're aware of that. Of course, they know. But it's just difficult as it is to be able to get into the perspective of the jury that knows very little about the case and you who know every single detail. And being able to bridge that gap, it can be difficult in even the best of circumstances. But then I think about that here in this situation where you're doing the second trial, and it's just even more of a complication. And then you've had so many voir dires. A lot of your witnesses have had to testify multiple times. How do you keep that straight in your mind? Here's what he testified to in the first trial. Here's what he testified to in the voir dire. Here's what the jury knows. So it's very hard for me to get myself in that mindset, and I don't have a lot of confidence that I can look at the case the way the jury is looking at it and have a good prediction of what the jury is thinking and so forth. There's just too much other information out there that would make me a particularly bad jury in this case, I guess. But we're getting close enough, I think, to the point where at least the basic battle lines of the case are being drawn. And it is a very different case this time. Real focus from the defense, not just on the data, but on some very basic data. Because we haven't gotten, for example, a fight over Hoslong to dying cold at 227. We handled that on cross, but we haven't called a defense expert to testify about any of that. So could just be resting on that issue on what we achieved in cross-examination. Poke a hole in it, but not put forward an aggressive defense case to prove that that's when Hoslong happened. Not really seeing a fight over the shenanigans, the sketchy behavior by the folks inside 34 Fairview, the butt dials, the getting rid of the phone on the military base. All that stuff seems to be getting cut as collateral. And the focus is not just really on the data, but real specifically on John and John's body. What John's body tells us. And why do I say that? Well, we're going to come back and we're going to finish up with Crash Daddy, Dr. Wolfe. He's on redirect when we left on Friday, so that's where we'll pick back up today. We're finishing up with Crash Daddy, Dr. Wolfe, and he's going to conclude the force calculation that he did, focusing on the damage to the taillight. Damage to the taillight and the rear end of the Lexus in general. What would it look like at different speeds, different types of contact, etc. And so we've already seen there's kind of a basic problem here, which is that you don't generate enough force to break the tail light the way it was in the Sally port. Not just the outer lens of plastic, but the interior components, the diffusers, and even some of the pieces in the back, the tail light housing. So you can't do that even in a full on, even in a direct hit straight on the dummy, but then turn that into a side swipe type of accident, even less less able to generate that type of damage. So we've already got that critique of the Commonwealth's theory of the case in evidence. But we're about to turn to John. Once we get Dr. Rentschler, we're going to take the other side of that force calculation. Newton's law tells us the same force that's acting on the headlight or on the tail light is the same force that was acting on John's body. So we're going to get, as we're closing up the defense case, a focus on John's injuries from a biomechanical standpoint. And then we're also still anticipating Dr. Laposata, the defense's forensic pathologist. So more focus on John from the autopsy type of perspective. And what does the autopsy tell us about whether or not there was a theory here? So if this is the case, we are seeing very much a much more focused defense case. Priority is on John and the data, the vehicle data in particular, and emphasizing problems with the Commonwealth's theory, right? Your timeline doesn't really work because even when you add 30 seconds here, add 20 seconds there, you still end up with John engaging in activity outside the window of that text stream event. And it looks like that's where we're going to leave. Possibly. Looks like that's maybe where we're going to leave the data. Not do a deep dive into the health data, not do a deep dive into the Waze and the clock. And is there more of an offset from the Waze clock? Like all these little things you remember from the first trial. It's not real clear we're going to get them this time. So the focus on John, if that is what is happening and what the defense is doing here, the priority that they've established for their case, it's probably one of the strongest things to focus on, right? Worked for me. John didn't pass the eye test for me from day one. I kept waiting to hear, give me the case, Commonwealth, give me the explanation for how we can look at this guy and be like, oh yeah, car accident. And it never happened. So it's a particularly strong weakness in the Commonwealth's case. Is it going to be enough? That's the $1 million question. Is it going to be enough? So tough call. Good opportunity for a poll. Have a little check-in, see where we're at. I think I'm still leaning towards the most likely outcome being the hung jury yet again. And just a big part of that is, of course, the courtroom that we're in. Every advantage possible is going to be given to the Commonwealth. We already know that. It's already very obvious. But we're getting closer, guys. Getting closer. So if we finish up with Dr. Wolfe today, take Dr. Rentschler. Don't see us getting done with him all the way today. I suppose it's possible, but just seems unlikely. We have Dr. Laposata still expected to testify. Anybody else? That gets us to Tuesday. That gets us to our anticipated time for the defense to be concluding their case. It gets us to Tuesday. Could that be it, guys? What do you think? If they make that call, no Brian Higgins, no Brian Albert, none of those folks. The friend who helped Brian Albert extract his phone over there on the FBI equipment, the tow driver from Dighton, Paul Beatty, all these people that have been on the list. And we've been all thinking, okay, yeah, this time we'll get that tow driver. This time we'll find out why Jen McCabe was blowing up Paul Beatty's phone at 5 a.m. when Karen called. Once again, we might not find out. We might not find out, guys. This is just part of that irony of the trial being a truth-finding process, but at the same time, it's also adversarial. So it's not an information dump. We don't just put everything that we've learned, every bit of testimony, every witness. We don't just put it all in front of the jury. We do it selectively and strategically and for a purpose. So we don't necessarily get to know everything. We aren't going to find out a lot of those details, which I think is, maybe potentially a little bit disappointing. Folks who really want answers, want to know what happened here. Don't know you're going to get it because the way the adversarial system is set up, it's the Commonwealth's job to show us how it happened. Show us how it happened, and it's the defense's job to ask if that's possible. Raise questions about whether that's realistic. Point out where it conflicts with other pieces of evidence. Not really the defense's job to give us the truth of the case. And if the Commonwealth doesn't have the truth built into their theory, then kind of a little bit ironic, isn't it? That this whole trial may go through the whole thing, and it turns out to not be a truth-finding process at all. Just a process of can you come up with a hypothesis, and can it survive being poked at by the defense? So I didn't see, I did check X this morning. I didn't see that there's been any new filings that have come in. And so, at least according to the last advisement we got from Bev, the motions, they've all been dealt with, everything that's been pending. One of those involved the defense witness, Duke Ellington, not Duke Ellington. The defense is not calling Duke Ellington, but they're calling a different Ellington. Richard. Now I don't even remember his first name. Ellington. Not clear if Ellington is going to be allowed to testify. If that motion, the Commonwealth was complaining yet again about when there's late disclosure. We didn't get this stuff in time for us to have a meaningful opportunity to deal with it. And of course, we already know one of Bev's top priorities is making sure the Commonwealth gets a fair trial. So it's not clear if we're going to hear from Mr. Ellington at all. And he was going to focus more on some of that phone data, and in particular, what seemed to be most alarming to the Commonwealth was focusing on what the phone data shows about the phones after they came into the possession of law enforcement. I gotta say, that's tough stuff to leave on the table. If you have that, if you can show tampering with the phones, then it's really not hard to imagine tampering with the taillight, is it? It's not hard to imagine tampering with the shirt. Not hard to imagine tampering with the glass and the bumper sprinkles. And then from there, is it hard to imagine tampering with the photographs, with the metadata, that type of thing? If you can really nail them down on, get them, show that there's a foul here with the handling of a piece of evidence, then it's going to call into question the integrity of the rest of it. And we've got possibilities of that, certainly. The bumper sprinkles, good possibility. No explanation for where that glass came from, just that the rest of it was in Trooper Proctor's hands. Not a particularly helpful fact for the Commonwealth. So we've got a suspicion, we've got evidence that if we're inclined to look at it that way, we certainly can. But no, once again, smoking gun. No smoking gun. Well, guys, if we have these phones and there's a record of some type of action being taken on the phone after it's in law enforcement custody, that's pretty caught red-handed, isn't it? Ring camera video being deleted, for example, isn't that pretty caught red-handed? So I can understand why the Commonwealth is fighting that hard. It would be very difficult to leave that on the table because it would be so beneficial to the defense. And yet then it takes me back once again to, if this is good and this was strong, why did we wait till the 11th hour? Why didn't we have a report on this well in advance of this retrial? Just to keep that from being any kind of question. I mean, if it necessarily depended on some type of evidence coming out at this trial, some type of testimony, then maybe I can see it, but I'm just not sure that it does. Seems to me to be the kind of thing that would be independently admissible. You don't need a foundation of a witness saying they did or didn't do something with the phone, I guess. I mean, wouldn't it inherently raise suspicion if you can show investigators are going in here and deleting stuff, for example? So I do wonder about that. If we don't hear from Mr. Ellington, I'm going to wonder why. Seems like there's a pretty good possibility if we don't hear from Mr. Ellington that it is because Bev has said too late. She's granted that motion from the Commonwealth, discovery violation. You waited too long. And if that's the case, just why? Why did it take? Why did it take that time? I'll definitely wonder about that. I haven't seen anything online from the folks who seem to know. There have been folks that have been getting information about who's going to be testifying next, what's the order of witnesses, and so forth. And we know that the parties are providing that to each other and to the judge. So it's out there, at least in that limited circle. It's not a secret. And so far, what we have learned from that has been accurate. They've called it correctly, and I haven't seen anybody saying, Mr. Ellington gonna be coming on the stand in a matter of hours or so, next day, next couple days. We're getting so close to the end that starting to get impatient for questions to be answered. I just want to know. I know. We've been very patient this whole time, all of these weeks that we've come in and sat here, and maybe it's just because as you get close to the end of trial, you do have a little bit of a sense of time is running out, time is running short. So not that much longer that we're going to have to wait to find out some of these things. If they don't call Mr. Ellington, then that definitely reconfirms that the focus is going to be on John and John's body, and not so much a battle about the phone data, nominal fight about the car data. Did they get enough on Cross? They got a lot of work done on Cross. I don't want to understate that. Witness after witness after witness for the Commonwealth came through and got effectively neutralized by the defense, pointing out problems with your methodology, problems with your underlying information, problems with what you chose to rely on and what you didn't, problems with various assumptions, problems with your memory. We haven't even really put up a super strong fight on I hit him. Definitely enough achieved on Cross that we might be asking questions about it. But there's nobody we can hang our hat on if we're back in the jury room saying it didn't happen. I don't believe that happened. There's nobody we can hang our hat on. No Seraph, no Mulaney, no Kelly, none of those other folks at the scene. Didn't hear it. It's hard not to put up a fight on I hit him without putting on Seraph. The very first one there, he's the one that's in the middle of Katie McLaughlin's story. Her account of hearing it. It's in front of a police officer. Police officer turns. Seraph says, turns, go get Goody. How do you not call Seraph? I say, yeah, none of that happened. Give the jurors that are on your side something that they can go take with them into the jury room and say that didn't happen. Not just because, well, there's problems with the Commonwealth witnesses, their stories don't work, it doesn't add up with the body cam, the dash cam. Give them somebody who'd say specifically, it didn't happen. I didn't hear that. That interaction with Katie McLaughlin, nope, I have no memory of that. But it brings us back to kind of brings us back to the very beginning, doesn't it? Square one. We pointed out you always have to prioritize in a case. You got to pick what's important and what's not, and not focus your attention on what isn't important. It's very true that the most important fact in this case is whether John O'Keefe was hit by a car. It's the most important fact in the case. If John O'Keefe wasn't hit by a car, then the rest of it doesn't matter. It doesn't matter how, it doesn't matter who, it doesn't matter when, the details of the cover-up and the frame job, they don't matter. All that matters is John O'Keefe wasn't hit by a car. So from a technical standpoint, I can really appreciate if the defense does keep it that focused, that tailored. Don't run down all these rabbit holes. You don't necessarily have to. Technically, I hit him. Really doesn't matter. John O'Keefe wasn't hit by a car. But it's nerve-wracking, isn't it? Seems like it's going to maybe take some balls to kind of pull that off.
Hi, good morning.
Good morning, Judge. You're going to have to start with the side. We're going to have a glitchy stream today, it looks like.
So I just saw a transcript that was placed here on maybe referenced this morning, and there's a motion to limit Dr. Rentschler that I just got that I'm not prepared for. So that we'll do later today, okay? All right. So the Commonwealth's motion to call witnesses in rebuttal. I've read everything. Ms. Little, I appreciate you getting your opposition to me. I think I had it by Saturday morning, so I appreciate it. I read all the cases on it. Does the defense want to be heard any further on this?
I read all the cases on it. Like, why do you even have to say that? Tell me you didn't read the cases.
Yes, briefly.
Okay.
With regard to Dr. Crosby and Ms. Coons, as the court...
Speak into a microphone.
Sorry.
Speak into a microphone.
With regard to Dr. Crosby and Ms. Coons, the Commonwealth has been on notice that the defendant intends to present a defense regarding the arm injuries, that this was caused by a dog bite. They have been on notice of that, not just for months, but for years. That was presented at the first trial. The Commonwealth does not have a right to rebut information that they have been on notice of from the start of the case. So their decision to wait for rebuttal to call these two witnesses is improper, and we're asking the court to exclude their testimony.
All right.
As it relates to Dr. Welcher, the scope of his testimony, our request is that that be limited to very specific information, specifically responding to the new testing that ARCA has done. As the court knows, the Commonwealth has proposed a number of new testing ideas, as well as information that is greatly outside the scope of what ARCA intends to testify to. And so we're asking that the court limit their testimony from engaging in new testing that has nothing to do with what ARCA has testified about at this trial. With regard to Dr. Welcher's testimony, the court has made very, very strong rulings that Dr. Wolfe, as well as Dr. Rentschler, are not allowed to speak to the credibility of Dr. Welcher himself. And so some of the information that the Commonwealth proposes is to directly attack the testimony of Dr. Wolfe and Dr. Rentschler. And under the court's rulings, we're asking that the court limit that scope as well.
And I told you I would.
Thank you.
All right.
That's all, Your Honor.
Thank you. Mr. Brennan, do you want to be heard?
Regarding DNA evidence, evidence cannot be rebutted until it is introduced because the defense has a number of potential ideas of areas of testimony. It does not compel the Commonwealth to try to anticipate or deflect attacks, especially if they're meritless. And so the issue of dogs and dog DNA does not become relevant until the defense calls a so-called dog expert. They raise the issue, it's proper grounds for rebuttal. There are 3 witnesses, Ms. Hartnett, UC Davis, and Dr. Crosby. If Dr. Laposata is precluded from testifying about dog bites, we would not call Dr. Crosby as a witness. However, regardless of what Dr. Laposata says, we would ask to call Ms. Hartnett and to call the witness from UC Davis. It is an issue that directly affects the assessment of Dr. Russell, the very expert they chose to call in their case in chief, and so we can now, from my perspective, properly rebut it. The second issue regarding Dr. Welcher, limited to the new information you will see from the testimony or have heard. Most of the testimony is new, but we understand it's limited. We don't expect Dr. Welcher to have a direct comment on the credibility of any witnesses, but he will address the tests, how he believes would be the proper procedure, and there'll be a number of issues that have been raised on direct examination, but he will not in any way have a comment on the credibility of the defense experts.
All right. So the case law supports me allowing this motion. I'm allowing the Commonwealth's motion. So the motion for rebuttal witnesses is allowed. Mr. Brennan has said he will not call Dr. Crosby, depending on the testimony that comes in. So, all right, Jim, I'm just going to give you this.
Thank you.
The case law allows it. Very specific there, Bev.
All right, so the motion regarding the testimony of Dr. Laposata. So the Commonwealth is moving specifically to exclude, there's a motion to exclude irrelevant photographs. We'll deal with that after the main motion to exclude certain testimony. So if we start on page 7 of the report, that's where you want me to start, Mr. Brennan?
You're on.
Okay, page 7 of your report. I have some questions. So, Mr. Jackson, Dr. Laposata cannot opine about the investigation of the case, the law enforcement investigation. She does that throughout her report. So she can't opine to that. But when we get to page 7, what do you say is out, Mr. Brennan? I mean, I've gone through it, I know what I think, but it's the Commonwealth's motion.
I think that her opinion about no object being present to cause a pattern injury is appropriate.
And where are you, on page 7, the first paragraph?
Yes, photographs and descriptions of the site. It is the...
Right, I might have a different page 7.
Might have a different page 7.
So my page 7, okay. Okay, yep.
Dr. Laposata's proposed opinion that photographs and description of the site where Mr. O'Keefe's body was found show no object capable of producing a pattern injury, I think is appropriate. His body was found on flat, grassy ground, probably frozen and covered with a minimal amount of snow. I agree is appropriate. It is the next paragraph where it begins in the middle of the sentence. It is logical to conclude that Mr. O'Keefe was injured elsewhere and his body was moved to the front line. There is no basis in fact for that. It's an improper opinion.
Yeah.
We left the argument.
So I told you that on Friday, Mr. Jackson.
We're not seeking that.
Great, okay, so that's out. And Mr. Jackson, again, the medical examiner erred in her diagnosis of hypothermia. Again, that's the improper critiquing of the expert. She can say that it wasn't hypothermia, obviously. Okay, so same with the first sentence of the next paragraph, the Wisniewski spots were misidentified. Great, all right, so we can probably do this much quicker then. All right.
How bizarre. You can say
All right, so page
it's
8 is
hypothermia. It's not
fine.
hypothermia.
So now we go
but
to
you can't
page
say
10.
the person who said it's hypothermia was wrong.
So this is the dog bites. So if you want to pick it up at, what does the Commonwealth say about this?
At this point, there's no basis provided that she has the training, expertise, methodology.
She's a forensic pathologist.
What's the offer of proof on this, Mr. Jackson?
It will be more extensive when I establish the foundation testimony, but basically she's not only done autopsies involving dog bites and the wound pattern recognition related to the source of those dog bites, she's also taught classes on wound pattern recognition, source of coming up with diagnoses concerning the source of specific pattern of wounds. She has a methodology that she uses. Medical school classes, if I didn't mention the course.
What does she teach? Is this in her CV? Because I didn't see it.
It will be in her foundation that I will lay in front of the jury.
All right.
I won't seek any opinions unless and until the foundation is properly laid, but she has extensive experience, not only with specifically with autopsies that she's conducted herself, but supervising autopsies of others that deal with pattern recognition, the methodology involved with pattern recognition.
How about dog bites?
Dog bites, specifically 5 autopsies. I believe she will indicate that she's done 5 autopsies as they relate to dog bites.
Okay.
A medical school class specifically on the issue of wound pattern recognition, which that class includes dog bite recognition.
All right, so we'll need a short voir dire of her on this before she testifies.
Because the court doesn't believe that I can lay the foundation in front of the jury and just forego a voir dire. I won't ask any ultimate question until we go to sidebar, but I think we could short circuit that.
Well, she's very specific about the dog bites here. So if she's seen 5 autopsies with dog bites, I'm not inclined to give it to you. Okay?
What?
Seen only 5 in her 40 years or whatever.
It's not that she's only seen 5, she's performed 5 autopsies.
Okay, so that's why we need a voir dire. So we need a very short voir dire.
She's also been qualified on the issue of dog bite wound pattern recognition in federal court as well.
Okay.
So she has a plethora of foundations.
Has that been provided to the Commonwealth in advance of today?
I don't know.
None of it has. So here's the difficulty, whether it's a voir dire or it's in front of a jury. I have absolutely no ability to research and cross-examine her on dog bites. She can say she had 1 case or 50 cases, that she testified in state or federal court, or she took a class. I can't verify it, I can't contradict it. I have no ability to prepare for this witness about her basis, methodology, and experience in dog bites. What I have is her showing a couple pictures that she pulled from a book, and then she has some Google or Shutterstock research in her report. And so the idea that she has a history or basis is going to be uncontested, because there's nothing I can do to contest it, and that's not appropriate. I should be able to research. Get
When did
transcripts,
she
vet,
submit her
and,
report?
be able to approach the witness on whether or not
Because
she
pretty
actually
sure
has
it was a
the
while ago,
reliability and education
meet the
experience.
deadline.
We can't do that if we call her and ask her for a jury or a voir dire.
Brother, that's where, if we want to compare apples to apples, Dr. Wolfe, AJ Wolfe, was allowed to specifically testify to the wound pattern, or his interpretation of wound pattern recognition back then. That was nowhere in his report. That was objected to by the defense. Mr. Alessi went to sidebar, strenuously objected, said this is nowhere in the report. We didn't have any notice of this. And the court said, overruled, he's allowed to testify to the pattern of recognition. At least in his mind, he can cross-examine on it. There is no requirement that the Commonwealth have every single case that Dr. Laposata has ever dealt with, dealing with.
No, we had an expert on dog bites who I allowed to testify as to dog bites based on, we had a whole As you know, it was Mr. Alessi, I think, 3 days with Dr. Russell on the voir dire. This is new to me. I'm going to have a short voir dire on to what she can testify to.
I have no problem with voir dire, I just wanted to short circuit it, but
So,
I'm gonna take that.
all right, so let's go on to page 17.
Commonwealth has an objection to the third line. Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. She is not qualified as a reconstructionist or biomechanical engineer. She has tried in other courts and been rejected. She does not have the experience, the background, or the ability to do that improperly.
What do you say, Mr. Jackson?
Your Honor, I believe she does, as a medical examiner, have the experience, and it's the qualification, it's the specific job of, and the qualification of a medical examiner to opine on pattern injuries.
True.
If the foundation is laid, especially as it relates to motor vehicle accidents, and now we're not talking about dog bites, which are a more defined subset of her overall experience. Now we're talking about motor vehicle incidents and accidents that she has specifically seen thousands of.
Okay.
Multiple thousands.
So-
If she does have the qualification to say, if the proper foundation is laid, that the wound pattern that I see on Mr. O'Keefe's arm is inconsistent with anything that I've seen in terms of a motor vehicle accident. I don't know if she said-
Let's just find out how many motor vehicle accident autopsies she's done during that voir dire. What I have a question about is tail lights are typically made of durable polycarbonate or acrylic plastic. I would keep that out. I'd be inclined to allow in the injuries on his right arm do not correspond to injuries that could have been produced by plastic pieces impacting his arm. But let's hear about
That's
that.
appropriate. I wouldn't ask about polycarbonate. I have no intention of asking about that.
And also, the last sentence, I think it's okay, and we'll see with voir dire. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes, assuming she has experience with
and
autopsies of
scrapes.
motor vehicle accidents. But I would keep out the part as would be expected from pieces of shattered tail light. Was there more on that?
I object to that because this is now yet another witness that is coming in under the guise of some type of specialty, but really for accident reconstruction.
All right, so let's see what she says on voir dire regarding her experience with accident victims. I think she gets more into the accident reconstruction on the next page that I don't think is proper.
Which I am not seeking to achieve.
All right, so that whole first paragraph on the next page, you're not seeking to introduce?
Yeah, just one more.
Yeah.
At least the first, we're starting with the first sentence, yes, we would be seeking to introduce that. Pedestrian injuries produced by contact with a motor vehicle include a component tissue crushing force as the car profile protrusions connect. That's basic. I believe that she does have the qualifications to opine about that. That's pretty standard, and that should be admitted.
She has absolutely no experience in accident reconstruction or the injuries. She is not a biomechanical, biomedical engineer. They have one, and he's going to testify to it.
Yeah, I have that as out, Mr. Jackson.
The reason that I believe that it's appropriate is because you don't have to be a biomechanical engineer to understand when you see, for instance, a known pedestrian accident, what are the results, especially if you've seen hundreds or maybe even thousands, what are the results that you typically see in the wound patterns, for instance, crushing forces, broken bones, fractured bones, crushed soft tissue, things of that nature, internal bleeding. That's the province of medical exam.
Okay.
Exactly what they are trained to identify and to opine on.
Okay, so
I wouldn't get into things like, for instance, what she doesn't have the experience to do is say, when a car is involved in a rollover collision, these are the mechanical forces that are exerted on the body during a rollover, and the G-forces that are subject, that the body is subject to in rollover, things of that nature. When a car is impacted head-on by another car, there are a number of G-forces that are put upon the body, etc. Those are biomechanical issues, have nothing to do with her expertise, and I wouldn't be seeking anything like that. But once the body is removed from the car, and then it's on the autopsy table, that's where her expertise begins to fly.
Okay.
She can talk about, and I believe she has the experience and the qualifications to talk about what the body suffers at the hands of a vehicle, pedestrian, incident, or accident.
Okay, so the first two sentences are out. The third sentence, she can testify that Mr. O'Keefe had no bruising on his arms or torso. And she can testify, and she cannot say that would have resulted from the impact with the SUV rear profile. She can say Mr. O'Keefe did not have bruises on his legs. She cannot say from bumper contact, but she can say as shown by dissection of leg tissue and muscle at autopsy. And she can't testify to anything else in that paragraph.
Okay. Your Honor, is the court ruling that she cannot say anything about the human body contacting a motor vehicle? That sounds like what the court's saying.
No.
I think that's too narrow a ruling.
It is. You can put this in, what I said you could put in, can come in, and the rest cannot. We could,
And just for point of clarification, if I ask her, would you expect, I'm just gonna make it a hypothetical, would you expect if his legs were contacted by a moving vehicle, would you expect to see a bruise or contusion?
what do you say about that?
I don't object. One, it's leading. Secondly,
Well, I'm not asking the question.
Secondly, this is asking to have Dr. Laposata do accident reconstruction. She's not assessing a wound. I'd ask you to consider the case of Commonwealth versus Tompkins Appeals Court. I think we provided at 105 Mass Ave 1124, 2025 case. And a similar attempt was made to try to use Dr. Laposata as a biomechanical accident reconstructionist. The trial judge did not credit her proffer and found that she failed to meet the requisite criteria pursuant to Daubert Lanigan. And so recently it's been found by at least another court that she is not competent to do this. Because she's a medical examiner, it does not allow her to come in and start endorsing or vouching for the ARCA witnesses. They already have witnesses to do that. And so not only on page 18, going back to page 17, about the pattern injuries don't correspond to injuries to a light. She would only know that if she had the training experience.
I'm sorry, where?
You said on page 17 you would allow Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by regular fractured plastic pieces impacting his arm. That's not her role as a medical examiner. That is the role of a reconstruction or a biomechanical engineer. And she clearly is not competent, at least as cited by the appeals court, to have that type of opinion. And so there's one thing to assess wounds, there's another to try to correlate or draw a distinction between the wounds in a car collision. It is essentially giving an opinion to the jury, he didn't get hit by a car. That is the core fundamental theory of the defense. This is simply trying
Oh, I thought it wasn't.
a witness to give that opinion. That's improper.
All right.
Thought we already understood it wasn't
Sure.
the ultimate issue.
Mr. Brennan's going to cite the Tompkins case. He needs to cite the Tompkins case. That dealt with a situation in which the witness was called and she was asked by the lawyers, specifically in that case, the people that called her, the lawyers that called her, to opine about blood-stain pattern recognition, blood spatter evidence on the driver's seat versus the passenger seat, and what her opinion was about who actually was driving the vehicle. It was a rollover collision in which people were ejected from the car. She was then asked to opine about blood-stain patterns in the driver's seat and whether that was more or less consistent with the blood, the originator of the blood, one particular individual, was he more likely in the driver's seat or the passenger seat at the time of the bleeding, and was it before or after the rollover? Very, very different set of facts. And of course, that is a biomechanical engineer's province. And the court was correct in saying, I'm not going to credit her testimony on that issue, but that's what she was asked. She opined on it, and the court said, I'm not going to credit her testimony.
All right, so
To do this type of analysis and wound pattern recognition, which is what she's being asked to do.
So let's see with her voir dire this morning.
Okay.
She actually was allowed to testify about blood spatter. It is the reconstruction testimony that she was not allowed to testify about.
I read the Superior Court judge's decision. I have not read the appeals court rescript, so I need to do that. I'd like to get going, but there are photographs of inside the garage. You intend to put this in through Dr. Laposata?
No, not through.
Through whom?
if I could just have.
Yeah, can I do this? With regard to these photos, well, ultimately, the Laposata will be shown them, correct? But they'll be introduced through our investigator who took the photos. We intend to call that investigator after Dr. Wolfe testifies.
And what will that investigator say? These are photographs.
So he will testify to two subject areas. One would be he took measurements from the street to the various entrances to 34 Fairview. I just happened to testify about what those measurements were. And then where he took self photographs, we have pared them down to, I think, 3 or 4, just of one establishing shot showing the garage from the street, and then a couple of photos showing the side entrance to the garage, the pedestrian entrance to the garage, which also shows the interior of the garage, including a step and a
For what purpose? How are they relevant?
I'm sorry?
How are they relevant?
So the defense is presenting a Bowden defense in this case. We are alleging that the police did not do a thorough investigation. They did not really investigate anyone other than Karen Reed. The Commonwealth's own evidence, including the testimony of Ian Griffin, is consistent with John O'Keefe after what they claim to be the trigger event in Dr. Welch's initial report. John O'Keefe walking in a westerly direction, which would be from Fairview Road to the house, taking approximately 36 steps over a distance of 25.4 meters, which is approximately 84 feet. That is consistent with him entering the house. It's consistent with him entering the garage. The police did not take photos of the garage. They didn't investigate, is there a hard surface in the garage? Is there a ridge-like surface in the garage? And these are, photos are introduced on that Bowden issue to say that there was evidence in the house. If the police only went in there, they would have seen that. And that may have sent them in a different direction. So it's relevant for that purpose.
Do you want to weigh in on this?
These are not only relevant and not material, it's misleading. They're not seeking to have measurements from the flagpole to the door. They're trying to seek measurements from the driveway to the door. There is no evidence whatsoever John O'Keefe was ever on, near, or anywhere by the driveway. The evidence is that he was at the flagpole. While the data showed there was a turn westward, it didn't show movement westward. It did not. If there was a measurement from the flagpole to the garage door, that is something that I think would be appropriate. From the driveway, totally irrelevant. There's no evidence, no witness, no substantive evidence in this case that John O'Keefe went in the house, went near the house, was dropped off. They're relying simply on the fact that there were 37 steps. They have no idea what direction or where. What they want to do to argue this is to show inside the garage and then posit a theory that somehow John O'Keefe was killed in the garage, it was colder than it was in the regular house. That would account for the temperature on the battery. They have no evidence to support that. You can't use Bowden as a panacea. You can't just say Bowden, they should have done what we want them to do. It is what is reasonable. The police went into the house. They spoke to the occupants of the house. There was no evidence that Mr. O'Keefe went into the garage. You might as well take a photograph of anybody else's garage in America and put it up in front of the jury. So this is going to create a mistaken, baseless argument that this evidence somehow shows that Mr. O'Keefe was A, in the garage, and B, he was injured in the garage. That's why they want to show it to Dr. Laposata. Couldn't some of these angles have caused the injury? Total speculation, no relevance at all, and it is just prone for an opportunity to mislead this jury. This should not come in.
If I may respond in 4 ways. First of all, Mr. Brennan just informed this court that there was no evidence of movement of the phone. I'd like to quote his own witness. At 12:25:30, the device's bearing shifts to a westerly direction, as location records also show the device moving west from the roadside toward the house. So that was false. Secondly, with regard to, we should be measuring from the flagpole, our theory is not that he entered the house from the area of the flagpole. Our theory is that he was placed at that flagpole, and as Mr. Brennan correctly points out, there's no evidence that they introduced as to where he was on the road prior to walking into the house in that westerly direction. Our theory is as good as his. He cannot prove anything to contradict our theory. The third thing is that Brian Nagel and Heather Maxey saw Karen Reed in her vehicle alone. The passenger seat was illuminated and empty. John O'Keefe was nowhere in the area of that vehicle. He was not in that vehicle. There's only one other place that he could be, and that is in the house. So finally, the fourth point, Your Honor, this court has continually always done, as the court should, a 403 analysis. The probative value we have established through their own witnesses. They called all these witnesses, and they established the foundation for the admission of these photos. There is no unfair prejudice. I argue that anytime there's exculpatory evidence or a case that advances the defense theory, that's by definition going to prejudice the Commonwealth's case. This is not unfair prejudice. He is allowed, Mr. Brennan is allowed to cross-examine this witness and to make whatever arguments he wants to make about the likelihood of the garage being involved or not. But he does not and should not get the benefit of the fact that his investigation, the police investigation, didn't do what we just did. And this evidence should be admitted.
The argument is purely rhetorical. There's not one fact he offers. The witnesses that saw the car saw it in front of them. Nobody ever got out. A light on.
What about the westerly bearing, Hank? That's
factual,
factual, isn't it?
So there is no evidence that Mr. O'Keefe went anywhere near the house, on the breezeway, in the door. It is speculative, it is baseless. They want to take that baseless argument and then bootstrap it to Dr. Laposata to further speculate that something in the garage that could have caused the injury. That is not Bowden. That is not a due process right. That's not 403. It's empty. It's no factual predicate whatsoever.
Okay, so,
The only other thing, just to put a cap on this, the location data circles, again, Mr. Brennan's own evidence, he introduced it, puts John O'Keefe in the house.
all right, so I'm going to allow you to do the measurements. These photos will mark for identification. The photos are not admissible. So, all right, Chrissy, can you just mark those, please? All right, let's bring the jury over. We will do, Mr. Jackson, how long will you be with Dr. Wolfe?
Probably 20 minutes.
All right, and depending
Yes.
on that. All right, so during the morning recess, we'll do the voir dire of Dr. Laposata. All right, let's bring him on over, please.
So, surprise, surprise. Now, Dr. Laposata has almost certainly filed her report back in March, right? Because that's when the defense deadline was. And we had a deadline for motions in limine as well. And yet here we are, all the way this far into trial, entertaining late motions about should we limit her testimony? Why isn't this raised earlier? Why isn't this raised earlier? So yet another voir dire of a defense witness. Welcher with his blue paint and his relying on everything but the scientific evidence to support his opinion doesn't so much as warrant a voir dire. But now, let's see, we've had Green, we've had Russell, we've had both of the ARCA witnesses, and now Rentschler. We've got 5. Have there been any that I forgot? Any other defense voir dires that we had to go through that I forgot about? Now, yet another one for the freaking medical examiner to be able to talk about the injuries, and if she's only autopsied 5 five 5 seems like a lot, Bev. If you'd tried 5 murder cases, I bet you'd be a lot better at this. 5 seems like a lot to see dog bites. But no, if she's only seen 5, she's only autopsied 5 dog bites, that's not going to be enough for Bev. Why 5? What's the basis here? Where's the magic number where you've done enough dog bite autopsies that now you get to opine about it? What about all of Hank's people that have no dog bite autopsy experience whatsoever, but they still get to hypothesize about it? Not sure as we walk away. I mean, yeah, the case law says they get to bring rebuttal witnesses. All right. I guess according to her. Now, UC Davis, we already anticipated that was going to need to come in, right? They got to bring in the no dog DNA, only pig DNA, because they got to try to cure their confrontation problem. Bringing that up with Dr. Russell when it's not in evidence, and the analyst who did the testing hasn't been subject to cross-examination. Yeah, we got a confrontation problem with that if we don't bring that in. But otherwise, Crosby and Hartnett. The case law allows it. Once again, no specificity at all. She's read the cases, and the case law allows it. Classic Bev. Classic Bev. No specificity. Which case allows it and why? Nothing. Nothing like that. This general conclusory, the case law allows it. And I got to tell you, Bev's felicity with the case law is so poor, I'm very skeptical of her reading of it. There's too much of a pattern of misstating, holdings of things, pulling language out that's dicta in the case. It has nothing to do with the circumstances that are presented to her, relying on that dicta that she finds. But, if the issue were about this case, sorry about the audio, guys. I am apparently going to have to put it on mute while we're waiting for the court live stream. This is just messy. Just messy. Bev has far too much of a pattern of misstating the holdings and relying on dicta and so forth. For me to have a lot of confidence that when Bev just says generally, case law says I can do that, case law says it's allowed, can't give that a whole lot of credit personally. So we'll be having a voir dire of Laposata, 5th expert for the defense to have a voir dire, right? Did I count that right? Green, Russell, Wolfe, Rentschler, and now Laposata. Meanwhile, Dr. Welcher can come in and testify to conclusions based on nothing scientific whatsoever. Not so much as a voir dire. 5 autopsies of dog bites sounds like.
Court is now open. You may be seated.
Okay. All right. Good morning again, counsel. Good morning, jurors. So we appreciate your patience. We were in here trying to streamline things, so we got a lot of work done this morning, so thank you. I do have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday? Everyone said no or shook their heads. Right, thank you. Can we have Dr. Wolfe, please?
Mr. I'll remind you, you're still under oath.
All right, good morning.
Good morning.
Welcome back, Dr. Wolfe.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Dr. Wolfe, thank you for joining us again this morning. I'd like to draw your attention to a picture. I'm going to... May I approach, Your Honor?
Yes.
I'm going to show you. Do you remember seeing that photograph?
Yes,
You were shown this photograph last week, is that right?
correct,
By Mr. Brennan, correct?
correct.
Do you recognize the photo as the same photo that you were shown last week?
Yes,
Under questioning. Does that appear to be a photo of, just generally?
it appears to be a photo from of the test dummy from the 29 mile per hour impact test.
Does that appear to be a true and accurate photograph of the condition of the dummy following that 29 mile an hour crash test?
Yes,
With the court's permission, I'd like to enter this as next in order, please. If you could hand that to the court order.
Exhibit 218.
Let's see the crash dummy, AJ. Show us how mangled the crash dummy is.
Permission to present that, Your Honor?
Yes.
Is this the photograph?
yes.
Dr. Wolfe, first of all, what caused the damage? Well, let's start with the most basics. Which arm is this, left or right?
This is the left arm.
What position was, you called this dummy Rescue Randy, is that right?
Correct,
What
yes.
position generally was Rescue Randy in upon impact during this test?
He was oriented such that the right side of his body and his right arm would be contacted by the vehicle.
What caused the defects in the damage to the sweatshirt as we see it here?
That was due to the interaction from the Rescue Randy sliding on the pavement surface to his position of final rest.
Is that sometimes called road rash?
Yes.
Did you see any road rash in any other place on Rescue Randy in this photograph?
Doesn't appear so in this photograph, no.
His chin and his
Highlight the
nose.
face. What about there?
Sorry, I thought you were talking specific to the clothing. Yes, as I mentioned on Friday, there were signs of road rash to the body of the dummy itself, on the face and on the torso and arms.
Can we zoom in on the sleeve a little bit? Do you see any staining on the sleeve as well as the defects, the holes and the tears?
Yes.
What is that staining from?
Again, just from that sliding contact with the pavement, so it's just likely debris and kind of a film from the pavement surface being deposited onto the material. With
regard to John O'Keefe's sweatshirt that you reviewed photographs of, Did you see any other defects other than the right arm and the fact that it was cut off of him medically?
No.
Any other indication or any indication whatsoever of anything that you see consistent with road rash?
No.
Okay, let's go back to the full frame. The second image I'd like you to take a look at. If we can have the lights for just a second.
Show us the rest of Randy.
Do you recognize what's depicted in that photograph?
Yes.
How do you recognize it?
It is the backside of the test dummy from the 29 mile per hour full-on impact test.
Which arm is featured in that photograph?
That would be the right arm.
Move that into evidence as next in order, Your Honor, with the court's permission.
Okay. Exhibit 219?
Permission to display.
Yes.
Does that appear to be the right arm of Rescue Randy as he's face down?
Yes.
Is that following the impact?
Yes.
Do you see any? Were you shown this photograph by Mr. Brennan on cross-examination?
No, I was not.
Can we highlight the right sleeve just a little bit, please? Do you see that defect in the sleeve?
Yes.
Do you also see some artifacts above that defect, above and to the left?
Yes.
Can you tell what those are?
They appear to be fragments from the back window of the test vehicle when it shattered.
Does there appear to be any additional, let's go back to the full frame. Does there appear to be any additional defects on that particular sleeve?
There appears to be some material transfer likely from the pavement and also some road rash.
Does that appear to be transfer from the pavement?
I think that might be a shard of glass from the back window.
What was the condition of the back window after this test?
It was completely shattered.
Okay. The defect that we're looking at, that large gash, was that from road rash sliding on the pavement?
Yes.
If we can go back to the full frame, please. I'd like to show you an additional photograph.
The stuff on John, not around John.
Do you recognize
They
what's
found
depicted in
nothing
that
on
photograph?
John at the scene.
Yes.
What is it?
It is the front side of the test dummy from the 29 mile per hour full-on impact test.
Does that appear to be a true and accurate depiction of the condition of Rescue Randy in that sweatshirt after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph, Your Honor, is next in order.
Okay. Exhibit 220?
Permission to display.
Yes.
Can you describe what we're looking at in this photograph?
This is mainly showing the upper body of the test dummy from the 29 mile an hour impact test, showing the road rash to the front side of the body.
Were you shown this photograph on cross-examination?
No.
What caused the holes in the bodice of the shirt? In other words, the part that covers the chest and the torso.
After the impact, the dummy was projected and sliding on the pavement surface. So again, this is consistent with the front side of the body sliding, making sliding contact with the pavement, creating those abrasions and holes. And again, that asphalt material transfer that you see on the front.
Can you go up back to the full frame, please? Do you see additional road rash? Take a look at his right arm. You see additional road rash on Rescue Randy?
Yes.
On both the fabric and the arm itself?
Correct.
Go back to full frame. And can you see his face as well in this photograph?
Yes.
Are those the chin and nose defects that you saw?
Yes.
Are the defects in the shirt that you see here consistent with the condition of the shirt of John O'Keefe as you saw it in the photographs?
It is inconsistent.
May I approach, Your Honor?
Yes.
Another photo that I'd like to show you. Do you recognize what's depicted in that photograph?
Yes.
What is that? We can take this down.
It is the rest position of the test dummy after the 29 mile per hour impact test.
Were you shown this on Friday?
No.
Is that a true and accurate depiction of the condition of Rescue Randy just from a different angle after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph.
Okay. Exhibit 221.
Permission to display that photograph, Your Honor?
Yes.
Is this an overview of the entire body of Rescue Randy after that impact?
Yes.
Take a look at his torso, the exposed portion of his torso. Do you see road rash on his exposed torso?
Yes.
Do you also see that the road rash that you earlier described on the bodice of the shirt, the front of the shirt?
Yes.
And what
What
about,
his
let's go back to
jeans?
full frame. Is there also road rash on his jeans?
Yep.
Yes.
If we could go back to full frame. Have you ever heard a phrase, knocked out of your shoes?
Yes.
Where are the dummy shoes?
They are still on his feet.
And this is at an impact of 29 miles per hour, correct?
Watch the form of the question.
Sure. What was tell us one more time, what was the speed of this impact?
This was a full-on 29 mile per hour impact.
We can take that down.
Didn't knock him out of his shoes.
May I approach?
Yes.
Take a look at that photograph and tell me if you recognize what's depicted in it.
Yes.
What is that?
It is the back of the test Lexus after the 29 mile per hour impact test.
Is that a true and accurate depiction of the condition of that Lexus following that 29 mile an hour impact?
Yes, and I should be more specific. It's post the 29 mile per hour impact with the test dummy, not just the arm.
Understood. Thank you. The collision that caused the damage to Rescue Randy that we've just been looking at.
Correct, yes.
Okay. Move for the admission of that photograph, Your Honor.
Okay. Exhibit 222.
Permission to display that?
Yes.
Is this the photograph that we were just talking about?
Yes.
And this is the condition of the vehicle after that rearward impact with Rescue Randy, correct?
Correct.
Did the subject vehicle photographs that you looked at, were those consistent or inconsistent with this photograph?
Those photographs were inconsistent compared to the test.
Was there anything consistent about the shirt that you were shown on Friday, the left sleeve that you were shown on Friday with John O'Keefe's actual sweatshirt?
Was any of that consistent with?
Correct. Was that consistent or inconsistent, now that you've seen all the photographs, with the condition of the shirt that John O'Keefe was wearing on January 29th?
The test clothing was inconsistent compared to that of Mr. John O'Keefe's.
Thank you. You were asked on cross-examination several times about the weight of the hybrid 3 arm. Do you recall that series of questions?
Yes.
You were asked how much lighter the hybrid 3 arm was than the static estimate arm, correct?
Correct.
I want to make sure we're clear about this. The hybrid 3 arm is the physical arm that you attached to the ATD and did testing with, correct?
Correct.
The statistical estimate arm is something in the ether, right? It doesn't exist.
Sustained.
How would you describe a statistical estimate arm?
It's probably from taking a sample of the population and getting an average and a high and a low.
Okay. Is that a physical arm? You touch and feel?
No.
Okay. Do you have any information based on everything that you've reviewed at all about the actual weight of John O'Keefe's right arm?
Nothing in terms of a weighed measurement of the arm, no.
Okay.
Fix the math. It bothered a lot of people. I don't know if the jury cares, but
What
it would
was
be
the
helpful to fix the
percentage
math.
that Mr. Brennan gave you in terms of how much lighter the hybrid 3 arm was than the statistical estimate arm that he gave you?
From what I recall, I think the percentage was 26%.
Did you calculate that yourself, or did you take Mr. Brennan's word for it?
I believe I took his word for it.
Do you recall what the weight of the hybrid 3 arm was exactly?
9.38 pounds.
What is the difference, if you can calculate, what is the difference between what was the statistical estimate arm, the number that Mr. Brennan gave you?
I think I heard him say 11.8, but I also think he said at one point 11.6. So I'm not sure of the kind of the final number he landed on.
Does
Sustained is ask the question. Starts right from the end.
does
Not sure what he landed on.
11.86 sound right?
Yes,
Okay. Let's use 11.86. Do you have a calculator with you?
I do.
With the court's permission, could Dr. Wolfe use a calculator if he needs to?
Yes.
Thank you. What's the difference between 11.86 and 9.38? Just in raw numbers?
You're looking at just the difference between those two?
Subtract
Okay.
9.38.
2.48.
Does that mean there's a 2.48 pound differential between the statistical estimate arm, the heavier arm, and the 9.38 arm from the hybrid 3?
Yes, that's the difference in pounds.
All right. How would you calculate how much lighter? What's the proper way to calculate how much lighter in terms of percentage the 9.38 arm is?
You would want to do a percent difference calculation.
Divide 2.48 by 11.86?
Objection.
Sustained. Watch the form, Mr. Jackson.
How would you tell the jurors how you would calculate that percentage difference?
You would subtract the 11.86 minus the 9.38, and then you would divide by the sum of those two and divide by 2, the average of them.
Can you do that calculation?
Yes. Okay.
And what's the number?
23%.
Not 26%?
Objection.
Sustained.
Is 23% smaller or larger than 26%?
Objection.
Sustained. Let's move on from that, Mr. Jackson.
That was one part of the bad math, but can we correct the rest of it? How speed
What
is
is the
not
number that you
acceleration and
get?
weight is not mass.
If you were to divide 2.48 by 11.86.
.21.
In percentages.
21%.
Thank you. was the hybrid 3-arm 21% lighter by that calculation than the 11.86 estimate arm?
Yes.
On cross-examination, Mr. Brennan asked you several questions related to kinetic energy formula, correct?
Correct.
You referenced that. Did you reference that formula in some of your answers?
Yes.
May I approach?
Yes.
Show us the formula. Now do some math for us to show how the 2.5 pounds makes no difference at all in the formula. Not sure what we're approaching for. So good on AJ getting all those photographs in to show. Oh, by the way, that arm with the holes in it, it's the wrong arm. It's the wrong arm. Not real consistent with the arm being scratched by the tail light, is it? Because it's the wrong arm. That was funny. Now, a lot of these, they should already be in if these are photographs that are from his PowerPoint. Because I know we saw some of these, didn't we? If they're in his PowerPoint is in evidence. But if not, then good on AJ to go ahead and get all of these in so that they can see, here's the total condition of the dummy. He's got his shoes on. He's got road rash all over him, including his face and his body and his jeans and all this stuff. He's got the markings, the drag marks and the transfer from the asphalt. None of that on John's clothing at all. So now we're moving on to the bad math. Hank didn't calculate the percentage difference correctly. But that in and of itself isn't huge to me. I mean, okay, 23, 21%, whatever. It's still a difference, right? What matters is why the difference doesn't matter. So I do hope that we are going to get into that. Okay, he got the difference wrong, but if the difference doesn't matter anyway. Guess this sidebar doesn't need everybody.
May I inquire?
Yes.
You're looking at something that's been identified, a document that's been identified as 3 X's, XXX. Do you recognize that? Oh, you're not looking at it.
Not yet.
You see it now.
Yes.
Do you recognize what that is?
It is the formula for kinetic energy.
With that, Your Honor, may we display the formula? We don't have to cut the lights. I think it'll be very obvious.
Yes.
Go ahead and cut the lights anyway.
Can we bring the lights back up and see if that's visible? Can you still see that, Dr. Wolfe?
Yes.
Your Honor, is that okay?
Yes.
Great.
So he could do math in the light.
You said this is the formula for kinetic energy, correct?
Correct.
You were asked a series of questions about whether the weight differential in the hybrid 3-arm would make a significant or material difference in your testing as it pertains to the velocity of the vehicle that you were testing. You remember those questions?
So watch the form again. Ask it differently.
Just foundational.
Remember those questions?
Were you asked about weight differential of the hybrid 3-arm?
Yes.
Were you also asked about whether it would make a material difference to the testing if you didn't adjust for the velocity?
Sustained.
What were you asked in terms of, what was the question that was posed to you about the weight of the hybrid 3 arm versus
Like,
the
I don't know,
velocity
because it made no
of the
sense.
testing?
That there would somehow be an influence on, I think, wanting to make a reduction to the velocity of the vehicle.
Does that make mathematical sense to you?
Sustained is to that point.
Would that have a material difference? With the weight of the arm, at 2.48 pounds, would that have a material difference in the testing that you undertook?
No.
Why is that?
Well, to start, that's one of the reasons why we went above and beyond the 24 miles per hour to impart significantly more kinetic energy to the arm. So if you look at that equation, it's a quadratic equation because you're squaring the velocity. So if you double the velocity, you quadruple the amount of kinetic energy. So you get a significant increase in small changes in speed because of that speed differential.
Did you do a test with just the hybrid arm contacting the taillight at 24 miles per hour?
Yes.
Did you also do a test with that hybrid 3 arm contacting the vehicle at 29 miles per hour?
Yes.
I'd like to talk about those 2 tests. Okay? Can you explain to the jurors what they're looking at? I want to start with going from left to right. What does the E sub K mean in that formula?
So that stands for kinetic energy, which is the amount of energy that an object has when it's in motion and has a velocity to it.
What is the 1/2 on the other side of the equal sign?
Just a constant.
And what does the M, as in Mary, stand for?
So that would be the mass, in this case, the mass of the arm.
And what's the V, as in Victor?
That would be the velocity of the arm as it's accelerated.
Why is there an exponent at the top of the V?
Because you're squaring that. So you're basically multiplying the velocity times itself. So it would be velocity times velocity.
Is this a formula that's traditionally used in accident reconstruction?
Yes, it's very common.
Is it sort of one of the foundational formulas? Okay. When did you learn this formula?
High school.
Probably back in high school physics.
I'm going to ask you, if you wouldn't mind, to walk the jurors through a calculation dealing with the 24-mile-an-hour test using the 11.86 pound statistical arm as an assumption of the weight of the arm.
Okay.
Do you understand?
Honor, may I have a pen and paper to write?
May I approach you, Your Honor?
Yes.
I have a pad here too, if whatever's easiest.
Okay. Whatever is easiest.
Do the math for us. I love it. This is good. I'll just do both of the calculations.
If you assume the mass of 11.86, that's the statistical arm weight,
That's pound. That's not mass.
and you assume the V for velocity is 24 in miles per hour. I don't care about the units, doctor. Just assume 11.86 and 24. Can you calculate this
5.39 kilos.
quadratic equation?
Yes.
What do you get? I want to do it step by step. What's the result of squaring 24?
So you're not concerned about the units?
I do not want to talk about units.
Just, okay.
If you mention the word joules, my head will explode.
That's, I didn't know if you wanted, Newton meters, foot pounds. Okay.
Stop it.
So
Immediately.
just 24 squared
Correct.
is 576.
Do you always, in this calculation, do you always use the exponent first? Do you always do the square first?
Sustained.
What's the first thing that you do in solving for this equation?
You would want to square the velocity, but it's ultimately all going to be multiplied. But yes, you would square the velocity, multiply by itself.
What's the next step after you get 576?
Again, assuming we're not concerned about units, you would multiply by the 11.86.
Can you do that for me and tell me the answer?
How many decimal places do you want? Nearest whole number?
2.
Okay. 6,831.36.
What's the next step once you get that number?
You would multiply by 1/2 or 0.5.
Can you do that for us, please?
3415
That'd be
and some.
3,415.68.
What does that represent in terms of the energy into the taillight? I realize that we're not dealing with the proper units, but does that represent anything as it relates to the energy that's imparted on the taillight?
That would be the energy to the arm
Okay,
that's being transferred.
understood. 3,415.68, is that right?
Correct.
And that was at what mile per hour?
24.
Let's move to a different equation.
Okay.
Now I'd like you to presume different
8.
numbers.
9.48.
I don't know what the question is.
Can you do the same calculation using the 9.38
Yes.
pound arm that you actually used in your testing for the mass?
Yes.
And can you use the velocity of the actual test you did of 29 miles per hour?
Okay.
Don't
And
make
same
it
thing,
messy,
not worried
Alan.
about
Just
units.
do-
Okay.
Do each one side by side.
What's
I
the
would
first thing you
prefer,
do
but
in solving that equation?
So if you square the 29 miles per hour, you will get 841.
What's the next thing you do?
You multiply by 9.38,
What's the number?
7,888.58.
And what's the next thing you do in the equation?
You multiply by 1/2 or 0.5,
And what's that final number?
3,944.29.
That would be the number or the amount of energy imparted on the arm at 29. Is that right? 29 miles per hour?
So ask it differently.
Sure. What is that 3,944.29 number? What does that mean in terms of the kinetic
kinetic
energy?
energy.
That would be the kinetic energy that the arm has if it were moving at 29 miles per hour and weighed 9.38 pounds.
One final calculation. What is the percentage difference between 39, 44, 29 and the other test that we just did, or the other calculation, 34, 15, 68?
But you changed the speed, Alan. This is why I didn't like this. You changed the speed.
So in terms of a percent difference, again, when you're subtracting the two and then dividing by the sum divided by 2, so that's basically the average of the sum, it is 14% difference.
Which of the two tests, the two energy equations that you just did, which represents the higher kinetic energy imparted to the arm? The 24 mile an hour test, that's the hypothetical, or the actual test at 29 miles an hour? Which one?
The 29 mile per hour speed with the arm weight of 9.38.
What does that mean, Dr. Wolfe, in terms of the testing that you did with the lighter arm, 9.38 pound arm, at the 29 mile an hour test, as it compares to the hypothetical 24 mile an hour test?
It would be more force and more energy in the 29 mile per hour impact test.
Even though you used a lighter arm? Potentially.
Sustains to that.
And what was your opinion and conclusion as it pertained to the subject taillight using the 29 mile an hour test What was your opinion and conclusion as it pertains to the subject taillight? Was that consistent or inconsistent with the damage that you saw on the 29-mile-an-hour test?
It was inconsistent.
Thank you, Your Honor. That's all I have.
I didn't love that math. I didn't love it. He changed too many variables and then compared the ones with the different variables.
May I, Your Honor?
Yes.
Did you ride to court with this morning?
Good morning, Doctor.
Good morning.
Doctor, did you have a chance to speak to anybody from the defense this weekend?
Not over the weekend, no.
After you left here Friday?
On Friday, I let them know that I was returning back home, and then I let them know last night that I had arrived, yes.
Did you receive any new information or have any conversation before you came in today?
No.
Now, when we asked you about weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Do you remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Do you remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
I don't know. Remember you answered Attorney Jackson and you said, I don't know where that came from.
Right, referring to, I don't know what source you pulled that 11.8 from.
And so you were suggesting that that is just a number pulled out of thin air, right?
System.
Was that a surprising estimate, 11.8 to you?
I don't know that it was surprising. I don't know what your source is for it.
Well, when you engage in accident reconstruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
I'm not usually doing that part of the analysis, no.
So when you're
I'm usually
relying
doing the
on
arm
body
severing
weight
myself.
and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the number's just on the thin air. If you're doing a study and you have to figure out damage to an arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
Like, if you make it up out of thin air, you have to find a resource, a reliable, vetted resource. True?
I would agree.
And that's what you do.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that the 216-pound, 6'1" man would have an arm that weighs 9.38 pounds? Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective. My specific
Objection.
question is,
It's sustained. Ask the question again.
I'll ask you again, Doctor. Tell us where you got the 9.38 pound value from when considering a 6'1" 216-pound man. Where did you get that from so you could be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you just a very simple question. Dumb it down for me if you can, okay, doctor? Where did you get the source to legitimize using a 9.38-pound arm for a person that's 6'1", 216 pounds? Where is your source to say that arm is validated to use for that size man? Where is that?
Again, it's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, in our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Is that your answer?
Yes.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile, isn't that fair to say?
Correct.
And there is, in fact, a 95 percentile crash test dummy, isn't there?
There is, yes.
Yeah. You chose the 50th percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less. True?
Correct.
The truth is, you have absolutely no study, no paper, no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference or study you can offer us right now, do you?
I don't agree with that, because again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head, and to calculate the force, he adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
You have one paper, one study. I know the answer to this, but let me ask. You have one paper, one study to support that it is appropriate to use the 50 percentile 9.38 arm for a person who is 6'1", 216 pounds. I won't ask you again, but if you can answer this once for me. Do you have one paper, one study?
So I'll take out the commentary. Can you answer that question, please?
Sorry, can you repeat the question?
You have one paper. Give me a name, an author. One paper, one study that supports using a 9.38 arm, 50th percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and is 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
You talked about, however, would you come up with the number 11.8? Like it was something that is curious or foreign to you, right?
Objection.
Sustained.
Are you confused how the number 11.8 would come up?
Objection.
I'm going to allow that.
I'm not confused, I don't know your source for it.
When you do studies, would you agree that the head has a similar weight to the arm and that the weight of an arm would be about 5.48% of a person's body weight?
I'm sure that there's various studies out there that talk about that. Could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer, you're the expert. When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case, dating back to last year, it's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment of the evidence, and you're relying on other people's math? Is that what you're telling us?
I don't
Body
agree with
stuff,
that
yes?
because, as I've mentioned numerous times, Dr. Rentschler and I worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about statistically vetted, that it's 5.48% of the total body weight? Would you agree with that?
It sounds about right, but again, I
Okay.
don't have the percentage off the
So
top
if
of
you
my
take
head.
5.48% of a 171-pound man, which is the crash test dummy you were using, the 50 percentile, what do you get?
You said 5.48%?
Yeah,
Just over 9 pounds,
okay. Close to 9.38?
9.37.
Okay, now when you have 216 pounds, 5.48%,
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now, you said you had some confusion where I'd get that number from, this 11.8.
No, he
Do you
didn't.
remember that?
Yes.
He said he didn't know what your source was.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11, is that the first time you heard of it from anybody, 11 pounds? Is that a new number to you?
I don't understand your question.
Well, you're saying that when Attorney Jackson asked you, where did Brennan get those numbers from? You said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8
Yeah.
or 11?
11.
As I just mentioned, last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony, 11 pounds. Your prior testimony, right?
Yes,
Testified before under oath in this case, didn't you?
correct.
And when you testified under oath, and you were giving a general estimate about the pounds of Mr. O'Keefe's arm, based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath.
Yes.
Right. You can't delete something that's under oath, right?
Sustained.
And so when you feigned confusion on Friday about this 11 pounds,
Sustained.
so when you answered questions last Friday about wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds before yourself, haven't you?
11 is not 11.8.
Yes, but again, I don't know where you got that 11.8 from, so,
Well, we just did the math, didn't we?
yes,
Okay.
I don't know where
And you used a
5.48
calculator to help you, didn't you?
I did, yes.
Calculator works.
Yes.
Okay. You said you wouldn't calculate the difference, but you did. And so what you just went through this exercise is you divided that difference, that 2.48 pound difference, right?
Correct.
And then you divided it by 11.86. Divide 2.48 by from the 9.38.
Okay,
What percentage do you get?
26.
Would you agree with this statement about whether the arm and body weight, comparing the weight of the head to the arm, would you agree that the head and arm are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight? So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so I,
Didn't ask you. I'm asking if you would agree with that.
can you repeat the question, please?
So ask the question.
Does the arm weight
You
weigh
didn't
the
do
same
the
as the head?
calculations. Since when did we get to ask him about the
Or
stuff
the
he
arm
didn't
does weigh
do?
the same as the head, almost identical, because your arm, just one of the arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. Would you agree with that?
I haven't done the calculation, but if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object, if it gets hit center mass, that's going to be even greater force because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
Yes, the source.
He's coming at him from Rentschler's report. They're
Do you agree
talking
with
about
that?
the other side of the
Yes, and
equation.
I think I described that a little bit earlier, is you would increase the mass, you multiply it by the acceleration, that's going to increase your force. Force is equal to mass times acceleration.
Right. So mass has a direct correlation to force. You agree?
Correct.
So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree with that, wouldn't you?
Correct, more force on the arm, yes.
Right. So weight matters, doesn't it, sir?
Yes.
Force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change the weight, same speed, it changes the amount of force.
Correct, yes.
Yeah. Okay.
but not materially.
When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints.
No.
You didn't explain it to the jury that there's a difference in weight matters.
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you explain to the jury about the difference in force when there's a change in weight? When you did all your PowerPoint and calculations, did you break it down for them?
Well, I think it was certainly stated. I mean, I know that we went over Newton's second law, force is equal to mass times acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the speeds, did you explain to us that there's a difference when you change the mass so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate the force for the speed of test so it looked like the collision had to happen at a faster speed to cause a certain amount of damage? Were you doing that intentionally?
No.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have created the opposite illusion, right? You used a weight that was lighter than Mr. O'Keefe's estimated arm.
Right, because again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with Mr. O'Keefe's sweatshirt and his arm, and you gave some opinions about what you would expect for damage to his arm. When I asked you on Friday whether you had any support, any vetted journals, learned treatise, any support whatsoever about whether you should use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
Putting aside the fact that you have absolutely no professional studies or journals to support that you should be using a crash test dummies arm for these type of tests, are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and a person's body? Are you aware whether that exists?
I'm not aware of those studies, no.
As a inquisitive engineer, wouldn't you want to know if there was legitimate studies in your work, in your profession, that suggests or states that you should not be using crash
Well, he's
test
not the one who
dummies
pointed out the damage to clothing, is he?
injury
It was you,
to
Hank.
the
You put the
arm
photo up.
as far as lacerations? Would you want to know that?
I think, again, you're getting confused between my role and Dr. Rentschler. Can I finish, please?
No, objection.
Okay, so, no comment, Mr. Brennan. Answer the question, please.
I wasn't addressing the lacerations or the abrasions to the arm, sir.
You had photographs and you were opining that you would have expected or you would not expect there to be abrasions or cuts on that clothing in your test A and B, didn't you?
There were no holes or cuts in the material, no.
I understand, but you offered opinions. Didn't you offer to the jury an opinion that the abrasions on Mr. O'Keefe's arm were inconsistent with your tests in A and B?
The cuts and the holes are inconsistent.
Sir, when you are assessing cuts and holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
I would agree with that.
Right. And so if there was literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the taillight.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes.
You push a human arm, it's like an indent. You can push in, can't you?
Yes.
And that property of pushing in, if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard. Isn't it?
I don't know that I agree with that.
Well, do you disagree with that?
Well, the hybrid arm is a vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure. Human arm, softer than the hybrid, yes?
Yes.
When you push it, you can push in, much different than the hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
Which creates an easier, tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human that pushes different than the crash test dummy, would you agree that a crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm? Would you agree?
I don't think I would agree with that, no.
When you used the crash test dummy in test A and B, that was the 5'9" dummy?
Yes.
When you considered tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt?
Don't know if I recall the exact size, but I think one of them might have been an extra large.
And then you bought a second one that was medium. So when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large. You used a medium sweatshirt, yes?
Yes.
Because it was a smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in tests A and B, did you?
I don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolfe? And while she's pulling that up, is there a difference between, see that's how that's blue? You see that's medium?
Yes.
So the blue ones that you use to test A and B, correct?
Correct.
The smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Correct.
And then when you used Randy and brought him into the scene, you used the extra large, the gray one.
Correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new.
Correct.
The extra large you put on Randy was new.
Correct.
Did you consider the wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
The wear and tear?
Yes, the wear and tear.
No.
Did you ever consider the differences between a brand new sweatshirt and one that had been worn?
No.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes more easily. Did you do any type of analysis on that whatsoever?
No longer.
Any type of analysis whatsoever on the age or whether it's stretched the same, anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Okay. Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
No.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis and offered an opinion in front of a jury on this?
Specific to impacting an arm with a taillight, yes.
Before you decided to come in and give an opinion,
Nobody's come up
did
with
you
this
take
idiotic
any
idea
study or look
before.
at any journals on fabrics?
No.
Did you consider any of the variables that one would want to consider regarding fabrics before you came in and gave this opinion?
No.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you have never done before, and that you did absolutely no study on fabrics or any of other people's analysis on fabrics in cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. Again, we worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yep?
Correct.
You're the one testifying, giving opinions to this jury, yes?
Yes.
You're the one asking them to rely on your experience and
Now I
training.
am, yes.
True?
Correct.
You're the one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion, putting aside Dr. Welcher, Dr. Rentschler. You have a responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
When wouldn't you? When would it not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes,
single time?
and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
Right. But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in this subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
You wrote a report back on February 12, 2024.
Correct.
In February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair. Do you remember writing in a report, "It is significant to note that the injuries have been classified as abrasions and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis"?
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection is sustained.
I'll move on.
The objection is sustained.
Did you agree with that?
Sustained.
Did you write or endorse these injuries would not result from impact with a non-damaged tail lamp cover and the amount of force required to fracture the tail light cover?
So we're going to see you at Sidebar.
How's your circus this morning, Bev? Are you enjoying it? Are you having a good time with the circus that you have enabled and facilitated here? I don't know. You're allowing it. You'll allow it. You'll allow it. Apparently, Hank now thinks it's up to him whether the witness gets instructed to answer or not. Why would he think that, Bev? Oh, I don't know. Because you allow it. You allow him to run around the courtroom, stinking up the whole place, farting, the whole room with this nonsense. And then we all got to sit around and smell it. That's on you, Bev. That's on you. You're the reason why this is the way that it is. Because you're totally okay with it. Here we are, still weeks in. Not a single boundary has been set. Not a single admonishment of Brennan doing the same thing over and over again. This is not news now. This is the most predictable thing ever, that he's going to ask improper stuff, that he's going to make these improper comments, the little snide commentary, and it's going to be objected to, and you're going to do absolutely nothing about it. That's about as predictable as that we're going to start every day 15 minutes late at this point. We've seen it so many times, we know exactly how it's going to go. He's going to fart all over the courtroom and it's going to stink. And you're going to do nothing about it. You're just going to sit there, breathe it in, Bev. Enjoy it. Enjoy every little deep puff that you get. You are the one who is permitting all of this. I hope you're enjoying the circus. These clowns performing to your satisfaction, Bev? I definitely want to know his basis for all these questions about there's a study saying it would be bad to use a dummy for this. Gotta have a good faith basis to ask questions. I think is asking a lot of questions, presuming there is such a study. But do I trust Hank for 1/2 of a second to have an actual factual basis for a question like that? As a matter of fact, I don't. I do wonder if that's going to show up. Is that going to be something that Dr. Welcher gets into? There's some study that we need a basis. Need to establish that basis that says you can't use a crash test dummy arm to check for damage in the fabric. Certainly hope so. Because we don't trust Hank for 1/2 of a second to actually have a basis for the questions that he's asking. Not taking his word for it. Let's take ourselves down the road to Welcher coming back up for rebuttal. He's going to come up and he's going to criticize. He's going to criticize this testing when he did none except for the finger paints. I'm already kind of looking forward to that. We know it's going to be aggravating. We know it's going to be obnoxious. But it's going to be kind of funny too, isn't it? This guy who threw up his hands, well, you just can't do anything, too many variables, we don't know enough, there's just no way that science can address all this. At the same time that the Commonwealth is trying to say that the science is on our side. Well, just no way we can figure it out. But it just happened because, witnesses said so. Therefore, there was a collision. It's going to be entertaining. It's going to be entertaining to see these shameless people couldn't be bothered to do any testing of their own, get up and criticize the testing that ARCA in fact did. It's coming, guys. It's coming. It's going to be quite an experience, won't it? So yeah, now we're sidebarring because Hank is up here trying to cross-examine Dr. Wolfe about portions of the report that are clearly not Dr. Wolfe's portions of the report. They go to the injury to the arm, not the damage to the taillight. See, and why does this matter? Because they had to test the damage of the taillight to get to that failure point, right? That's the focus of what he's doing. What speed do you need to have contact with an arm or with a body for the taillight to fail the way that it did in the Sallyport? So that's the predicate of what he's doing. He's deliberately breaking the taillight so that we can calculate, given this car, given these speeds, given the, general weight of an arm, how fast do you have to be going for that taillight to break? Not because we're trying to prove, this is how fast Karen's car went or anything like that. We're just establishing if the Sallyport taillight was put into that condition as a result of a collision with John, how fast did the car have to be going to produce that result? That's it. So that's why we broke taillights, because you have to break the taillight to understand, to be able to demonstrate. That means the car had to be going this fast. Rentschler's now going to take that and he's going to turn it around. He's going to say, given that speed that was necessary to break this taillight, what would that do to John? What would that do to John compared to what we actually see on John? How do these things add up? This is a very different use of the ARCA witnesses since the last trial. Rentschler was very limited on what he was able to testify to. And so Dr. Wolfe ended up being, I think, a little bit more of the star of the show. But I think that's going to be different this time around. This is much more of a build-up to Dr. Rentschler.
You were asked questions about impact with the taillight. And in fact, in one of your answers to me today, you talked about after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't there?
Correct.
And so while glass or plastic that shatters from a taillight might not impale clothes of the skin, would you agree, if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy and the taillight?
Well, the arm, as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off. Would you agree with that?
At some point, they will separate, yes.
At some point, but before the at some point. What I'm asking is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained?
Sorry, can you repeat the question?
Yes. Would you agree that
He really
if a
wants to
Lexus
get
is
that
backed up to
contact while
24 miles
rolling
per
with the
hour
tail light.
and hits the dummy's arm and the tail light shatters?
There's no teeth on the broken tail light.
If the dummy wasn't restrained and moved regularly, it would extend the contact between that shattered tail light and the dummy's arm. Do you agree with that?
It would move with the vehicle until it got pushed out of the way, just move to the side,
And
yes.
so what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken tail light?
Dragged?
Yeah,
I don't know
so
if I
when say
understand.
Drag, push. How about we use the word push? Pushed by the broken tail light. Could that happen?
The arm would move with the tail light until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your question.
Well, no. You said it moved the vehicle. Sometimes it moves even faster, suggesting space between the broken tail light and the arm. That's what you're suggesting, right?
Correct.
So it can move with, it can move faster. Can it ever move slower and the vehicle pushes and drags against the arm?
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand, but before it moves out of the way, could it be pushed by that broken tail light? That's the simple question I'm asking you. Could it be pushed by the broken tail light?
Just moving adjacent with the taillight, just moving along. Yes.
Would you agree with this? If you have an arm struck at 25 miles per hour, significant more damage that tail light shatters, hits and moves forward into arms, parts of tail light pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken tail light can, in fact, push the arm? Would you agree with that?
Generally, I guess, again, it would move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of a taillight if the taillight broke, correct?
Just moving at a common velocity.
The operative word here is push. And so do you like to agree with me? or
Push
you can
isn't
disagree
a
with me?
scientific
Can
word,
the
Hank.
broken taillight
That's why there's a problem.
push the arm so it contacts and provides force against it? Could that happen?
Yes.
When you were showing those photographs today regarding test F, now you use Randy in test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16 pounds less than Mr. O'Keefe, yes?
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle.
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear. He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate, studied crash test dummy, is he?
I don't agree with that because, again, we use that type of dummy in all different types of tests.
There's an H395M PED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did the test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
That is one way, yes.
Right. So that way you don't have to put the dummy on a forklift, and then it creates a different scenario than real life, correct?
That could be one way that you could do it, yes.
It doesn't impede any roll or drag when the dummy's hit. That's one reason you would do that rather than a forklift, yes?
Correct.
Also, it might show some throw, which could lead to other type of damage like holes in clothes, yes?
Correct.
But you didn't use the magnet, you used a forklift.
Because again, the purpose of the test was to evaluate, we talked a lot about those time frames, right? That 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that, 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet, you used a forklift, right?
Correct.
And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you?
We didn't expect him to.
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Oh, I certainly expected that.
So you expected a throw with that?
Yes.
Certainly expected.
And the street has hard concrete and it has a lot of irregularities to it, doesn't it?
It's asphalt, yes.
Yeah. And the photos that you were showing today on redirect examination, did the defense show them to you during your direct examination? Any of those?
No.
Because it didn't matter, did it, Hank?
Ms. Gilman, can you pull up that last exhibit with Randy on the ground? I think it's exhibit 221. Okay. And so this is Randy, right, doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
Appears to be a fragment of the taillight.
Can you zoom out? Could you go back an exhibit to the one before?
Exactly where they
zoom
didn't
in?
find it that morning.
Did you see any taillight fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please? Can you tell from here?
Yes.
And finding taillight fragments on the clothes
Right where it wasn't on John.
after a collision, that's not unique, is it?
Unique? No,
Yeah.
it's possible.
Well, according to this, it's probable, yes?
In this test, that did occur, yes.
Could we
Weird
have
how that
exhibit
didn't happen with
201B,
John.
please?
Not a single piece of tail light, a chunk like that found on him.
Do you know what this is, doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards
found in Mr. O'Keefe's clothing?
Objection.
Sustained.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No, sir.
Can you take that down, please? When you did your analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I don't know if it was on the concrete, it might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please, Cindy?
Objection.
Sustained.
Did you?
Beyond the scope of
You talked
redirect.
about cuts and injuries. Did you?
Sustained. It sounds like it's beyond the scope.
Very well. When you did test D, did you say the peak acceleration was 780 Gs?
Beyond the scope.
Your Honor, may I refer to my notes?
Yes.
Page 11 of your report.
I think I lost an exhibit. Okay.
Is that what you described it as?
For test D,
Yes.
the acceleration of, we talking about the hand,
Yes.
780 Gs, yes.
780 Gs. Okay. When you did your comparison before you gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Objection. Beyond the scope.
Beyond the scope, Mr. Brennan.
A few more questions, Dr. Wolfe. You showed us holes in Randy's sweatshirt from test F. Do you remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
Sorry, can you repeat the question?
Yes. When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the,
May I approach and retrieve the exhibit, Your Honor?
Yes.
Excuse me, sir.
Oh, this. Can you pull it out of the plexiglass so I can
You
see?
want to look at the back of the sweatshirt to see if there was any holes to the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. Do you see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here, 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 here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry, can you?
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken
On the
taillight
grass?
shards in his clothing, did you?
No.
I have no further questions.
Just a moment, Your Honor. Very good.
He's ready to be done, Alan.
If I may, Your Honor, very briefly. You were asked by Mr. Brennan, give me one name, very dramatically, of someone.
Objection.
The objection sustained.
You were asked, give me one name to support using a 50 percentile hybrid 3 in testing forces on a 216-pound man. Do you remember that question?
Yes.
How about the name Judson Welcher? How about that name?
So the objection sustained.
Did Judson Welcher use a 50 percentile hybrid in his drop test?
Objection.
So that's sustained as to form.
What did Judson Welcher use in his drop test?
A hybrid 3 50th percentile male, the same that we use in our testing.
You were also asked whether or not using that hybrid 3 arm with the same speed would have an effect on the force equation, on the force calculation, correct?
Correct.
And you agreed it might have a small effect on the force calculation, correct?
So sustained as to form.
This is just foundational, Your Honor.
Sustained as to form.
How did you answer that question?
I'm sorry, can you repeat the question?
Sure. Let me ask it this way. In the 29-mile-an-hour test with the hybrid 3 arm, were you going faster than 24 miles an hour?
Yes.
And what was the calculation again on the increased force that would be exerted on the taillight, on the arm, area of the taillight? 14%?
Yes.
Objection.
So sustained.
How much, what was the percentage that you calculated? The increase?
14%.
And did you find damage, even with the increase of 14%, did you find damage on that exemplar taillight consistent with the extensive damage on the subject SUV?
Objection.
I'll allow it.
No.
Can we have 201D put up one more time? Mr. Brennan just asked you if you made
That's the
note
first overruled.
of these little red pieces, correct?
Correct.
You have
In
any
its
idea how the
entire
size
froth?
of those pieces? As you sit here.
Not without a scale of some sort, no.
So as you sit here, do you have any idea what the size of those pieces are?
I couldn't tell you as I sit here today, no.
No idea if they're a foot long?
Objection.
So the objection sustained.
You were asked, when shown this picture, if you accounted for this in terms of damage to the garment, the sweatshirt, right?
Correct.
What if I told you those were,
Objection.
So the objection's sustained. He said he doesn't know
Hypothetically.
the sizes. That's the end of that, Mr. Jackson.
I realize he said he doesn't know, he was
That's
asked
the
questions,
end
Your
of
Honor.
that, Mr. Jackson.
Do you have the, Mr. Wolk, do you have the picture of the tin? The TIN, tin, the little round tin? Do you see that tin?
Yes.
Are you aware that all those pieces are inside that tin?
Objection.
Sustained. And jurors disregard that.
Did you ever see this tin in your analysis?
I do recall seeing, yes, in the evidence photographs of all the fragments, yes.
In your experience, are very large pieces or very small pieces put in little tins about 2 inches wide?
Sustained.
You were asked a question about the arm being pushed by the taillight. Asked a bunch of questions about that, right?
Correct.
And you indicated, what did you say in terms of the contact by a vehicle pushing an arm?
It's going to move with the vehicle until it separates.
Okay. In your testing, how long did it take the Hybrid 3 arm to get up to speed of the vehicle in the 24-mile-an-hour test?
About 10 milliseconds.
I'm sorry, say that again. About
10 milliseconds.
10 milliseconds, correct?
Correct.
So when you say the arm is being pushed, it's being hit, right?
Objection.
The objection sustained and it's struck.
In every one of your tests, every single one of your tests, did any taillight fragment tear a hole in the sleeve of the shirt that you were testing?
No, there was no holes, punctures, fraying, nothing to the material.
Was there ever a defect in that garment in any of that testing other than the road rash that we saw in the 29-mile-an-hour direct impact?
That the only test that showed the holes and the abrasions was that full-on hit where the body was sliding on the ground. There was no test where the taillight caused any type of punctures, holes, or fraying to the material.
And in that test, what happened to the back of the Lexus, the test Lexus?
Destroyed.
Okay.
You heard I have follow-up questions.
Of course he does. We knew he would. That's why at some point you need to just stop, Jackson. Except I guess we're going to have a sidebar about the scope of Re-Recross. Welcher using the same 50th percentile dummy seems like that hurts. That hurt Hank quite a bit. He did the same thing, but he's going to come in and criticize the test for doing the same thing as he did. So clarifying, I think it, again, this could be like dumbed down a little bit more to make it clear to the jury what exactly you're saying. The response to the whole push, the arm got pushed by the taillight because that's Hank's theory of the mechanism of how he got cut on the arm, is there's this continued contact and the rolling and so forth. So responding to that, it took 10 milliseconds. Okay, the push, this is what the jury needed to understand. The push was for 10 milliseconds. To the extent we want to use this unscientific word push to describe what's happening, that's how long the push was 10 milliseconds. So we got that in, but I'm not clear because he said it took 10 milliseconds to get up to the speed of the car in the 24-mile-an-hour test. but that's what that means. 10 milliseconds was the length of the push. Would have liked that dumbed down just a little bit more.
On Redirect, you again talked about the impact between an arm and the broken taillight.
Correct, yes.
And I had asked you on cross-examination or recross-examination whether that broken taillight could push the arm, which of course would create force or friction, yes?
Well, once it's moving at a common velocity, I'm just not understanding your question then.
If it's not a common velocity, if the broken taillight is...
Ask the question.
If the broken taillight is pushing the arm, which would mean the broken taillight is going at a faster speed than the arm. If it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, let me ask you this. Would you agree with this? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. Do you agree with that?
Objection, Your Honor, about the source.
No.
Dr. Rentschler, do you agree with that?
Objection.
So I'm going to allow it strike the source.
Do you agree with that?
I'm sorry, can you repeat?
I can. If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, specifically if there's a taillight that shatters, so you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. Would you agree with that?
Objection, Your Honor.
I'm going to allow it.
In reference to the greater damage, are we talking about damage to the arm?
Do you agree with that phrase?
It's out of context.
The best way I can characterize it is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way.
Objection.
Do you agree with that?
I'm going to allow it.
No, you need to approach. I need to approach.
Seems like, yeah, he's taking it out of context. He's feeding little pieces in. Just one other little trick that Brennan engages in that maybe could have been the witnesses could potentially have been prepped to expect. He's going to take stuff out of context. He's going to try to confront you with stuff that the other witness said. Like, none of this is new now at this point either. We've seen this multiple times. The witness is going to be crossed with something that other witnesses said. But you also can't trust him to be giving you the full picture or the full characterization. This is like what Bev does with the case law. She goes in, she finds some language that she likes. Doesn't matter if the holding is consistent with where she's reaching. Doesn't matter if it's exactly the same legal point that's at issue. She's just like, ooh, I found these words, I'm going to use them. That's really the same thing that Brennan is doing with this type of cross-examination. He's finding some words in Rentschler's report, and he's like, ooh, this sounds good, I'm going to go ahead and use that. But the problem is, in the context of the report, not just the distinction between what Rentschler was doing and what this particular witness, Dr. Wolfe, were doing, but also just we don't know what he's talking about or why. Expect he's going to be mischaracterizing and trying to color it in a certain way that may not be accurate.
I'm going to read this one more time, okay?
Okay.
Would you agree if you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that?
Again, my area of expertise is not injuries to the arm, so whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
When you do a demonstration, isn't this exactly what you see? Could you play E again for me? Isn't this exactly what you see? Play that, please.
For 10 milliseconds, yeah, that's what you see.
And now, stop, please. If Randy is not restrained by a forklift, he is going to move with the car, correct?
No.
Well, if it's just the arm, his arm's going to get accelerated and move, and then his body will be there still.
And that broken taillight, if Randy is not restrained on a forklift, is going to be pushed, like this says, by the arm, by the broken taillight, isn't it?
It's going to move with the arm.
Thank you.
All right, so jurors, we're going to take a morning recess. We'll see you in about 20 minutes.
Please rise for the jury. Right this way.
See you in about 20 minutes, and we are going to have a voir dire, I understand. Are we going to have our voir dire of Dr. Laposata now? I don't know if a 20-minute recess is going to be long enough to accomplish that, but I guess we'll see. I don't know why his arm would come into contact longer with the car, like this theory of Hank's, if he's not on the harness. Still, he's rotating.
All right, so we're not going to do the voir dire right now of Dr. Laposata because everybody needs a break. What we'll do is we'll take the 20-minute recess. Who's doing the director, Dr. Laposata? Is that you, Mr. Jackson?
Yes.
All right, so what I would ask you to do is not do anything on your direct examination with Dr. Laposata that involves the mention of dog bites or the evidence regarding motor vehicle experience, because we still need to have the voir dire, but I don't want the jury sitting out there any longer than need be, at least until the luncheon break. So without that, how long will it take you? Can you use the hour?
Thank you for the credentials, but you're under half her credentials are the fact that she's an expert in dog bites and an expert in motor vehicles. I get her education, training, background, but
Okay, is that all in her resume?
it's all in her. It's all going to be in her direct examination.
No, my question is it in her resume? Has the Commonwealth received notice regarding the dog bite stuff?
The Commonwealth has received the same resume that the court has received. I don't know specifically what her resume says about dog bites. I don't think it says the word dog bites anywhere in her resume. No.
We have absolutely no notice.
But the courses that reference
Absolutely no notice.
Say that again?
The courses that reference her teaching, dog bite issue and pattern recognition, they're listed in the resume.
All right, we'll see you at 12.
The circus gets even more circusier. Now we get a little Cirque du Soleil style of direct examination, because we're going to start the direct of the witness without knowing. We're going to start the direct of the witness without knowing what she gets to actually testify to. Okay, so now Now the trial. Now we have like the trapeze work has been introduced here. The defense gets to walk a tightrope where we have to go on direct. We have to put our witness on direct and start asking questions. But we haven't had the voir dire yet. So we can't qualify her, even though it's like the very first thing you do in the course of putting a witness on the stand. Because Bev is tired and everyone needs a break right now. Okay, that's the reason why. Not because this motion was filed extremely late, well beyond the deadline for motions in limine at the last minute. The 11th hour. Doesn't seem to be a problem. Why didn't you raise this earlier, Mr. Brennan? You've had the report. You know perfectly well if it says in it there are dog bite issues. You didn't ask for a Daubert Lanigan hearing in a timely fashion. So here you go, defense. Good luck. Start asking questions. Better hope you don't cross the line that Bev has in her mind. But what you can and can't ask about. Can you spend an hour with the witness talking about other stuff, Mr. Jackson? Can you just shoot the shit with the witness for an hour until we get to lunch? Why don't you maybe just take a slightly longer morning recess? Get your voir dire done. Why don't you just do that? The circus, it's nuts. So, okay, so we started off. I see that the motions have been posted. Dee Dee, of course, awesome Dee Dee, got a hold of the motion. So haven't seen them yet, but they are there. They've been filed. So we started off the day dealing with these motions that none of us had heard about so far. But we started with so first she says there's a motion to limit Dr. Rentschler. Isn't this ironic too? At the same time that we're trying to limit Dr. Laposata, she can't testify to biomechanical stuff. We also want to be sure that we limit Dr. Rentschler. Now, don't know what about exactly, but we're going to deal with it later today. And then a Commonwealth motion to call witnesses and rebuttal. Those are the only two that Bev acknowledged when we walked on the bench, but apparently there was this other one to also limit Laposata. So seems like there's three motions that are out there. First started off with Ms. Little, Elizabeth Little, arguing that, yeah, the Commonwealth has been on notice that the defense alleges the injuries have been caused by a dog bite for years. So they could have and perhaps should have addressed that in their case in chief. They don't have a right of rebuttal if it is not coming as a surprise to them. As to Welcher, she argues the scope of the testimony should be limited very specifically to responding to new testing by ARCA. That's what she said. That's what she said originally, right? The purpose of this, the Rule 14 sanction, is remedial. It's meant to fix the problem to the extent there was one that isn't just being, imagined and justified. It's to fix the problem of the late notice. That's what the sanction is for. So you don't normally get rebuttal, but because ARCA is doing this new stuff, new testing that they won't finish until May the 7th and get their report in, that's what Welcher remedially can respond to. That's how you cure the lack of notice about ARCA's testing. So she's absolutely right on that. But Bev also real specifically left that door wide open. Oh, we'll decide the scope of Welcher's rebuttal testimony after ARCA testifies. Some back and forth about commenting on the credibility of Welcher. Well, kind of cuts both ways, doesn't it? In a normal courtroom, it would. Everyone would be on the same page when it came to critiquing the other side's work. But somehow it seems that only goes one direction. That when it comes to critiquing ARCA, Welcher is going to be allowed to say all these things they did wrong. But when it comes to ARCA critiquing Welcher, they don't even get to say, this isn't science. This isn't even science. This doesn't even pass the fundamental high school level bar of what constitutes a scientific proceeding. Yeah. The rules don't seem to go both ways here. So then we got to the DNA. The evidence can't be rebutted until it's introduced. It's not the Commonwealth's job to anticipate. Well, it is actually, because it's your witness who did the dog DNA testing and found pig DNA. Found pig DNA on John's clothes. So yeah, you definitely can. But we got that preview. He wants to bring in Hartnett, UC Davis, and then Crosby to respond to Dr. Laposata. But if Dr. Laposata doesn't testify about dog bites, then they wouldn't call Crosby. The dog trainer is going to rebut the medical examiner, guys. If that's going to be the case, we better get Garrett Wing in too, huh? Better get Garrett Wing in too. And Welcher isn't going to, he won't comment on the credibility of experts. I'll believe that when I see it. But this is about the 20th time that Hank has represented to me what he is or isn't going to elicit and what it's going to look like. And it's been inaccurate. So pardon me if I don't have a lot of faith in Hank's representations about what Dr. Welcher is or isn't going to say. Color me a little skeptical of that. If I'm the defense on this, I might be telling the judge, given that limitation and that concession, please order Mr. Brennan to direct the witness about the scope, the limitations on the scope of his opinions here. Make sure that Dr. Welcher knows and that it's Mr. Brennan's responsibility to make sure that he knows. He is not to opine about the credibility of any of the other experts. I'd probably put that on record. I'd probably ask for that request. Order him to make sure that limitation is clear. Just to be sure. We want everybody on the same page. And if the rules of the road are evolving as we get through trial, it's going to be very important to be sure that the witnesses understand what the rules of the road are. So please instruct Mr. Brennan to order him to make sure that his witness is aware of these, so that if something is to slip out when Dr. Welcher is back on the stand, we have some accountability and responsibility. We know whose fault it is that Mr. Brennan's representation turned out not to be correct. I would probably do that at this point. Make my record. So case law, according to Bev, allows rebuttal testimony here. What case law? Your guess is as good as ours. No idea. Then all of this working through Laposata, what's in her report, what she can testify to, what she can't testify to. So she cannot opine about the law enforcement investigation. Brennan doesn't want her to talk about there's nothing present at the scene that would cause that type of pattern injury. Logical to conclude he was injured elsewhere. No basis for that, so that's out. Bev, that's out. We can't talk about what's logical to conclude. If there's nothing there that could cause his injury, logically, he was injured elsewhere, but we can't say that. It's just logic, but we can't say that. Thank God the jury has their own logic, right? Fingers crossed. We pray the jury has their own logic, because logic, you don't need an expert to tell you what's logical or what isn't. If there's nothing there that caused his injuries, we can all conclude logically that he was injured elsewhere. Just logic, but we don't get to say that. That apparently is a bridge too far in this courtroom. Logic, good to know. She can say that John did not have hypothermia, but she can't say the ME incorrectly diagnosed hypothermia. Got that? Got that? Now, once again, this doesn't make any sense, okay? The reliability and the basis of the experts and so forth, this is perfectly proper ground for examination and cross-examination. If your entire method is unscientific, if you overlooked some critical information, if you fail to take into account other circumstances that could contribute to, stomach ulcers and so forth, perfectly normal, ripe ground for cross-examination. It goes to whether we believe this expert or not. It goes to whether we should believe the expert or not. But we don't get to say that, apparently. Once again, this is just sort of a logical conclusion. If Squirty Bello says there's hypothermia and Laposata says there's not, Laposata is saying Squirty Bello got it wrong. We're just not allowed to actually say that, apparently. The jury is going to have to use its own logic and come to that conclusion itself. So then we get into the dog bites. There's no knowledge and expertise, according to Brennan. She's done autopsies on them. She's taught on pattern and wound recognition, but only 5 autopsies? Only 5 isn't enough. How many dead people have been chewed on by dogs? How often does that happen? Let's look it up. There's an average of 30 to 50 people every year that are killed by dog bites. Killed by dog bites, okay? That's not our situation here. Not a situation of John being killed by dog bites. He's just dead and happens to have dog bites on him. 30 to 50 a year. How many of those is she supposed to? How many of those is she supposed to be in charge of? Out of the, hundreds of medical examiners that there are around the United States. How about just in Rhode Island, where she was the chief medical examiner? How many just there? Well, we don't know. No, they don't have that information. Generally rare. Let's see. Some lawyer says, no, they're just using, they're using nationwide statistics. How many opportunities are there even to autopsy dog bites? Only 5? 5 sounds pretty good. By the time I've done my 5th murder trial, I'm feeling pretty good about my ability to handle a murder trial. 5 is quite a few. By the time I've done 5 DUI trials, know my way pretty well around a DUI trial. 5 isn't going to be enough? So what's the magic number, Bev? What's the magic number of how many autopsies are enough to be able to identify a dog bite? We're in a catch-22 here where unless you've autopsied dog bites, you can't identify dog bites. But if you can't identify dog bites, how can you do an autopsy where you identify dog bites? And apparently no ME will ever be able to say there were dog bites. This is just bizarre. It really is. I just, what's the thought process? 5 isn't enough? Why not? She's not going to tell us. Explaining the reasoning is not what Bev does. So just Ipsy Dixit, because she said so. 5 autopsies of dog bites isn't enough to review an autopsy that potentially involves dog bites and talk about dog bites. Brennan complains this wasn't in her report. It's not in her CV. He can't research. He can't cross on it. I would say that's pretty normal because your CV is meant to be a broad representation. It's not going to include every list of every case you've ever worked on. It's just going to include broad subject areas. And so defense points out Isaac Wolfe did the same thing. He was able to testify to wound pattern recognition. None of that was in his report. So then we get into how many motor vehicle autopsies has she done? Once again, is there a magic number somewhere? Is there a magic number somewhere? How many autopsies of porphyria would you have to do before a medical examiner would be allowed to testify to porphyria? How many do you have to do? How many times do you have to see that on the table? Bev, how many times do you think that happens? This is literally what their job is, particularly in situations where you have uncommon conditions, things that you don't see routinely. That's precisely why you need the person who's done 100 gazillion autopsies to be able to say, number one, this isn't normal. This isn't routine. This isn't the type of thing that you see all the time. And number two, because I see the stuff that's routine and happens all the time, when I see something different, here's how I figure out. Here's how I figure out what this unusual condition represents. Seems pretty normal. But apparently in this courtroom, there's some magic number. Now, Squirty Bello didn't have to establish a foundation of any particular number of types of autopsies that she encountered. We didn't have to hear how many motor vehicle. We didn't have to hear how many dog bite. We didn't have to hear how many severe head injury. We didn't have to hear how many pedestrian vehicle interaction. We didn't have to hear any taillight injury. How many taillight injury autopsies have you done, Dr. Squirty Bello? We didn't have to have any foundation like this. Not for her. Didn't have to have it for Dr. Wolfe, who's done, as far as we know, no autopsies. It's just a moving target, what the standard is in this court. But she gets in. Okay, pardon me, I'm back. Something glitched. Something glitched there. Let me make sure we've got the live stream still going. Yes, it is. Still just sitting there waiting for that fan. So hopefully everything is back on track and normal, and just our normal glitching stuff, but there's always got to be something, right? So according to AJ, she can't talk about the G-forces and things like that. That would be beyond the scope of her expertise. That isn't what she does. But once the body is on the autopsy table, she can testify about what she's seen. Bev says she can testify about what the injuries were that she saw, but she can't talk about what would result from a collision. So AJ asks, can she not say anything at all about the body interacting with the car? And Bev says, I'm not saying that. Well, then what exactly is the limit? If you explained why you think this limit needs to be imposed, then it's a lot easier to recognize how that will apply in the context as a whole. It would be a lot clearer if you understood why, but I think part of the problem here is that if you explain why, you got to have a basis for it, for one thing, and you're pinned down now. You're pinned down on your record about why you are limiting the defense's ability to present a defense, and so you'd better be right. And so as a result, we get this trapeze act where there's some kind of limitation, but it's not really clear exactly what it is because we don't know why. We don't know why it exists. We don't know what the magic number is of autopsies of specific conditions you have to do before you can testify about that. Brennan would object to questioning about, would you expect to see bruising? Of course he would. Of course he would. We already know that. So then they brought up 2025 case. Brennan brings up a 2025 case where she was proffered, I guess, to make some opinions about accident reconstruction. So it's one thing to assess wounds, another to talk about the cause. AJ says in that particular case, she was asked to opine about blood spatter evidence and what it told her about who was driving the car. That's quite a different situation. I would agree. Trying to determine who drove the car based on blood spatter is not the type of thing that normally an ME is going to do. But I'm not sure that we wouldn't have an ME do that here in Massachusetts, right? Based on how Dr. Scordi-Bello described how the ME reaches their conclusions and they receive the investigative information that the investigators have come up with and presents that to her. That's their theory. She looks at the medical condition and she evaluates, are those things consistent? Can I find this proposed theory of the Commonwealth is more likely than the other possibilities? Then that's how I would conclude. Given that that's how she makes her finding, homicide, accident, undetermined, etc., in cases by reviewing the investigative information, I'm not sure I'm buying that here in Massachusetts, she wouldn't be able to opine about whether this was a homicide, an accident, etc., by determining more likely than not who's sitting in the driver's seat. If you can determine that from medical type of evidence, I'm really not convinced that she wouldn't be allowed if this was coming from the other side. The photographs taken inside of the garage are going to be out. Very interesting to see this shift from the basement in the first trial to now the garage. In both cases, I think the explanation, well,
All right, so I'm told counsel wanted to see me.
Your Honor, issues has arisen related to the cross-examination or recross-examination of the last witness, and Mr. Alessi would like to address the detail about that.
All right, so the last witness was your witness. Is there a reason?
This is a separate issue. I'm asking Mr. Alessi to address the one on these.
Okay. What do you want to tell me, Mr. Alessi?
Bear with me a moment, Your Honor. I need to put on evidence gloves.
this is dramatic. He's not very good at putting on his gloves either. Are there not holes in the shirt?
Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie, and this regards questioning and representations in questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have 2 documents marked as exhibits, and then I am going to use Exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What I would like to have marked,
Another motion for mistrial.
what I would like to have marked, the first document, and I want to get the specific title. These 2 documents are from the criminalist's file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. Friday.
And may I see that, please? Okay.
That is the back of the hoodie, Your Honor. And if I could please have the next marked in order exhibit for identification.
Exhibit ZZZ, Friday identification.
Mr. Alessi just touching absolutely everything with those
So
gloves.
is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay. I can't tell entirely from ZZZ, but if that's your argument,
I can't tell.
why, for identification appears to support that.
Your Honor, may I have the exhibits marked for identification back for my argument?
Okay.
Thank you, Your Honor. Thank you, Madam Court Reporter. Your Honor, what we just saw is Attorney Brennan question Dr. Wolfe with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is the, what happened was Attorney Brennan held up the casing with a hoodie sweatshirt went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor.
Okay.
The first time I realized that line
Okay.
of question was going to be asked was when Mr. Brennan pulled the case out.
Okay. Go ahead, Mr. Alessi.
Thank you, Your Honor. So, to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing, without notice, shows it to Dr. Wolfe, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now,
Absolutely,
Mr.
Your Honor.
Alessi.
So, here is the back
Okay.
of the hoodie.
Okay. All right. Thank you.
It's very obvious that these are cutting holes cut by the criminalist, and I'm going to get to back to this in a moment. But I would like to do it, and certainly entertain any of Your Honor's questions, but in a logical order.
Sure. So I'm not. What about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay. All right. Thank you. Go ahead, Mr. Alessi.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up, we have no idea that this was going to happen, goes up, confronts the witness, Dr. Wolfe, shows the back of the hoodie sweatshirt. To my knowledge, the first time the back has been referenced of the hoodie sweatshirt. Shows Dr. Wolfe, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolfe is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that?
Yes, Your Honor. What
Okay.
we have is two documents to
You
show
couldn't
that.
understand.
Right. So the second
Convenient.
one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in
Yes.
a discovery? Let me get the date, Your Honor.
Sure.
Notice of discovery, May 2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence, not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolfe. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-2184. Analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor. And I can conduct my argument from right here if that helps, Your Honor.
I just want to see. Point out to me where it says, where it shows the back.
This is the back. So you can see the back of the hoodie. That's the back of the hoodie head. And then you can see the various... Let me just get a check on this, Your Honor. I'm not...
Right. Mr. Brennan, you should come up and look at this as well.
Thank you.
And I'm
So, Mr. Leslie, stay here.
yes.
All right, so this is why. I didn't see where Ms. Hartnett said that she cut it off. It was showing where Mr. Leslie says exterior front.
Can I get the
Label cuts.
Pardon me?
They're labeled cuts.
Right, but if I can, Your Honor,
Sure.
I want to clarify this. Yes, are you willing just to let me just make sure I get it.
Mr. Jackson, it says exterior front, what Mr. Alessi was pointing me to.
Well, just a second. It may have printed the wrong page. I can do it, but Mr. Wolfe, can you print the back? And then, Your Honor, are you comfortable using the computer of the back? Because I think we just had the wrong one.
We need to mark it, though.
I understood. We will see it. He's printing it right now.
She didn't understand it, but boy was she quick to jump on. But that says exterior front. I thought you didn't understand it, Bev.
We printed. We wanted to have the front and the back to show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
Okay.
At least now we know you understand the chart when you get the one that shows the back. Any grave concern yet? Don't see any huffing and puffing from the bench.
It'll take 2 minutes.
So disturbed by the.
All right, so go ahead with your argument.
Thank you, Your Honor.
Go ahead with your argument. You mark down another. How much
So, Your
longer
Honor,
are
what
you
is
going to
being
be?
printed is the...
It's going to take you long, Mr.
Which we
Alessi?
will mark will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminals.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is the reason for the motion for a mistrial with prejudice.
They shouldn't
On
have
its
to.
own to do this, and you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now that I have it yet marked so I can then refer to it.
All right.
Thank you.
Can you print extra copies too, so I can have my own copy?
Absolutely.
We already
And for
know
the
she's going to
Commonwealth to
deny the
see.
mistrial. She's going
And
to
I'm
say
show the
you cure it
Commonwealth,
by presenting
where it
this.
is printed.
Exhibit
What, on-
A.
Rebuttal on. I mean, how is this even going to work?
Sure. And here's another document, chain of custody document.
Hank staring at that like he's never seen it before.
Well, Mr. Brennan is reviewing that. When I had to, Madam Court Reporter, the chain of custody document for these, and asked that he mark as the next exhibit in order.
Okay.
And then with Your Honor's permission, I would have Madam Court Reporter hand them both up to Your Honor so
Sure.
Your Honor can see what I'm writing.
Thank you.
Exhibit B for ID.
Thank you.
Here's, thank you, Madam Court Reporter.
Do you need this, Mr. Alessi?
I do not need either of them, Your Honor, and I have the extra copies as well. Okay, so Your Honor, I now have enough copies for Your Honor and for the Commonwealth.
Oh, thank you.
So if I could have one set, that would be great. Yeah, thank you.
I still do not have ZZZ.
Nor do I. I don't need them.
All right. Thank you. Okay, go ahead, Mr. Alessi.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have Exhibit 88, which is the hoodie. So what Mr. Brennan did, and I'm now pulling Exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolfe, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminalist, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right, so let's move along from
right,
that.
That's right, and I'm going to come back to this. Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolfe, the ARCA expert, to try to make it seem like Dr. Wolfe didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolfe on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth? Isn't it some coincidence that these are the one, and the only one of the, you know, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Ms. Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
All right, thank you. Mr. Randy.
Absolutely no evidence of anything. Watch him come out on the attack, guys.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolfe about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
All right. So I'm not going to allow the mistrial motion.
You know
Mr.
that.
Alessi. What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B. 4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolfe, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this. I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 2022. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please? It's unclear for me. Do you have a better idea, Mr. Alessi, what day these were done? Is it all of those 3 days? Now I see a fourth day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11/2022, 5/12/2023, and 6/18/2023. Those are the 3 dates.
Your Honor, on or about May 18th, when the defense filed a motion to test. So that's the probative date.
So May 18th?
Yes, that's good.
Okay.
And that's 2023.
Yep.
It appears I made a mistake.
That's what I'm going to do. Is there anything further you want me to include in the instruction? Your rights are saved regarding the mistrial. I disagree with you on that.
Your Honor, I'm not going to go any more into the argument, but I appreciate the opportunity to provide perhaps some further instruction for Your Honor.
All right, so I'll hear you. Go ahead.
So the first, Your Honor, is with regard to two things. One, I would like the opportunity to have the hoodie sweatshirt held up, because that's what happened.
Yes. Yes.
These holes.
Yes. Yes.
Thank you. So that's number one as part of the stipulation, and then
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree, not a stipulation, but just as Your Honor said, with regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that rock wasn't present. On or about the time of event.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolfe about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes
Make it as wordy as
were a
possible
result
to make sure they don't get the actual point that the holes were not
of
there.
the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in. It's what I said, Mr. Alessi.
You're not going to listen to it?
Okay. All right, so it's what I said, Mr. Alessi. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor,
Mr. Alessi, the bad guy for not listening.
You should conclude that
Not
these
the prosecutor
holes
who
were
lied to
not
the jury.
Present in the hoodie sweatshirt. They were caused by the criminalist.
So I can just leave that all out then and just say, Mr. Brennan asked Dr. Wolfe about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring them in, please.
Judge, just as a housekeeping matter, the sweatshirt's been taken out of the plastic sheathing. It might need to be remarked. The plastic sheathing was marked, but if we're going to put it into a bag or something like that, it might need to have it marked. But we don't need to do that right this second.
Okay.
May I approach Mr. McDermott with
Yes.
Thank you.
Well, I'm glad we made that all crystal clear now, that the issue is the defense not listening. That's the only thing that gets Beth Boyd in all of this. The prosecutor lying, no problem. No problem at all, but the tiniest hint
All right.
that
thank you.
Mr. Alessi is distracted for a moment, that's the problem. Who's the ringleader of this circus anyway? Is that becoming clear?
Mr. Alessi, you're simply going to stand and hold the sweatshirt, right? Okay.
You should make Hank do it, Mr. Alessi. Make Hank do it.
So this is exhibit 223.
In your honor, I would hold it as your honor begins to read. Is that consistent with your honor's expectation?
No, I want you to hold it up with the back.
Would you like me to start?
You do that first, and then I'll give the instruction.
Thank you, your honor.
All right, so Mr. Alessi, why don't you just, where are you going to stand?
Pardon me?
Where are you going to stand?
I would suggest,
Where
your
are you
honor,
going to stand?
right about here.
All right?
Let's
So
micromanage
you can
that
stand there, you
too.
can hold it up, then I'm going to ask you to put it down, and then I'll give the instruction.
And then I will return it to Mr. Brennan, or the court officer. Return.
Yes,
Thank you.
court officer.
Bear with me a moment, your honor. I'm going to be put on the...
All right, then we will take the luncheon recess. When we come back, we'll have the voir dire. Or actually, is Dr. Laposata here?
She's here, she's on next. I'm gonna call up.
John Tederman.
T-E-D-E.
For just the measurements?
Go ahead.
Your honor, we're not going to be able to show the exhibits from Ms. Hartnett where the cuts, along with the next episode, show the cuts were made by Ms. Hartnett. Your honor.
Well, I say it, and I'm going to tell her what they are, so.
About as accurate an instruction as what they're getting.
Please be seated. Court is in session.
All right. Jurors, I appreciate your patience. Mr. Alessi, why don't you hold the exhibit up for the jurors, please? All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolfe. Okay, thank you. Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunches are here, but I think we'll, Mr. Yanetti, your next witness, please.
John Tederman.
Okay, you're gonna step up, face apart, and raise your right hand.
You solemnly swear the evidence given to the court and jury in the case now is here to the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
All right, good afternoon.
Good afternoon.
Go ahead, Mr. Yanetti, whenever you're ready.
Thank you. Good afternoon, sir. In a good loud voice, would you please state your name and spell your last name?
Sure. My name is John Tedeman. It's T-E-D-E-M-A-N.
Do you work, sir?
I do.
What do you do for work?
I am a private investigator.
Do you work for someone else, or do you have your own firm?
I have my own firm.
What is the name?
Forum Investigations.
And that's F-O-R-U-M?
Correct.
I'd like to ask you a little bit about your education and work history. You're from this area?
Yes, Boston proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School.
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University.
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location. Sorry.
I started out in Los Angeles, and then I was back in Boston.
And what years were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did you leave in 2008?
I went to law school.
Where?
Suffolk.
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker.
And what type of law did you practice?
Mostly real estate law.
When did you start forum investigations?
In April of 2024.
Are you still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
All right. How did you become involved in this case?
I was contacted by somebody from your office last Tuesday, I believe, the 3rd.
Okay. And was it explained to you why you were brought in at this late juncture?
Yes, it was explained that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
And what were you asked to do?
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did you agree to do that?
Yes.
When did you go?
On June 3rd. I believe I arrived about 5:30 at 34 Fairview.
Okay, and when you say June 3rd, we are talking about last week,
Yes,
correct?
last week, yes.
Whom did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
And it was not the Albert family, correct?
It was not.
Did that individual give you permission to enter onto the property?
He did.
What did you bring with you?
I brought an iPhone as a camera, and I brought a wheeled measuring device.
Can you describe what a wheeled measuring device is?
Yeah, it's like a handle with 2 wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
And if we could, Mr. Wolfe, could we display the photo of the front of 34 Fairview that's already in evidence with the court's permission?
Yes.
A measuring wheel.
And what exhibit number is that, Mr. Wolfe? 46? Do you see exhibit 46 on the screen, sir?
I do.
Do you recognize that?
I do.
What do you recognize that to be?
That is 34 Fairview Road in Canton.
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence on the front, from the front of the house?
I did.
Could you describe those for the jury?
Yes, on the left side center of the building, there's what I would call the front door, up those 4 steps, I guess. Then if you were to look farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows, and then if you can see the little red line, that is a side door that goes into the garage. Yes, right there.
It's been highlighted there?
Yes.
Okay. And then there are obviously the 2 garage doors.
And the 2 garage car doors, yes.
4 cars to enter. Okay.
Yes.
We can take that down. Mr. Wolfe, can put the lights on. May I approach the witness, Your Honor?
Yes.
So I've placed a photograph in front of you. Can you identify that for the jury?
Yes, that appears to be a photograph that I took of the side front door, the secondary front door, the garage door, and the two car doors to the garage.
Okay, particularly with regard to the side pedestrian entrance into the garage, the red door that you identified in the previous exhibit. Does that photograph fairly and accurately represent the layout of the house in terms of the outside and the entrances that you've previously testified to?
Yes, it does.
I would offer that, Your Honor.
Like to be heard.
All right, can I see those, please, sir?
Well, Judge, if you're not going to pay attention, we'll just take Karen home. We'll call it good. It's fine. If you're not even going to pay attention, we don't have to go through this. She's up there working on something else. She's flipping through some papers, taking little notes of things. It's okay. You don't have to pay attention. We'll just go ahead and go home. We'll call it good. It's fine with us. Hank wants to be heard because these are new photos and he doesn't have notice. It's late. Rule 14. We've already heard it's because the original investigator that they had do this had some kind of health issue and so isn't able to come in and do it. This guy had to recreate the work. Why? Well, he can't testify to somebody else's work. It would be hearsay. So he just went out and took his own. And so now Hank is going to complain about that. I had no notice. I didn't have any notice. Now, are they materially different than what the defense investigator did the first time? Probably unlikely. So why would it matter? We got to get the measurements because that is an important part of the health data, being able to put that 84 feet into real crystal clear context. When we overlay 84 feet being walked, where could that put you all over this property, depending on where did you start from, etc. Particularly if you're walking with the westerly bearing, which also Mr. Brennan seemed to have forgotten about that earlier in the day. No evidence that he walked in the direction of the house. Well, except for right here where your own data guy says the bearing changed to westerly, and then he walked in a westerly direction, which puts him where? Which puts him where? If he walked that distance in a westerly bearing? If only one of the crime scene responders, one of the very first people at the crime scene, could have taken advantage of this very sophisticated technology, a wheel that has a measuring tape on it. Allows you to calculate distances on the ground without trying to run a tape. You just use your wheel. Quite a extended little conversation they're having over what should be pretty much a non-issue. It's a photo of what it's a photo of. What's the problem? Is it minutely different in some way from what the original defense investigator did? So Hank is screaming about notice. Didn't have notice of that. I don't know why we have to go check on what Mr. Wolfe has on his computer. Some tiny little difference. Now we gotta look again. Looks like we're gonna fold over part of the photo. Is that what we're gonna do? We're gonna fold out the side door. Is that a bridge too far?
Okay, Mr. Wolfe, whenever you're ready, if you can display that portion.
Yeah, they're gonna redact the photo and only part of it gets to be shown.
Do you see what has been?
So I'm going to ask you to take that down. Folks, we're going to take the luncheon break at this point, okay?
Rise for the jury. That's right. This way, please.
And so you can just follow the jury.
Is that what they weren't supposed to see? Let me guess, Bev's gonna have some grave concerns now. Take that down. If you're gonna be all vague and micromanaging and nitpicky, this is what's gonna happen.
You may be seated.
All right, so we'll fix that during the luncheon break, Ms. Yanetti, to what I said. All right, so can we get Dr. Laposata in here? We'll do a very brief voir dire of her.
Why do we even need a very brief? You're signaling that you already know what you're doing. You just need it on the record very briefly. 5 dog autopsies, not enough. Not enough dog bites. Not enough dog bites. How many motor vehicles? Don't know. May or may not be enough.
Then you're going to step up, face the clerk, and raise your right hand.
Do you solemnly swear the evidence you have before the case down here is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, good afternoon, Doctor.
Good afternoon, Your Honor.
We're going to do a brief voir dire, okay?
No problem.
Thank you. All right, Mr. Jackson, foundation on just those 2 points, please. Sure.
Oops.
Your Honor, for purposes of expediting, does the court wish for me to go through the foundation of the doctor's education, training, and background and experience which is going to take a minute.
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence, those two areas. And if there is support or methodology in Dr. Laposata's resume to point to exactly where that is. Okay? And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Yes, Dr. Elizabeth Laposata. That's spelled Laposata.
Dr. Laposata, what do you do for a living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. Laposata, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions. Where did you get your medical degree?
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had those board certifications?
Like 35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that for the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Many.
Have any of those dealt with motor vehicle and pedestrian incidents?
Many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint.
Hundreds, over 500 at least.
Do you have a significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main job or duty performed by a medical examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation.
Okay.
Do it as briefly as you can, with being as succinct as you can.
Certainly. To determine cause of manner and death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of things that might have happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong? What else could this be? So you have to make what in medicine is called a differential diagnosis and then see what the facts support.
Did you employ a differential diagnosis in this case?
Yes, I did.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, then we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as an expert forensic and anatomical pathologist in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
I want to talk for a specific for a second about a specific area of interest for the court. Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arm? I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
Without telling me what your opinion was, were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist could say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes.
Are you familiar with some or most of those publications?
Absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school?
At the medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
When was the last time you taught a course in pattern recognition?
Let's see, last month.
Do any of the courses that you've either taken, well, let's take them one at a time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds?
Courses that I've taken?
That you have taken?
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks. They appear continually in our medical and scientific journals.
Is that an important skill set to develop, wound pattern recognition as it pertains to animals as a forensic pathologist?
Absolutely.
Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically?
Oh, yes, they do.
In the course or courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds?
Yes, I have.
When was the last time you did that?
Let's see, it would be in the course in the medical school. Would have been several years ago.
Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds?
Yes.
So you've seen them in person?
Yes, I have.
Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites?
Yes.
When was that?
The last one I can recall was a federal case involving questions of a police dog.
Did you engage, in that case, did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw?
Yes.
Did the court qualify you to speak on that issue in court?
Yes.
Did you in fact testify in furtherance of your opinions and conclusions in that case?
I did.
I want to turn for a second to motor vehicle accidents or motor vehicle incidents. Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents?
Yes.
How many times would you say you've performed an autopsy on those issues?
Hundreds, maybe even 1,000.
Is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology?
Yes, it is, unfortunately.
Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents?
Yes.
And what methodology do you employ in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents?
Mm-hmm. Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at the hospital records, the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at photographs of that or see it in person.
Is that part of the normal methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
Do you also look at the other side of that handshake? In other words, look at the body of the individual that was in your case, killed, the decedent, in order to marry the two and determine whether or not the cause and manner of death had something to do with the motor vehicle, a motor vehicle impact?
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced certain injuries on the body.
I'm going to take them one at a time. With regard to animal wounds or dog bites, were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite or claw marks?
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes.
Is it to a reasonable degree of scientific certainty?
Yes, it is.
Is it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regard to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm?
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
And without telling me what that scientific conclusion is at this point, did you employ the same methodology that you've explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you've described for the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Your Honor, is there any area that I have not covered to the court's satisfaction?
So I'll let Mr. Brennan ask questions. I may have a couple of questions.
Thank you.
Good afternoon, Dr. Laposata.
Good afternoon.
If we could start with dog bites.
Yes.
Did you have any specific training in wound pattern recognition regarding dog bites?
Yes, it's in our literature standard textbook. It's standard information that is needed to be a forensic pathologist.
When did you receive training regarding pattern recognition of dog bites?
Beginning when I took my board, started in 1983.
And what did that entail?
It entailed reading literature. It entailed reading the standard forensic pathology and medicine textbooks. And it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites?
Yes, I've had many cases where there have been dog bite injuries.
When you were studying for your boards, were you doing that, or after you completed your boards?
I'm telling you that that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many cases since then.
Did you receive any education past reading literature for the boards, where you took classes, seminars, where it taught specifically wound pattern recognition regarding dog bites?
It's all part of wound pattern recognition. It's usually included in literature. If there are lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like baseball bat injuries. There's a huge number of types of patterned injuries that are part and parcel of what a medical examiner has to understand and diagnose.
Do you remember taking any specific classes or any specific training about wound pattern recognition relative to specifically dog bites?
Yes, it's in all the literature that I keep up with.
Did you take any training or did you attend any classes that involved wound pattern recognition of dog bites?
Yes, it's often included in our seminars and case
ask
reports.
it for like the 8th time, and she's going to say the same thing patiently.
Or seminars on your resume?
That I took? No.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was regarding wound pattern recognition relative to dog bites?
I can't give you a specific time and date.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition
What about the one she
relative to dog
taught?
bites?
I can't recall.
What about the one she taught?
Is there anything in your report that identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
I will ask you about the CV, but Dr. Laposata, I just wanted to ask you about your report first. Is there anything in your report that points to any specific training
In the report that I wrote on this
in your report
case?
relative to wound pattern recognition as to dog bites? Is there anything in your report that identifies that for us?
In my report, I put together the case of what happened to Mr. O'Keefe.
Okay. As far as your experience, though, do you ever make any note in your report about your specific experience and training about wound pattern recognition for dog bites in your report?
No, it's not appropriate.
In your CV, is there any way you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically, no.
Do you have anything on your CV that specifically talks about wound pattern recognition for animals?
Those are usually classified within other pattern recognition
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other than I've passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound pattern recognition of dog bites?
I don't know if I have given a list. I don't keep those kinds of lists.
You mentioned one case about law enforcement dogs in federal court. When was that case?
Several years ago.
How long would you say, if you had a guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about an individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this person.
And this was in
Caper.
Boston federal court?
Springfield, yeah, Boston, right.
Is there a difference between law enforcement dog bites and domestic dog bites?
They have the same kind of dog jaw.
So you would say
they're taught differently, obviously.
Would the wound pattern recognition be the same or different if you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Do you have any other cases that you've testified about wound pattern recognition relative to dog bites?
I've testified in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
I'll ask you about accident reconstruction experience. And I mean this respectfully, you don't have a biomechanical or a biomedical engineering type background, do you?
No, I'm not a mechanical engineer.
And you're not certified by ACDAR or any of those type of organizations, are you, doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene firsthand?
Yes.
And when you've done that, do you have a chance to look at all of the physical materials, the properties?
Well, when I go to a scene of a motor vehicle fatality, I look at the pieces that are scattered around. I look at the body. I look at blood stain patterns. I look at damage to the car. And then the body would go back for the examination at the medical examiner's office, and there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries to the vehicle.
You've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand. In this case, what materials did you look at? Because I don't think in your report it mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Well, so you would like for me to tell you everything I studied in this case?
Yes.
I have my list here. Should I read
That's fine by me.
Okay. I studied the autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuropathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing, blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear. I studied photographs of the outside of Ms. Reed's SUV as it was parked at the police garage. I studied the Canton Police report, incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened to Mr. O'Keefe.
Were you involved in a case, Commonwealth versus Daniel Tompkins?
Remind me about that. I've been involved in hundreds of cases.
Yes, you have. This case was in Franklin County Superior Court.
Also the one where she was excluded.
It was a case where you had an opportunity to present testimony and regarding blood spatter, which you've been qualified expert for. And that, I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
No, I'm not an accident reconstructionist.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
I have no idea. I'm not an accident reconstructionist.
Okay. Do you have anything on your CV specifically that offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
Okay. All right. Thank you, Dr. Laposata.
No, you're welcome.
So can I just ask Dr. Laposata about, you said you've been involved in autopsies with dog bites.
Yes.
How many?
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
When was the last one?
Let's see, probably 2 years ago.
Okay. Any questions based on my questions?
No.
All right. You are all set and asked you to step down, Dr. Laposata.
At 8:05.
Okay.
Thank you, Your Honor.
What a great record.
I do want to give everybody a break, including counsel. Can we do less than 5-minute arguments on this?
Adding one to the list, one more to the list of, can you do this fast? Can you be done real quick? 2 of them today. You guys gonna be able to do this fast so we can take a break? Look at how tired my eyelids are.
Your Honor, I'll make this very brief. Dr. Laposata is eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this voir dire for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds and the source of wounds, i.e., was it a dog, was it another animal, was it another source, was it lacerations versus abrasions, things of that nature. She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies that she's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally somewhere close to, I thought it was probably 5 autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attendant to the injuries that led to a different cause of death. But she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites, she's seen dog wounds, she engages in pattern recognition. She also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent or inconsistent with dog bites, and I expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously, many more autopsies dealing with that because it's more common. She also engaged in the exact same differential diagnosis. She has training. The subfield of, or the sub-issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on, going all the way back to the 1980s, dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about the two subjects that she's been called to talk, well, she's called to talk about several other subjects, but these two subjects that's before the bench right now than somebody with Dr. Laposata's qualifications. I will submit on the voir dire that we just completed.
All
Your
right,
Honor.
thank you.
Very eminently qualified. No classes, no studies.
I do not think that Dr. Laposata has articulated the experience the way it's been summarized. She could not provide any specific training other than her boards and her references to literature. She could not articulate one single class or seminar that she took that pertained to differential diagnosis of dog bite injuries. She has no specific memory of having any type of experience in differential diagnosis as far as being in a training, seminar, or advanced education. She has the experience of a medical examiner who has seen what she believes to be dog bites in the past. She has no publications or references that she has studied the issue of differential diagnosis or pattern wound recognition relative to dog bites. If we look at the standard Dr. Russell employed, Dr. Laposata does not have any of the merit to be an expert in dog bites. While she has taught, we did not hear about anything in particular that she has taught about specific pattern wound recognition analysis regarding dog bites. She is an experienced medical examiner, has a wealth of experience, past experience in autopsies, but she has no experience that is a basis for her as an expert in being a dog bite expert. Particularly, she mentions one case that she's testified in federal court that we've heard of today, and she has nothing whatsoever in her report or resume to establish that she has used, studied, and knows this methodology. In fact, her CV and her report don't have any basis for one to look at and see that she has any specific experience in dog bites.
Because it's
and so
basic.
Dr. Laposata, from the Commonwealth's perspective, should not be able to give an opinion regarding or about whether or not the wounds on Mr. O'Keefe were caused by a dog. She simply does not have the training and experience
about lying
and
about
education
evidence
and
to the
methodology
jury?
to make her a so-called dog bite expert.
You can,
Regarding
because it's
accident
fundamental to
reconstruction,
going to
she
law
said it
school.
best. She is not an accident reconstructionist. She saw some of the materials in this case, but it is a fraction of the materials in this case. She is not in a position to give an opinion whether or not the wounds are consistent with broken taillight. There is nothing we see on her CV. There's nothing we see in her report. There's nothing we heard on direct examination that she has any experience in breaking glass, breaking plastics, and the causation of wounds. It also overlooks the fact that the opinion that would be offered would extend beyond just the wounds on the arm. It would extend to a general opinion that he was not involved in a collision, and that's improper. There's no predicate or basis for it. And so based on her testimony and absence of being able to provide any education or experience, she should not be able to testify about either of these two matters.
Okay, thank you.
So she shouldn't be able to say anything at all, sounds like.
Mr. Brennan suggests that, well, she's only been qualified in one court, federal court. The federal government, the federal judge that was handling that case, qualified her as a dog bite expert in that case. That is not a small thing. That, as a matter of fact, it's a very big thing for Dr. Laposata and her credentials. In addition, she indicated, contrary to what Mr. Brennan just suggested, she indicated that she has been training on wound pattern recognition as it pertains to dog bites for her entire career, not just when she was studying for her boards, since she's been studying for her boards. And it's been constant and consistent throughout her entire career. She's made these differential diagnoses. She's seen the autopsies. She's seen the wounds during autopsies firsthand, probably 50 or more. She's supervised another 75 or more autopsies dealing with known dog bite wounds. She has the credentials. The court will recall that, for instance, Dr. Isaac Wolfe was called to testify by the Commonwealth. He had absolutely nothing, no credentials whatsoever to talk about wound pattern recognitions. He was a neurosurgeon, and yet he was allowed, over Mr. Alessi's objection, to talk about and to discuss his opinions and conclusions as to the wound pattern on the back of John O'Keefe's head. Certainly, Dr. Laposata brings much, much, much more to the table than Dr. Isaac Wolfe. I'm not comparing them. They're apples and oranges. Dr. Laposata is she doesn't have to be a sole dog bite expert to be expert in dog bites. She doesn't have to be Dr. Russell. She just has to have that level of knowledge, that level of skill, that level of expertise that's beyond that of the average layperson in order to opine as an expert on a particular issue. She certainly brings that to the table as it pertains to dog bites, and I think her skill and her education, training, and background certainly speaks to the fact that she has that in spades with regard to motor vehicle pedestrian incidents.
All right. Thank you. All right, I'll get your ruling as soon as I can. So we're going to start back up at 2:20, and I expect to go straight through the rest of the afternoon.
All right, for the court, please.
She is full of the sighs today, isn't she? Already tired on Monday, Bev? So it looks like we'll be getting about a 40-minute lunch. So we already did our recap of the motion hearings this morning, the arguments such as were presented. So I don't know that we necessarily need to get any of that. She's already gone through and nitpicked a bunch of stuff that she's not going to be able to testify to. She doesn't get to talk about what kind of injuries would result from a collision. Why? I don't know. Seeing thousands of them apparently isn't enough to be able to establish what's a baseline expectation. Dr. Scordy Bello testified about it, didn't she? She testified about no traditional motor vehicle collision injuries, the type of thing that you usually look for: broken bones, lower extremities, injury to lower extremities. And she didn't see anything like that. So then we got into, we were just talking about the investigator took the photos, trying to establish the distances. Brennan's, screaming, "This is irrelevant. It's material. It's misleading. You don't know where he was at." He was at the flagpole. Well, actually, we have a lot of evidence about different places that he was at, don't we? Because we have the car stopped out front. We have the car scooting forward, ending up near the flagpole. But we also have it parked roughly even with the front door when Ryan Nagel and Heather Maxson arrive, and John is already not in the car. But it's total speculation. Maybe he was in the garage and then it's colder in the garage. That's good thinking. That is good thinking, isn't it? They're accounting for the battery temperature. 50 in a garage seems pretty realistic to me. It's not getting all of the heat from the house, but it is getting some. It's typically going to, share a roof or attic space or something like that. There's going to be some bleed through some, heat is gonna come in from the house, but it's not itself being heated. It's like garage doors typically aren't going to be as well insulated as a, solid wall of a house. It's going to have cracks in it and stuff like that. It'll have some insulation, but not a ton. So yeah, 50 degrees seems like in the ballpark to me of what you could maybe expect a garage to be during the storm. It's about my experience, and I say that because we've got our little home gym out in the garage, so you go out and you use it in the winter. It's like, not necessarily the funnest place to have your gym during the winter because it's cold. It's a lot colder in the garage than it is in your house. But hey, it's better than having it outside. Mr. Yanetti points out that's a misstatement of the evidence yet again, because it shows that the bearing shifts to westerly, and that the steps start occurring in a westerly direction. Points out he wasn't in the car at the time that Nagel and Maxson saw him, so it's not an unfair prejudice. Brennan's saying this is absolutely no evidence, and Yanetti's saying your own location data is the evidence. Yeah. Absolutely no evidence. Absolutely no. It's always a tell. It's always a tell. Of course there is, even if it's only inferential, but inferential is good enough. And in fact, it's going to be in the instructions. Indirect evidence, just as good as direct. If it's something you have to use your brain cells to figure out from the facts and evidence, you get to do that. You don't have to leave your brain cells at the door, not follow any logical conclusions. So Bev says the measurements are okay, but photos of the garage are out. Apparently, photo of the garage front even seems to be problematic for some reason. Photograph of like where these doors are in relation to the other doors. Apparently, that's a problem too, but we'll figure that out. So after the motion hearing, we got the redirect of Dr. Wolfe was concluded. We got photographs showing the dummy and all of the road rash that was all over the dummy at the end of the 29-mile-an-hour impact. He was not knocked out of his shoes. He, in fact, still had his shoes on, even at a higher impact speed of 29 miles an hour. Ultimately, the dummy and the damage to the dummy, the road rash, and so forth was inconsistent with John. The condition of the clothing was inconsistent with John. The 11.8 is a statistical estimate that he believes comes from the population average. There is no actual measurement of John O'Keefe's arm. And so then we walked through the math, did a whole lot of math correction. First off, the 23% difference is not what you get when you perform a correct percent difference calculation. To do that, you have to subtract and then divide by the sum of both of them, and then divide by 2. And so you end up with 23% lighter. If you just divide it by the larger one, it's 21% lighter. So first step we do, it's not 26, even if we account for there being some difference. It's less than that. And then we look at the kinetic energy formula. E sub k equals 1/2 of mass times velocity squared. It's the velocity squared that is driving the outcome of the kinetic energy, because it's squared, it's exponential. The weight of the arm is pretty insignificant compared to that, so that's why he points it out. It's quadratic because you're squaring the velocity. So small changes in the speed will affect the outcome, but the arm not. So we did all the math. I didn't love how we did the math. I didn't love it, because he ran us through all of the math with the 11.86 pound arm at 24 miles an hour. And we got the energy being 3,415.68. Forget about the units. I know everybody is like upset about the units. I'm also upset about the units. These are make-believe units for purposes of just doing math, because we didn't convert the weight of the arm into kilograms to get a mass. whatever. So we did the calculation that way. The heavier arm than we actually used at the 24 miles an hour gets you the 34.15. But then if you use the lighter arm and do it at 29 miles an hour, much faster, you get the 39.44.29 measure of the energy. So you get more kinetic energy with the lighter arm at 5 miles an hour faster. We get that. But all we have are these two counterpoints, and we changed multiple variables. And so I really would have liked to have seen, just give us both arms at the 24 miles an hour, and we'd be able to tell. We could do that ourselves right now. We could do that ourselves. 9.38. No, we got to start with the speed squared. So 24 squared is 576. We already know that. Then we multiply that by 9.38. And then we divide it by 2. We get 2701.44. Well, that is actually quite a bit different than 34.15, isn't it? 34.15. So if we do the math, with the 9.38, we get the 2701.44. Now let's do the percentage difference calculation. We on this yet? Forget where we are. So 3415.68 minus 2701.44. We get 714.24. Then what are we supposed to do? Then we're supposed to divide that by the sum of both of them. So I've got a sum 3415.68 plus 2701.44. Then I divide that by 2. Isn't that what I do? Evidence correction. Divide by the sum of 2 and then divide by 2. So yeah, so then we get 1508.56. Now I'm confused about where to go with the math from here. Divided by, no. It would be 714.24 divided by the 1508. I don't know. I'm not sure. I lost track of the math there. Sorry. I should never try to ad-lib math. I'm a lawyer for a reason. Well, we didn't get, you know, what to me would, I think, be satisfactory math to help us understand how big a difference does the arm make, the weight of the arm make. He says it doesn't make that big of a difference. I'm receptive to that, but I'd just like to be shown. And I think the way to show me that is to do the same math with the both different, you know, do the same calculation, the same formula with the different weights of the arm, and then show me what the difference is. And how big is the difference if that's the only variable that we change? He didn't do that. Might be that there was a reason why he didn't do that. You know, maybe it looks more significant than it is. I look at it, I see, hey, if I get 2701, that does seem quite a bit less than 3415. It's 700, you know, 714 roughly of whatever our measurement is. You know, it's fake or but we got what we got. Didn't get followed up on. He got a 14% difference between those two calculations, but the two calculations are not the same. So I don't know. I didn't love that. It was enough for me to catch as like, I don't feel like this is making the point that I want to be made here. But it didn't get brought up on recross, so we don't know. We don't know, still sitting here, I guess, how significant the difference of the weight of the arm is, because that math wasn't done. So we knew first thing would come up. Do you have any chats with the defense over the weekend? No, he did not. No, he did not. And when he answered, I don't know, about where the 11.8 pounds came from, he meant he doesn't know that source. Agrees that it's not his normal practice to go and sever the arm and weigh it. No, I wouldn't expect that to be the accident reconstructionist's role, to sever the arm and weigh it. But just some more back and forth. John is not a 50th percentile person. These are 50th percentile dummies that were used. But strangely enough, Welcher also used the 50th percentile dummy with his drop calculation on the head, and you just adjust for it in your math. Huh. Perfectly normal, apparently, to do that. Even Welcher did that himself. So no, he's not confused about the 11.8. He's just not sure what the source is. There's probably a variety of them out there about what the average is. He doesn't know, as he sits here today, what the average percentage of the body weight an arm is. Not sure he would be expected to do that. A lot of this stuff is what Rentschler talked about. We got a lot of the snide, the questioning when I put in here that I put in quotes, because this is the circus. This is the circus that is that's being allowed to go on. No correction, no grave concern, nothing at all. So when you feigned confusion last week, there are courtrooms in the country where that prosecutor would be sitting in jail right now for contempt for being unable to conduct himself in accordance with the required decorum and civility of the courtroom, the propriety of the questions, and what you know perfectly well is not proper. There are courtrooms he would be sitting in jail in contempt for refusing to abide by the rules, but not this courtroom. We barely get these objections sustained and stricken. So he agrees weight matters. I don't think anybody ever said weight doesn't matter. The question is, how much does it matter? If you increase the mass of the arm, you also increase the force on the arm. So be careful what you wish for, Hank. A heavier arm would give you more force, but we're talking, when we're taking the weight of the arm into account, we're talking about the force that the arm is inflicting on the taillight. It has to be sufficient to break the tail light. When that comes back the other way, and now it's time to talk about how that force is also acting on the arm, be careful what you wish for. May I answer? No, Hank says. It ain't up to you. It ain't up to you, Hank. But that's not going to be corrected. That's not going to be addressed. No issue with that at all. The just embarrassing lack of decorum in this courtroom. By the way, well, we'll get to that maybe later this afternoon. Had to go and look up some judicial standards just to see, like, yeah, there are judicial standards about maintaining decorum and civility in the courtroom. It's one of your basic jobs as a judge, what you're supposed to be doing. So then we talked about the movement and the push. And, you know, what constitutes the push? Well, I mean, they will move together at the same speed. They use different sizes of sweatshirts. Okay. He stands behind his opinions. Yes, indeed, he does. Hank was trying to get somewhere with, even though you don't have a study, he's been saying repeatedly, this is perfectly well accepted to use crash test dummies for different types of calculations, and some of them you can correct with the math and so forth. So he's been saying this over and over. You don't need a study that says it's okay to use a crash test dummy to test crash impacts, because it's so fundamental. It's like you don't need a case that says you need probable cause to get a warrant Like we all know that. We all know that it's a given. So yes, despite the lack of study saying you can use a crash test dummy to test crash impacts, he does indeed stand behind his opinions. Then they went in and tried to, impeach him with Rentschler's report, but that was Rentschler's report. So we had a sidebar. And after that, he had to move on. So then we got into the push and blaming, I guess, the time of the contact to the dummy being suspended, the arm being suspended. The arm being suspended doesn't stop it from moving with the vehicle. I mean, what you see very clearly is that there is that brief window at the point in time where the taillight shatters, and then it reaches the same velocity as the car, and it moves, and they're no longer in contact. So just a lot of this argument about pushing, because pushing is not a scientific concept. We got a new word, biofidelic. Biofidelic. Because we're arguing about Randy, and Randy being whether Randy is a mannequin or a crash dummy. In this particular case, he just needs to be 200 pounds of human-shaped material. We're not here to pick up from the doll what the G-forces are and things like that. We just need something, because we're not interested in Randy right now. We're interested in the tail light. All we need is the weight of the thing on the tail light. That's what we're calculating. So totally okay to use these dummies. You don't have to use the one with a magnet. We're just looking at what happens to the tail light. What happens after that does not matter to his analysis. In fact, he certainly did expect Randy to go flying and to break the overhead line. That was a little bit of a oops by Brennan. You didn't expect it to break the line. Oh, I absolutely did. Because we didn't care about Randy in this scenario. We didn't care at all about Randy in this scenario. We care about the tail light. And then we looked at the little photo of the taillight chunks on the dummy. Yeah. Taillight chunks on and next to the dummy, exactly like there were not on and right in the vicinity of where John was found, where they were blowing off all the snow in the yard with that leaf blower. Exactly where the taillight is in these photos is where it was not on the morning of January the 29th. Then he starts going into a bunch of things that are beyond the scope. Then we had the holes in the back of the sweatshirt here, and that very dramatic. Here's the sweatshirt encased in plastic. Look at that. Yes, I see other holes. They're inconsistent with road rash. You would need long sliding. Just landing or lying on your back would not give you the sliding contact. He did not consider John O'Keefe landing on his back. That was the line of questioning that ultimately got Hank into some trouble, but not that serious of trouble. Just not grave concern type of trouble, just minor concern. So then redirect, give me one name of someone who would use a hybrid 3. How about Judson Welcher? Yes, it's the same thing. Same thing he did, use the 50 percentile male. You still at the 29 mile per hour speed with the increase in force, you did not get taillight damage consistent with what was on the Sally port. That was an important point. Even with this higher force, you still were not able to get to the level where we had similar damage to what was seen in the Sally port on Karen's car. The 10, we visited the 10 and the fragment. Little judicial comment there. That's the end of that, Mr. Jackson, because he said he didn't know the size, so we can't orient him to the rest of the evidence, apparently. With the arm being pushed, it will move with the vehicle until it separates. It took 10 milliseconds to get up to speed in the 24-mile-an-hour test. There were no holes torn in the shirt by any testing besides the road rash at the 29 miles an hour. Nothing where the tail light caused any punctures, holes, fraying, or anything like that. Then we went into our Recross. If the tail light is going at a faster speed than the arm, but it's moving at the same speed, sir, the tail light is not going faster than the arm. How would that even happen? How would that even happen? The arm can potentially go faster because of that restitution effect he talked about. Never said anything about applying that to the tail light. The tail light, you know, is part of the vehicle. The issue with the restitution effect was that it's because of the enormous differential between the weight of these two items that the arm can accelerate faster than the speed of the vehicle. Nothing in that about the tail light. All he can say is that they are moving at the same speed. He agrees the tail light would have been pushed into the arm, caused the tail light to fracture, then they would have moved out at the same speed. But his area of expertise is not the injuries to the arm, just the whole, you know. Yes, it would have been pushed into the arm and caused the tail light to fraction. And as we saw, it happened over a period of 10 milliseconds. So then we had our recess. But came back from the recess. And we've got that motion to the mistrial, motion for the mistrial that Mr. Alessi brought, based on intentional misconduct vis-a-vis the hoodie. We went through and established. Hoodie was undamaged when it went to the criminalist. The criminalist cut holes in the back, documented it 9 ways from Sunday, all in the possession of the Commonwealth, yet they intentionally brought it up to the jury on cross-examination of Dr. Wolfe without good faith, without a good faith basis, implying that those holes on the back had something to do with January the 29th and what happened then. But in fact, they were cuttings taken by the criminalist. So then we, you know, we have to struggle, of course, to get all that in, because making the record of the error, we can't make that straightforward. Got to make that overcomplicated too. But eventually, yep, we get all these things off. We've got the hoodie now out of the plastic where it should be. I don't know why it was in plastic in the first place. I really don't. I really don't. I mean, what a strange decision to make. But now it's out of the plastic. So the jury has seen it in its loose condition. Bottom line, the Commonwealth has no case because they can't prove that there's a collision. So now they are trying to create some evidence where there is none. They are rising to the level of manufacturing evidence, trying to make it seem like Dr. Wolfe didn't do his job when all along they knew those holes were caused by the criminalist doing the sample. So it is misdirection and misleading on a key issue of the case. By the way, all these other sources available about the holes to the back of the hoodie, the provenance of those holes, none of that made it into evidence. Even the photograph of the back of the hoodie didn't make it into evidence. What a coincidence. What a remarkable coincidence. The prosecution's supposed to be held to a higher standard, becoming evidently clear. The more desperate they get, the more they are resorting to conduct like this. This is the antithesis of a fair trial. Confidence in the process and that prosecutors will conduct their duties responsibly require that at some point that be enforced. Yeah, in a normal world, it would, wouldn't it? It would require some kind of standard to be enforced. But here we are And so then Brennan, did what was probably the only option available. I messed up, but you can cure this short of a mistrial. Just give him an instruction. It was inadvertent. Wants her to comment on his own activity. So then she's not going to grant the mistrial. We already knew that. She'll put the documents into evidence. She'll allow the hoodie to be displayed. She'll instruct the jury. And then we're wordsmithing what the nature of that instruction is going to be. And so she's describing it. And then Mr. Alessi is apparently conferring with his co-counsel, and she gets all huffy. That's what I said, Mr. Alessi. If you're not going to listen, we'll just bring the jury back in. Look who's causing the problem. How dare you make her have to deal with this, Mr. Alessi? Don't you know the jury is waiting? This is taking valuable time. How could you do this to the court like that? We see where the problem is. Not a single grave concern about the misconduct. But Mr. Alessi, you are not giving me the attention I require. And we're going to have an issue with that. This is just classic. So then we just get the instruction. The back of the sweatshirt is held up. We get the instruction, and it's just the holes were made by the criminalist back on May 18th. Holes were made by the criminalist. Nothing about, they did not happen from the accident, just they were made by the criminalist. That's what she decided she's going to do, so that's what we get. Then we get John Tedeman, the private investigator for the defense. He has just laid some foundation for going to 34 Fairview to take measurements with the measuring wheel and take some photographs. Anybody find it interesting that it really seems like the new homeowner is pretty FKR? No problem. Permission to come in, do whatever you need. Last week you show up to do stuff. Last minute. No problem at all from the homeowner. The homeowner, guys, I'm just here to tell you, the homeowner is totally free Karen Reed. Okay, they don't have to allow this. You don't got a court order. You don't have anything. They don't have to allow you onto their property to do anything at all, but they do. So that ended when, we have to redact the photograph. We can't show the whole photograph for some reason that is not evident. And so they put it up on the screen, and then we have to take it right back down, and then that's that. And now we're going to go to lunch, but we got to do Laposata's Voir dire. So we did Laposata's Voir dire. Bottom line, she's extremely qualified to do everything she's being proffered to do. Talk about dog bites. Yeah, that's so fundamental. You learn about it in school, and then you're board certified. Your testing accounts for it because it's something that you have to do as a forensic pathologist. It's just so routine. She herself has done probably 50 autopsies involving dog bites, overseen about another 75, quite a bit more than the 5 that was going to be not enough for Bev. What are you going to do with 50 to 75 now, Judge? What's your magic number now if that's not going to be enough? Pattern recognition is such a common part of what they do in the differential diagnosis that she doesn't even remember a specific class. You don't have to. She's taught in medical school some of these principles and so forth. She was qualified by a federal court to opine on whether specific injuries had been caused by a dog. So she actually has a history of being qualified to testify about this type of thing in a court that uses the Daubert standard. Yes, she came to conclusions about the cause of wounds to the arm and also the consistency with a motor vehicle collision. She was able to come to scientific conclusions based on that. And then we came back on redirect, and what we got was that she doesn't have a specific class on dog bite injuries. And she just kept repeating. I love how she handled that. Brennan's going to keep repeating the question. She's going to keep giving the same answer. This is such a basic part of what you do as a forensic pathologist that it's in your textbooks, it's in your studies, it's in the board exams. It's all part of wound pattern recognition. Then she comes up with some other examples: hammer injuries, gunshot wounds, baseball bat wounds. They all leave patterned injuries that the medical examiner is going to be expected to recognize. So no, she hasn't listed every single class she's ever taken. Where is it in her resume that she has this knowledge? It's right there where it says she's a forensic pathologist because it's part of the basic knowledge you have to have. So no, you wouldn't put that in your report. It's one of those goes without saying types of things. Dog bite training, it's just with other pattern recognition training. She doesn't have a specific list of cases she's been involved in where she's testified about dog bites. The one in the federal case was about COVID and the canine caper. They always give these very clever names to the canine dogs, right? Caper, Warrant. I always liked Warrant as the name of the dog. That's a pretty funny one. Got a warrant? Yeah. Go get Warrant. Ha ha ha. It is kind of funny, but yeah, she was able to opine about whether caper inflicted the injuries that they saw. They have the same jaw, so otherwise pretty much the same as far as the canine and the domestic dog. She's not a mechanical engineer. She relates the injuries to the motor vehicle collision. They look at the pieces, the debris, the body, the bloodstain patterns, the damage to the car, and then pass what they learn onto investigators. Investigators might do further examination of the scene and other specialists, and it's all part of correlating the injuries to the vehicle. In this particular case, she's reviewed autopsy report, neuropathologist report, toxicology, 104 photos of the autopsy, 70 plus photos by Watson, John's medical records, Good Samaritan's records, another 30-some photos that they took, clothing, the photos from the crime lab, the photos of the SUV, the Canton Police Department report, 100-plus photos of the scene. Brought up the case where she was not allowed to testify, but she does not purport to be an accident reconstructionist, disclaims that, nothing on her CV about it. Probably Bev wants to know how many autopsies of dog bites. Oh, probably 50. What do you think about that, Judge? 5 wasn't enough. I don't know what your magic number was going to be. Okay, how about we increase it by 10 times, a factor of 10? Is that enough? Supervised 75 last time 2 years ago. Yeah, I'd say she's qualified. So at the end of the day, it's the argument. That's her experience. Brennan says it's not enough. It's not enough. She doesn't have anything in her resume that makes her a dog bite expert. Well, just that part where she says she's a forensic pathologist, Hank, and it's fundamental to being able to do that job. So she's going to rule as soon as she can, and we're going to start up in like about another 5 minutes. So with that, guys, please do give me a break to step away momentarily. We're hot. We're having a heat wave over here. Definitely got to check the trees. So hopefully I will make it back before court gets back on. Hang tight, and I'll be right back with you. Okay, guys, thanks for giving me a second there. We made it a little bit of a rush to try to get back here before lunch got started again. You know, I did realize a thing I did forget to mention in my recap. Don't want to forget to mention we got two more. Is this going to be, how long is this going to take? Two more. How long is this going to take directed towards the defense today? So they have been added to the list. We have a total of 3 now. How much longer is this going to be directed to the defense? 0 directed towards the Commonwealth. No apparent concern with how long it's going to take the Commonwealth to do things. So what have you guys been thinking? Donna ST, is Welcher the only witness the Commonwealth intends to call? Apparently they want to also call Maureen Hartnett and then call Dr. Crosby to rebut Dr. Laposata, it sounds like. Don't think they're quite in the same area of expertise, but, you know, we didn't have to have any kind of a Daubert Lanigan hearing for Dr. Crosby. He's facially qualified to be able to testify to these types of things. We don't even have the brief voir dire that was necessary for Dr. Laposata here. Nothing at all. Nothing like that for him. So he'll come back and rebut the medical examiner. That is what Hank intends based on his representation. So Andrew Hansen, you need another option, partial verdict. Does Bev allow a partial verdict this time? Yeah, that's a good point. I guess if it's a partial verdict, it would be hung on one, at least one. You know, the rules do say that if there is a partial verdict, she has to allow it. The real question here, I think, is if there is a partial verdict, is the jury going to be able to figure out how to fill out the paper this time? Because that's going to be the only way to signal. Although maybe everyone's on heightened alert now. Maybe they'll be asking specifically. You can't reach a verdict. Are you sure you can't reach a verdict on any counts? No, they probably won't. Probably won't. So if they actually do fill out the forms returning a partial verdict, she doesn't have any choice under the rules. She's required to, I believe, wasn't that what we saw in Massachusetts? She's required to accept it. Let's see. No, it looks like it's all in May language. It's all in May languages. This is what I'm looking at here, Criminal Procedure Rule 27. If there are 2 or more offenses or defendants tried together, the jury may, with the consent of the judge, at any time during its deliberations, return or be required by the judge to return a verdict or verdicts with respect to the defendants or charges as to which a verdict has been reached. And thereafter, the jury may, in the discretion of the judge, resume deliberation. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. So that is the standard that we're working with, and it's May. It's discretionary, so it doesn't sound like they do have to allow that. It would probably be a mess if she didn't. If they actually filled out the form and she refused to accept it, I got to think that's going to be a problem. That's going to be a problem because we now have it in writing. The whole issue with whether there was a verdict or not, it's a very different issue in a situation where we filled out the form and we've come back and like prepared to present it. And the judge just doesn't accept it for some reason. I think that would be more of an issue. Jack Spears, your hair looks amazing. Slay Queen. Thank you so much. It's just what a little blow dry will do for you, huh? Watching from the UK, I am absolutely shocked how this judge has zero control of the court. If this was in the UK, it would be so different. Yeah, I imagine it would. A lot into the formalities over there in the UK courts. Very high priority to exercise all of those basic civilities and formalities. My esteemed colleague over here across the well. No, I forget. It's my friend, isn't it? Don't they call the opposing party the barrister, the barrister for the other party? Don't they call him my friend? Am I misremembering that? She has no control over the court because she doesn't want to. She doesn't want to enforce any boundaries when it comes to Mr. Brennan. She wants him to be able to run the show and for her to not have to do anything about it. And the thing is that, you know, if you're a lazy judge and you have a good prosecutor, one that is trustworthy and will play in between the lines, you kind of can do that. You can just defer to them to rule it because you can rely on them to not put you in a bad spot. But the problem is when you can't actually rely on the prosecutor, that's a really bad call.
All right, I appreciate the court personnel waiting so that we could have that voir dire. It was helpful. All right, so my rulings are very similar than they were this morning. So first of all, on the Daubert analysis regarding Dr. Laposata being able to testify as to the dog bite wounds, I find that she is not qualified. I'm not satisfied that the Daubert requirements have been made, specifically not just the experience, but the reliability of the methodology she used and how it was applied. So based on that, she cannot testify to the dog wounds, and I want to take a minute to differentiate this testimony with Dr. Russell's. I found that Dr. Russell was an expert, qualified to testify as to dog bite wounds, mainly from her experience in the ER, coupled with her being an ME. Dr. Laposata does not have that experience. I found that Dr. Russell's methodology was reasonable and was sufficient, and I found that it was appropriately applied. Remember that Dr. Russell was published in the area here. So regarding pages 10 and 11, all of the text on Dr. Laposata's report on pages 10 and 11 that start with the injuries on Mr. O'Keefe's right arm are excluded. Now moving on to the testimony regarding not being consistent with a motor vehicle strike. I find that Dr. Laposata's opinion on these not being the result of a motor vehicle collision exceed what is within her scope of expertise in some regards, not in all. In some regards, significantly, like I said this morning. So on page 17, the first sentence is in. The second sentence, tail lights are typically made of durable polycarbonate or acrylic plastic. That is out. I know the Commonwealth objected to, but I'm letting in. Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting the arm. She cannot say tail light, but she can say that based on her experience. His arm had no tissue bruising.
What
from
other
impact.
plastic is there?
That also comes in. And the next sentence, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. That's within her realm of expertise as a medical examiner. The next page, though, I may have said this morning that first sentence, importantly, in review of that and review of the Tompkins case, that first sentence stays out because to me, it seems like that sentence depends on a biomechanical analysis, factors such as speed and force and the position of Mr. O'Keefe. So that's, oh, I'm sorry, page 18, the next page regarding the same subject matter. And the portion of the next sentence is also out. This results in bruising or bleeding under the skin. That's out. But Dr. Laposata can testify that Mr. O'Keefe had no bruising on his arms or torso. And that's it for that sentence. In particular, Mr. O'Keefe did not have bruises on his legs as shown by dissection of leg tissue and muscle at autopsy. That's it for that. And the conclusions are problematic to the extent that is consistent with this ruling and what we discussed on Friday. So that's it. That was just the text of her report. I have not begun to go through all of there's no PowerPoint with this, Mr. Jackson, right?
There is no PowerPoint.
All right. Do you intend on displaying any of these photographs?
I'm sorry?
Do you intend on displaying any of the photographs that are in her report?
Yes. I have to go through it now with the portfolio and
all right, so you likely not get to that today. We've done important work, but we've wasted an awful lot of the jurors' time today. So I want to bring them in.
And whose fault is that?
And
my suggestion, we have to finish with that.
right, we're going to do that now. So that'll give you an opportunity to pull your thoughts together.
Right, and I expect what I will do is my intention. I will go through her. That will take me a good amount of time. I will go through the part of her initial analysis that will not include any of the photos, but I may be overnight to actually go through the court's ruling. It's very specific, and I want to be as
okay. So let
that as possible.
Let me know what you intend to put in. All right, and there's a lot of text describing the photos that is out, right? It's just hearsay.
I mean, we've had Dr. Welcher's PowerPoint.
That was not objected to. There's a big difference.
Yes, it was objected to.
So we'll deal with this tomorrow, with the photographs tomorrow.
I just want to let the court know, not waste the court's time.
Okay, thank you. And we're bringing the jurors in. Did the Commonwealth want to respond in any way?
No, thank you.
Okay. And there's a motion on Dr. Rentschler. We will give that, I haven't read it yet. We'll give that no more than 5 minutes tomorrow morning each side.
Sure.
This jury, you can tell just by looking at this jury, they're fed up. So.
Your Honor, the only thing I want to put on the record is, with regards to the court's ruling, I do want the record to reflect that is obviously it's over the defense objection.
Sure.
And I just want to make for the record a quick comment. The Commonwealth waited until June 5th to even bring this up, to file a motion regarding Dr. Laposata. They had a report, and all reciprocal discovery was done in March 6th, 2025. That's document number 45.
Yeah.
And the Commonwealth was ordered to file whatever motions they wanted to, whatever motions in limine they thought were appropriate by March 7th. And they did not do that. They were supposed to be heard on March 18th.
Okay, so the jurors are coming in. We're going to mark the report and the CV for identification.
I just need to know when I can make it.
You just made it.
I made it-ish.
Okay. Okay.
But the point is...
Untimely.
Go ahead, real quick.
The point is, the Commonwealth has not explained the delay making this motion. They haven't, and we're playing by the same rules, Judge.
So the basis of my ruling was not late disclosure. Okay? Late disclosure. Commonwealth says they're partial.
That's not the court's missing the point. It's the opposite. We got late disclosure. We got late disclosure that they were objecting. They've had since March to object. They blew the motion in limited time, and then they come in just before Dr. Laposata just before Dr. Laposata testifies, and now we're sort of sandbagging this and getting court moves against us. So I want to make sure that the record is imminently clear about
Very clear. Mr. Brennan, do you want to respond real quickly?
Your Honor, we can always object even during proffering of testimony. There's no foundational issue.
And that's consistent with what my rulings were when I allowed other witnesses to testify, that the defense could object if the foundation weren't properly laid. So bring them in, please.
Anyone surprised? Anyone surprised that the voir dire actually meant nothing at all because Bev is just going to go with what her knee-jerk reaction this morning was anyway? And her knee-jerk reaction this morning is, no, it's fine for Yuri Buchanan to testify about injuries, but the medical examiner, no. Her methodology isn't reliable. It's the same methodology, wound pattern recognition, that Russell testified about. Nevertheless, it's not enough. Same thing about inconsistent with a motor vehicle accident. Gordy Bello could testify about that, but not
Jurors, you have been
Laposata.
extraordinarily patient with us today. We're going to go straight through until 4 o'clock, and we're going to make every effort to not leave you waiting out there as long as you have, as long as we did today. All right, Ms. Yanetti, is your witness ready? All right, Mr. Tedeman, whenever you're ready, sir.
Thank you. Thank you, Your Honor. Sir, before the lunch break, you had identified 3 entrances to the front of 34 Fairview, leaving aside the 2 garage car doors. Do you recall that?
Yes.
May I have that last exhibit displayed, please? Not that one, the one that we discussed right before court. There it is. Maybe zoom in on that a little. Okay. What do you see on the screen at this point, sir?
I see the 2 rightmost entrances to the house, excluding the main front door.
Okay, which would be obviously to the left of this photo, particularly with regard to the 3rd entrance, the one in red. Could you describe that?
Yes, so it's if you're facing the house from the street, you're looking towards the west. So that door goes directly into the garage facing north.
Okay, so basically from the street, you don't have to enter the house, you can go into the garage directly.
That is directly into the garage, yes.
All right, and as we're looking at the house from this point, are we looking at it from the vantage point of Fairview Road?
Yes.
And that is a westerly direction toward the house, sir?
Correct.
In the course of doing your further work that you were asked to do in this case, did you peer inside the garage?
Yes, I did.
Did you see concrete steps and a ridge there and a hard concrete floor?
Yes.
Sustained. Jurors, disregard that answer.
You mentioned that you were asked to do some measurements. Can you describe what you were asked to do for the jury?
Yes, I was asked to measure from basically the mailbox area of the driveway to the various entrances to the house.
Did you take those measurements?
I did.
Okay, if I'd like to take them one at a time. First, did you measure from the end of the driveway next to the mailbox all the way to the main front door, which is not depicted on this photo?
Yes, I did.
How did you measure it?
I used my wheeled measuring device, and I walked directly across the lawn to the front door, well, to the bottom of the front steps, and then used it to go up the front steps straight to the door.
And what was the measurement, if you recall, from the mailbox area near the end of the driveway to the main front door on the left?
I believe it was 65 feet 9 inches, but I have notes if I
think you got it right, sir.
Okay.
Next, did you measure from that same location near the street, the end of the driveway next to the mailbox, to the second front door, which is actually depicted in the exhibit that's on the screen?
I did.
And how did you measure that?
I walked along the edge of the driveway on the asphalt right next to the grass towards the house from the mailbox and the edge of the street towards the house. I took a left onto the brick walkway, proceeded along that walkway, then took a right to the walkway that you can see right there, heading directly to the door, and went up onto the little decking area, and then those 2 steps directly to the doorstep.
Okay, so you walked essentially almost the whole length of the driveway?
Yes.
Before you took the left to get to where the steps start, going to that second front door?
Yes.
And then went up to the door itself?
Yes.
Do you recall from your memory what the measurement was?
I believe it was 70 feet 1 inch.
And finally, did you measure from that same end of the driveway near the street next to the mailbox to the red side door, which is the pedestrian entrance into the garage directly?
I did.
How did you measure that?
I did the same thing, walking directly from where the mailbox and the driveway intersect, basically, all the way up the driveway, took the same left onto the red brick pathway, took a right to go towards the front door, went up the 1 step that you can see, and then instead of going up the next 2 steps, I took a right directly towards the garage entry door.
So essentially the same path of travel, it's just you didn't go straight into the second front door, you took a right to go into the pedestrian entrance to the garage.
Correct.
And what was the measurement that you discovered having done that?
I believe it was 78 feet 3 inches.
All less than the
Now,
87.
finally, could we have displayed the map of Cedar Crest, Fairview, and Chapman? There it is. Sir, are you able to see the street names from where you are? And if
Yes.
not, could we have the top street magnified so that the witness can see it? Okay, you see that?
I do.
What do you see that to be?
Cedar Crest Road.
Okay, if we could have the connecting street where the, that's it.
Fairview Road.
All right, and finally, the one down the bottom?
Chapman Street.
Okay, if we can get the whole map back up. Having seen those 3 street names, does that orient you as to what this is a map of?
It does.
And what is that?
This is the surrounding area of 34 Fairview Road, the neighborhood, basically.
Okay, and it includes the 2 connecting streets on either end?
Correct.
Does the red dot symbolize anything for you?
It looks to be where 34 Fairview Road is located.
Okay, and if you're on Fairview Road to the right of that red dot as it exists on that exhibit, and you're looking toward Fairview Road, what direction would you be facing?
I'd be facing west.
If I may have a moment, please.
Okay. I think that's probably it.
No further questions. Thank you very much, sir.
Thank you.
What, Mr. Tedeman, you couldn't be successful as a lawyer? Real estate practice not going very well?
Good afternoon, sir.
Good afternoon.
You had a wheel to measure?
Correct.
And so there's like a tape measure, and when you wheel it out, it gives a straight line?
No, it's two wheels with a meter in between them, and you roll it out in front of you.
I see. Your first measurement was from the driveway to the front door?
To the main front door to the far left, yes.
And that was about 63 feet?
I believe it was 65 feet, something like that. I have my notes, yes.
So suffice to say, if you were to leave the front door and come back to that spot, it would be an additional 65 feet back, right?
Yes.
The second measurement was from the bottom of the driveway to the middle door on the side?
Yeah, the second front door, yes.
Did you say that was about 70 feet?
It was, yes.
And again, if you were to come back, that would be an additional 70 feet?
It would.
And the last one was the door near the garage. Did you say that was further, around 80 feet?
78 feet, 3 inches, I believe.
One way?
Correct.
And back is another 78 feet?
Correct.
When you measured these, was it from the asphalt of the driveway or to the left of the mailbox as you're looking at Fairview?
It was to the right of the mailbox on the asphalt, as close to the mailbox as I could get.
Did you happen to take any measurements from the flagpole to the front door as far as distance?
I did.
And what was that?
I do not have the exact measurement. I'm not sure.
Do you have it in a report?
I don't. No, not with me.
How about the flagpole to the middle door on the side? Did you take any measurements of that?
I'm not sure I took that one.
How about the flagpole to the furthest away door, which would be the door next to the garage? Did you take any measurements of that?
I think I took a direct measurement to that, yes.
Right. And what was that number?
I don't know.
Do you have a report you can share with us?
I don't. No, I'm sorry.
It's okay. Did you ever measure, if you were at the flagpole area, how long it would take to walk up the street? Or how far it would be to walk up the street, up the driveway, for any of those doors? Did you ever measure it that way?
I did.
And what was the distance if you were going to start at the flagpole, walk up the street, up the driveway, down the walkway to the front door?
I'm not sure that distance. Not positive the distance.
Was it over 80 feet?
It was.
And if you did the same route up the street, up the driveway, to the middle door, would you agree that would be well over 80 feet as well?
Can you repeat the question? How?
Sure. From the measure from the flagpole, up the street, up the driveway, to the middle door, that would be well over 80 feet?
Yes.
Same to the door next to the garage?
Yes.
Thank you for your time.
Thank you.
All right, you are all set, sir. Thank you very much.
Thank you.
Good job not doing more redirect on that because it didn't matter.
Okay, Mr. Jackson.
Thank you, Your Honor. We would ask the court to ask Dr. Elizabeth Laposata to join us.
Okay.
What if he shot up to the moon? Up into outer space with the SUV? How would that be greater than 80 feet?
You're gonna step up, face the clerk, and raise your right hand, please.
You solemnly swear the evidence you give to the court and jury in the case now and hearing is the truth, the whole truth, and nothing but the truth, so help me God.
I do.
Good afternoon, Doctor.
Good afternoon, Your Honor.
May I inquire?
Yes. And Dr. Laposata, please speak right into that microphone,
I
okay?
will.
Thank you.
Doctor, can you please state your full name and spell your last name for the jurors?
Yes, Dr. Elizabeth Laposata, spelled Laposata.
I'm going to ask you, you have a softer voice. I'm going to ask you to pull that microphone right under your chin, if you don't mind. It's pretty adjustable.
Okay. Better?
That's better.
Okay.
That's better. Doctor, can you tell the jurors what you do for a living?
Yes, I'm a medical doctor and I subspecialize in forensic pathology.
Can you summarize your professional background?
Certainly, I graduated in 1975 from Bucknell University with a Bachelor of Science in Biology. I went to University of Maryland School of Medicine, where I graduated in 1979 with a Doctor of Medicine. I did my internship and fellowship at Johns Hopkins Hospital in Baltimore, where I studied anatomic pathology, which is the study of the diseases of the body. I then did my subspecialty fellowship in St. Louis in forensic pathology, which is understanding causes of death and injuries to the body.
Currently, are you a professor?
Yes, I am.
And tell us where you work.
I own my own independent consulting practice, and I'm also an associate professor at Brown University School of Medicine.
How long have you taught at Brown University School of Medicine?
Since 1993.
And how long have you been a clinical associate professor of pathology, either at Brown or before that?
Oh, gee, then that would have been since at least in the late 80s. I've been associate professors at the universities and medical schools where I've worked.
Doctor, at Brown University, let's take Brown first. What do you teach there?
I teach the second-year medical students. I teach a lecture in diseases of the heart, cardiomyopathy, and myocarditis. And I've been asked to give some specialized lectures in toxicology and forensic pathology.
Are you responsible for training medical students in the field of forensic pathology?
When I was a chief medical examiner, yes, we would have medical students, residents come into the office so they could learn about what we do to understand cause and circumstances of death.
When you first got your medical license, did you then undertake to get certain board certifications and the like?
Yes.
Before we get to those board certifications, did you begin a practice in forensic pathology in some way or another?
After I finished my medical school and my anatomic fellowships and forensic pathology fellowships, then I was working in medical examiners' offices where I was examining deceased people to understand how they died.
When you get a medical license, is that statewide or is it nationwide?
Usually you get a state medical license.
And do you hold a state medical license?
Yes.
How many?
I have an active medical license in Rhode Island where I have my consulting practice, and I have inactive license in Maryland, Delaware, Missouri, Pennsylvania.
And you've been...
And I have inactive license in Maryland, Delaware, Missouri, Pennsylvania.
And you've been previously, at least before they were active, you were licensed in all 5 of those states?
Yes.
You already told us a little bit about your college. Did you mention Bucknell University? Your Bachelor of Science degree?
I think I did, yes.
At some point after you graduated from the University of Maryland School of Medicine, did you complete any residencies?
Yes, I did my residency at, excuse me, at Johns Hopkins Hospital in Baltimore in anatomic pathology.
Forensic pathology is different from anatomic pathology, correct?
Yes.
Did you also do any kind of residency in forensic pathology?
Yes, I did a fellowship in forensic pathology.
And what is the difference between, if you can sort of take us through that little by little, what is the difference between forensic pathology and anatomic pathology?
Anatomic pathology is sort of hospital-based pathology where we understand diseases of patients who are in the hospital and try to make clinical pathologic correlations to see if their diagnoses were correct, if the laboratory tests actually showed what we find at postmortem. And then forensic pathology deals more with understanding why the body stops functioning at a particular time. So that would be cause of death, and that can be sudden unexpected death or death due to violence.
And in forensic pathology, is that often associated with testimony in court cases that may deal with either on the civil side or the criminal side, coming in and testifying about things like cause of death and manner of death?
Yes.
What types of cases did you work on during your forensic pathology residency?
Oh, sudden unexpected natural death, gunshot wounds, knife wounds, sudden infant deaths, blunt force trauma, skeletonized remains, decomposed bodies, strangulation, the whole gamut of ways people can die unnaturally.
And what type, to contrast that, what types of cases did you work on during your anatomic pathology residency?
There you're mainly dealing with natural diseases and understanding heart disease or how somebody gets pneumonia, or looking at the brain to understand if a stroke was present. And that's especially important then to the doctors who are treating those patients, that they can see if the diagnostic tests were appropriate or if their treatments were worked.
You mentioned fellowship a little earlier in your testimony. What is a fellowship?
A fellowship is after you've done your internship and residency. A fellowship is more specialized training, and I did that in forensic pathology.
So that answers my next question. You do hold a postgraduate fellowship position, correct?
Yes, yes.
And that was in forensic pathology specifically?
I'm board certified in anatomic and forensic pathology.
Were you a research associate at the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Law?
Yes.
I'm sorry, School of Medicine?
Yes.
Old habits. What about postdoctoral research fellow? Were you ever a postdoctoral research fellow?
Yes, I did. I had an NIH research grant where I worked on, how alcohol affects the heart.
Where was that?
That was at St. Louis University, and then when I was on staff at the hospital of the University of Pennsylvania in Philadelphia.
What about postdoctoral research fellow at dealing with the cardiovascular division of the Department of Medicine at Washington University?
Yes, that's where I did research on how alcohol affects the heart.
Was all this in furtherance of your broad education and training as a pathologist?
Yes.
I think you indicated that you have served as a chief medical examiner in answering one of the previous questions. Can you tell me a little bit about that?
Yes, I was appointed chief medical examiner for the state of Rhode Island in 1993, where I was responsible for all unexpected, unnatural deaths or deaths that involve violence in the state of Rhode Island. So I had to supervise the office, made sure I have adequate staff, made sure my forensic pathology staff were doing a good job, made sure I had an adequate scene investigative staff. So running the whole office.
Is that the highest appointment in the OCME's office?
Yes, it is.
In that position, did you oversee every single medical examiner in the state of Rhode Island?
Yes.
Did you also hold a position as the co-chair of Child Fatality Review Committee in the state of Rhode Island?
Yes, as part of being chief medical examiner.
Tell us a little bit about that. What was that appointment?
Well, there's a big concern about infants who die and children who die. So those are reviewed specifically by a group of doctors from the pediatricians and also then the medical examiner's office. So we look at every child and infant death.
How long did you serve as the chief medical examiner in the state of Rhode Island?
For 12 years.
Starting when and ending when?
Starting in 1993 and ending in 2005.
As the chief medical examiner for Rhode Island, did you ever have the responsibility to work on any mass disaster cases?
Unfortunately, yes.
Okay, tell us a little bit about that. If you could start with the Egypt Air issue.
Yes. Excuse me, I'm so sorry. In 1999, the Egypt Air 990 took off from New York airport, and it crashed off the coast of Massachusetts, and 2,065 passengers died. And because of the force of the airplane going into the water, all the bodies were fragmented. So all the fragments were brought to my medical examiner's office. They actually vacuumed the ocean floor, and we had 2,600 some fragmented remains from that airplane crash, and that involved working with FBI, TSA to identify those individuals and understand exactly why they died.
What was your role and the role of your staff that you supervised in dealing with those other government agencies, the FBI, the NTSA, other entities, in terms of the fatalities that you did review as a medical examiner or the chief medical examiner of Rhode Island?
Well, I dealt with families from around the globe who had relatives on that flight, and then the FBI was looking into what may have caused the crash. The Egyptian government, who owned the airplane, was also there and interested in understanding what happened. And we were also, tasked with identifying everybody who was on the plane and to see if that matched the passenger manifest list. So were there people on the plane who shouldn't have been on the plane? So that sort of thing.
In terms of matching that manifest, were you the head of the department for the medical examiner's office that was responsible for trying to figure out who was on the plane and match those remains with the individuals that were on the manifest?
Yes, we made the positive forensic identifications and returned the fragmented human remains to their families.
Doctor, did you also deal with the tragic Station nightclub fire?
Yes.
In what capacity did you deal with that?
Again, this was a nightclub that burned down. It burned down very rapidly with a very hot fire, and that was in Rhode Island, and there were 100 fatalities from that. So those come to the medical examiner's office. I had my investigator at the scene throughout that time of recovering the bodies, and I was charged with determining the identity and the cause of death.
Were you successful, or your staff successful, in determining the identity of most of those individuals who perished?
Yes, all of them. We worked around the clock for 3 days to get that done.
And you were the head of that task force. Before you became the chief medical examiner in Rhode Island, did you previously work as a medical examiner under somebody else?
Yes.
Tell me about that. What was your first post as a assistant medical examiner?
My first post was after I did my fellowship training in St. Louis, Missouri. I was an assistant medical examiner for the city of St. Louis.
Were you ever an assistant medical examiner in Philadelphia?
Yeah, so after St. Louis, I moved to Philadelphia, where I was on staff at the hospital of the University of Pennsylvania, and I ran the autopsy service there at the hospital, and I was also an assistant medical examiner for the city of Philadelphia. After that, I was an assistant medical examiner for the state of Delaware, and then I came to Rhode Island as I was chosen to be chief.
Did you autopsy our World Series prospects?
Can we put dates on that? Assistant medical examiner in St. Louis, from when to when? Do you remember?
Oh my, let's see. May I look at my CV?
Sure, with the court's permission.
Yes. Okay. Yes, from 1983 to 85, I was an assistant medical examiner for the city of St. Louis. Then in 87 to 91, I was the assistant medical examiner for the city of Philadelphia. 91 to 93, assistant medical examiner for the state of Delaware. And then 1993 to 2005, I was chief medical examiner for the state of Rhode Island.
Thank you for that. Dr. Laposata, have you held any faculty positions as in the field of forensic pathology that qualify you as an expert in this case?
Yes. Every medical examiner's office I worked in, I also had faculty appointments to teach medical students and pathology residents. So I had faculty appointments at Washington University School of Medicine in St. Louis, at the Hospital of the University of Pennsylvania, in Philadelphia, and in Rhode Island.
Let's talk about those one at a time. Describe your teaching responsibilities at Brown Medical School, if you wouldn't mind. And that, by the way, that's from 1994 to present, correct?
93 to, well, as a medical examiner, it was 1993 to 2005. And there I would teach the medical students. We had rotations through the medical examiner's office, and also the pathology residents would rotate through the medical examiner's office, where I would teach them how to do a medical legal autopsy, how to understand cause and manner of death, especially non-natural and traumatic deaths.
With regard to your teaching responsibilities specifically, are you still teaching?
I'm teaching in the cardiovascular section now, but since I'm not chief of the medical examiner's office, I obviously don't have students rotating through there anymore.
Were you a lecturer in the role of medical examiner? Did you do a seminar in that regard at or associated with Brown University School of Medicine?
Yes.
Did you do some sort of a forensic pathology rotation for pathology residents from 1994 to 1995 in that capacity as well?
Yes, we would have the pathology residents who were at the hospital studying anatomic pathology come to the medical examiner's office so they could understand the discipline of forensic pathology.
What is cardiomyopathy?
Cardiomyopathy is a muscular disease of the muscles of the heart.
And what is myocarditis?
Inflammation of the heart muscle.
Did you ever teach or lecture on those issues?
Yes, I teach every year. I teach the second-year medical students about those heart diseases.
Have you ever taught anatomy and physiology to EMTs?
Yes.
Or in the EMT setting?
Yes.
And what about a class known as the 2-hour primer on forensic pathology?
I've taught a lot. I don't recall that particular
How about pathology residents morning conference in 2009?
Oh, yes. I give lectures to the pathology residents at the medical school at Brown Medical School in forensic pathology.
You also mentioned that you were an adjunct professor for biomedical forensic sciences and forensic anthropology in the Department of Anatomy and Neurology. Is that a division of the graduate school, Boston University School of Medicine?
Yes, I taught in the master's program in the medical school at Boston University School of Medicine for a master's in forensic science, where I taught a 40-hour course on forensic pathology and another 40-hour course on medical legal death investigation.
Were you actually the course director in that position?
Yes.
And were you also a course director in medical legal death investigation from 2006 to 2013?
Yes.
And what about a course director in forensic toxicology from 2006 to 2012?
Correct.
Did you direct the studies in biomedical forensic sciences, GMS, from 2012 to present?
Yes.
Describe that. What is that?
The graduate medical sciences?
Correct.
Okay, yeah, I would review and be on the board to examine projects that the students were doing to get a master's degree.
Were you also an assistant professor in the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Medicine?
Yes.
Okay. Without going into every single class that you taught, did you teach from 1987 to 1991, attending staff medical pathology?
Yes.
What is that? Just a general outline of what that teaching course was.
That's when I was at the hospital, the University of Pennsylvania. I ran the autopsy service, so I taught medical students and pathology residents about autopsy practice.
I want to ask you sort of broadly, can you describe your major teaching and clinical responsibilities when you were at University of Pennsylvania School of Medicine in the field of forensic pathology? What were your main clinical and teaching positions?
Well, I ran the autopsy service there, so I taught the medical residents and medical students autopsy pathology, and I was also a assistant medical examiner there, so I taught and started the forensic fellowship in forensic pathology.
Have you ever been qualified as an expert witness in forensic and anatomic pathology in state and federal courts?
Yes.
How many times would you say you've qualified as an expert?
Over 40 years, maybe several hundred.
How about in Massachusetts?
That includes all of them.
Okay. Have you ever qualified? Let me list a couple of states. In Massachusetts?
Yes.
California?
Yes.
Connecticut?
Yes.
Delaware?
Yes.
Florida?
Yes.
Illinois?
Yes.
Maryland?
Yes.
Minnesota?
Yes.
Missouri?
Yes.
New York?
Yes.
Pennsylvania?
Yes.
Rhode Island?
Rhode Island, yes.
Have I left anything out? That's
Did you say Massachusetts?
I did.
Okay, then
We
you're
started
fine.
with Massachusetts.
Okay, you're fine.
What types of topics have you qualified to testify about as an expert forensic and anatomic pathologist?
Really anything that has to do with circumstances and cause of death. So it doesn't really matter, like, what type of injury or a sudden unexpected death. Usually it involves examination, study of information from the scene, information from the autopsy, police and investigation and medical records, and we put that all together and figure out the circumstances as to how someone died and why their body stopped functioning. So that's the basis of forensic pathology.
Dr. Williams, excuse me for just a second. You want to make it for one brief.
Let's approach, because we've just spent a lot of time on qualifications for somebody who isn't going to be allowed to say much of anything at all. I suspect that a lot of this is not for the jury's benefit. All her experience with the nightclub fire and the plane crash and all of that type of thing. Obviously, it doesn't have anything factually to do with this case. But remember, we had the voir dire, and we had to truncate because Bev's in a hurry, right? We can't have the jury wait all day, and it's very inconvenient of the defense to be wanting to put on, evidence and justify it. So we got to do this very quickly. So just do the truncated version of her resume with respect to those specific things, right? The dog bite and the motor vehicle accident, and is she qualified to recognize either of those things on a body? So we're making a record now of the non-truncated version of how and why she is qualified as a forensic pathologist, like all over the country, to testify about the issues that are presented here. So it probably isn't, significant to the jury in the sense that, yeah, they probably are also sitting there wondering, why are we talking about a plane crash in a nightclub and stuff like that? They have to make their expert. They have to make the record of how thoroughly qualified she is when it comes to being able to perform very complicated and difficult tasks like identifying, bodies from parts, burned remains, so forth. Gotta imagine you're going to use some pattern recognition for that type of work. Not wound pattern recognition necessarily, but definitely going to be some pattern recognition. Like what? Oh, dental records is a real common one. Fingerprints is a real common one. Stuff like that. So we're having to go through this because we couldn't do it during the voir dire. That left with the conclusion that she's unqualified to have these particular opinions. Not enough experience. Her 50 to 75 autopsies involving dog bites.
2 minutes. Dr. Laposata, I'm going to ask you to step down, and you can go back with the court officer into that back room.
Okay, certainly.
What,
are we taking the jury out for a second?
Downstairs and back up the stairs to come back in 5 minutes. I'm going to sit here, you all can sit here. We're just going to be in recess for 5 minutes while we sit here.
Wait, what? We're sitting here for 5 minutes. They're not arguing anything, not in front of the jury. I don't know what's going on this one, guys. I'm hesitant to have the sound off, but don't want to talk over it. I'll go ahead and take us off the fan. I guess I'm going to mute it just in case, because I know the audio has been really bad. So 2 minutes we asked for. Now we're sitting here waiting. I don't know what it's about. We're not taking the jury out of the courtroom, so it's not an argument about anything. Something going on now? No. Yes.
You can have a seat.
May I inquire?
Yes.
Thank you. Dr. Laposata, you mentioned several topics about which you testified and qualified as an expert. Testified about it as an expert in several different states, several different courtrooms. Have you been qualified as an expert by those courts in those topics about which you just discussed?
Yes.
Do you hold any specialty certifications in the field of forensic pathology?
Well, I'm board certified in forensic pathology.
What about the American Board of Pathology?
Yes, the American Board of Pathology puts forth examinations that are a 2-day examination in the various disciplines of pathology. And if you successfully complete those examinations, then you become a diplomat of the American Board of Pathology in whichever subspecialty you're in. And I became a diplomat in the subspecialty of anatomic and forensic pathology.
What about a certification in basic bloodstain pattern analysis, the International Association of Identification?
Yes, I had a week-long course in understanding blood pattern analysis.
Can you tell us a little bit about the National Registry Emergency Medical Technician certification that you hold?
Yes, I took training to become an EMT.
Have you received a number of honors and awards in the field of forensic pathology?
I have.
What do those awards include?
May I look at my CV again? Sure. Thank you. I had teaching awards from Brown University School of Medicine. I was featured in a book by Faces of Public Health as having run a good medical examiner's office. I was nominated for Woman of the Year in Rhode Island for my work as chief medical examiner and improving the office and handling those 2 mass disasters. I was honored by Victims' Rights and Services Awards because I've always been aware of the fact that as a forensic pathologist, I am the last doctor this person is going to have, so I try to help the family understand what happened. I was honored for my work in the mass disaster in Egypt Air 990 plane crash. Let's see. I was Outstanding Woman in Public Service for Providence, Rhode Island. I've gotten teaching awards from Brown University School of Medicine. I was elected to the Board of Trustees in the Delaware SIDS Foundation and the Philadelphia SIDS Foundation. And then we're back to my medical school.
If you could pull the microphone a little closer to your chin.
It's very hard because the chair doesn't push in.
The chair doesn't move. Okay.
Oh, I got it. I moved.
We'll make do.
Okay.
Thank you, Dr. Laposata. What is the American Academy of Forensic Sciences?
That's one of our medical associations that is specific to forensic sciences.
Have you ever held a chaired position there?
Yes.
What position was that?
I was voted into a fellowship position.
Were you the chairman of Forensic Science Research, the Forensic Science Research Committee?
Yes.
What's the National Association of Medical Examiners?
It's also called NAME. It's another international association of forensic pathologists.
Were you a member of that organization?
Yes.
And at some point, did you get elected to the board of directors for that organization?
Yes.
And ultimately, did you become a fellow for that organization?
I did.
What is the American Society of Clinical Pathologists?
That's a society that is for people who practice anatomic pathology and understand how to interpret laboratory results and biopsies.
Did you become a fellow in 1991 until present for that organization?
Yes.
What's the difference between a member and a fellow?
A member is a lower level, and then you can be promoted to fellow if the board of directors feels that you've contributed in your field.
And were you associated with the College of American Pathologists?
Yes.
Are you a fellow there as well?
Yes.
What about the World Association for Medical Law?
Yes.
What about the American Association for Clinical Chemistry?
Yes, I'm a member.
Rhode Island Medical Women's Association, what is that?
Well, it's basically what it says. It's women doctors in Rhode Island.
Were you elected to the board of directors for that organization?
Yes.
Ultimately, were you elected as the president of that organization?
I was.
Rhode Island Medical Society, what is that?
It's an organization of doctors who practice in Rhode Island.
Are you a council member there?
Yes.
And what about the Massachusetts Medical Legal Society?
Yes, I was a member there. They have disbanded since.
It doesn't exist anymore?
No.
When it was up and running, you were a member in good standing?
Yes.
Good, good. Pennsylvania Association of Pathologists, what about that?
Yes, when I practiced in Pennsylvania, I was a member of that organization.
Did you, in addition to be a member there, did you also hold a chaired position? Were you the chairman for the Committee on Forensic Pathology?
Yes.
Have you served on any editorial boards of any scholarly journals or
Yes.
publications? Tell me about that.
I've reviewed articles submitted for the Journal of Forensic Sciences and the National Association of Medical Examiner Journals.
Did you also hold an editorial position for the American Journal of Forensic Medicine and Pathology?
Yes.
Is that one of the medical journals that is used throughout the country by other medical professionals, other medical examiners?
Yes.
It's a resource?
Yes.
And a text?
Correct.
Have you authored any peer-reviewed publications in the field of forensic pathology?
Yes, I have.
Can you tell us about some of those publications?
Let's see if I got here. Yeah, I've written chapters in textbooks about medical legal death investigation and forensic pathology. I've published articles involving alcohol metabolism, some drugs, cocaine. Let's see. Alcohol metabolism in the heart, I mentioned. Let's see. And so I've published 22 papers, and I've written several chapters.
You already said that you're board certified, double board certified in anatomic and forensic pathology. Is that correct?
Yes.
Now that you've gone through your education, training, background, publications, teaching positions, and chairs that you've held, I want to ask you a really simple question. What does a forensic pathologist do?
Yeah. We are the last doctor that the dead person has, and we figure out what happened to the body to cause their death. And we sign the death certificate that says how the body came to die and also indicates the circumstances under which the death occurred.
Are medical examiners also tasked with determining both manner and cause, not just one or the other?
Both, yes.
What is the manner of death and how is it distinguished from the cause of death?
The cause of death is what happens to the body to cause it to stop functioning. And the manner of death refers to circumstances under which the death occurred. So there's hundreds of thousands of causes of death for why the body stops functioning, but there's only a few manners of death, which would be natural, accident, suicide, homicide, or undetermined.
Those 5 main categories of manner of death, is that the responsibility or one of the responsibilities of a forensic medical examiner to determine that the death fits into one of those 5 categories?
Correct.
What does it mean when the death is deemed undetermined?
Now, when the manner of death is undetermined, that means at the time the death certificate was signed, there was not enough information to put it into either accident, natural suicide, or homicide. So at the time the death certificate was signed, there was not enough information to put it into one of those other categories. It doesn't mean that if more investigation takes place, then you might be able to put it in one of those other categories.
If a manner of death is deemed at a particular time undetermined, at that time, it's because it lacks sufficient additional information. Is that correct?
Yes. It's okay, AJ. You don't have to lead her. That's already what she said.
Information does a medical examiner, a forensic pathologist, consider in making these determinations between natural accident, homicide, suicide, undetermined?
Well, first you have the findings from the examination of the body. So that's sort of a starting place to see what happened to the body. Then you need to also look at the scene investigation. You need to look at any police reports and witness statements, and also medical history of the deceased. And using those 4 sources of information and using your training and experience, you can either say this is a natural death, this is a self-inflicted death, it's a suicide, it's an accidental death, it's a homicide, or if all that information doesn't allow you to put to a reasonable degree of medical certainty into any one of those categories, then you have to leave the manner undetermined. And if more information becomes available later, then you can change that death certificate.
What if no more information comes available later?
It just stays as undetermined. There are cases where there's just not enough information to put it in one of those other categories.
Without getting into what they may be, did you reach any opinions and conclusions in connection with this case?
Yes.
What materials and information did you consider in reaching your opinions and conclusions in this particular case?
Yes. I have my list of materials I reviewed. I reviewed Mr. O'Keefe's autopsy report, the report of the examination of his brain, the toxicology report, and the entire medical examiner file. I studied 100 and some autopsy photos, including photographs of the brain, and then there were 70 other photographs at autopsy taken by a state trooper who was at the examination. I reviewed Mr. O'Keefe's medical records from Good Samaritan Medical Center and the EMS run sheet. I reviewed photographs of Mr. O'Keefe's clothes that were taken at the crime lab. I reviewed photographs of pieces of tail light, hard plastic, clear, black, red. I reviewed photographs of the outside of Karen Reed's SUV. I reviewed the Canton Police Department incident report on the death. I reviewed 100 and some photographs taken by Canton Police of the outside of the house at 34 Fairview Road in Canton. I reviewed some photographs taken by the real estate agent who was going to sell the house of the inside.
In total, putting them in categories, did you review the forensic autopsy?
Yes.
Did you review all of the files associated with the medical examiner's office in this particular case related to the autopsy of John O'Keefe?
Yes.
Did you review the scene investigation through police reports and other things?
Yes.
Photographs as well?
Yes.
Did you review the police reports that were associated with the initial investigation in this case as well as follow-ups?
Yes.
Did you review witness statements and things of that sort?
Yes, if they were included in the police report.
That was my next question. Those witness statements would be included in the police reports that you otherwise reviewed, correct?
Yes.
What about Mr. O'Keefe's medical history as much as you had of it?
Yes, I reviewed his medical history.
And what about hospital records?
His medical history was in the hospital records.
Understood. What method did you use or methodology did you use in forming the opinion that we'll get to in just a few minutes?
Well, in order to arrive at a conclusion of how somebody dies and what the cause of death is, we have to put all our facts out, and then we say, how could these facts have come to be? So it's called like a differential diagnosis. So like if you go to your doctor and you have a white blood cell count, then the doctor would say, well, how many ways do you get this white blood cell count? So that's a differential diagnosis. And then you go from that list and pare it down by getting more data till you come to one final diagnosis. So that's the process of determining how somebody dies and the circumstance around it.
Is it fair to say that you have a pretty significant background, training, and experience regarding coming to the conclusion of cause and manner of death?
40 plus years.
And how many autopsies in total?
Well, myself, I've probably done over 3,000, and then I have observed and reviewed maybe 7,000 more.
So that's in total over 10,000 autopsies if you would estimate over 40 years?
Probably.
In addition to just autopsies, how many death investigations, separate and apart from autopsies, have you been involved with?
Well, the autopsy usually has a corresponding death investigation with it.
Do you have experience in examining, identifying wounds, not necessarily the cause and manner of death, but wounds that are associated with someone on whom you're performing an autopsy or you're supervising an autopsy?
Yes, and looking at the injuries on the body and understanding what caused them is a huge part of forensic pathology.
Have you ever conducted or overseen any autopsies of individuals involved in vehicle-pedestrian collisions?
Yes.
How many times, if you had to estimate?
No, hundreds.
100 or hundreds?
Hundreds.
When was it that you first started training on the issue of wound pattern recognition that helps assist you with coming to your conclusions, whether it be auto pedestrian incidents or otherwise?
Yeah, well, understanding wound patterns and injuries is a big part of forensic pathology because we want to identify what caused a particular pattern. So understanding that whole complex bag of injuries begins when you start your forensic pathology training, which was when I started back in '81.
In addition to the cause of death, which might be whatever, a gunshot, something. Does the pathologist also undertake an examination of the rest of the body that's not so obvious, other wounds, etc., that might tell a more defined story?
Yes, we look at the entire body, we look at the clothing, we look at the outside of the body, then we do the internal examination in order to understand not only why the body stopped functioning, which is the cause of death, but also things that could have contributed to it or helped to understand the circumstances around how that death occurred.
When you say the body, you mentioned the clothing. Why is the clothing important? Is that part of the body for a forensic medical examiner?
Oh, yes, it is. You always have to look at the clothing because it has materials on it that may be important as to how injuries occurred. So it's every time you do an autopsy, you have to always make sure you have the clothing. Many times it would have been taken off at the hospital, but then I would always ask my staff, tell the police, we've got to get the clothes, have to look at the clothes.
What is a gross examination?
A gross examination is not actually like grotesque, but it means like without microscopes. It means just looking with your naked eye.
Is it important to look at a body, a deceased person, when you're conducting an autopsy from head to toe for outside obvious wounds that you can see on the gross anatomy outside?
Oh, yes, and also to collect any trace evidence that may be present on the body.
Are forensic medical examiners trained to do that?
Oh, yes.
Are you trained to do that?
Absolutely.
In addition to a gross examination on the outside of the body, is it also important to look on the inside of the body?
Yes.
Are there wounds and injuries that might be hidden by the dermis, for instance, the skin, that might not be so obvious on a gross examination of a body?
Yes, you have to look inside the body.
And what's the mechanism of doing that?
Excuse me. We make surgical incisions in the body so we can examine the brain, the neck, all the organs in the chest, all the organs in the abdomen, and depending on the case, we may make incisions in the arms and legs to look for evidence of injuries.
What about x-rays? Are x-rays an important part of an examination in an autopsy?
Yes, they're usually done before the autopsy is started, and we look for changes in the bones or any foreign material that might be present in the body, like a bullet.
Dr. Laposata, have you ever exercised wound pattern recognition in your position as a forensic pathologist? Or do you do it every time?
Oh, all the time.
Have you ever taught any courses or given lectures on wound identification and wound pattern recognition?
Yes, it's part of understanding blunt force trauma, sharp force trauma, gunshot wounds. They all make injury patterns on the body that the pathologist can then relate to what caused that injury.
With regard to the case that's before us, what injuries did you observe with regard to Mr. O'Keefe's head specifically?
I observed that he had evidence of blunt force trauma to the back of his head.
Are those injuries consistent with a particular type or pattern of patterned injury?
Yes.
Describe that for us, please.
There in the back of his head, a little bit to the right-hand side, was a horizontal tearing of the scalp, and that's called a laceration. And surrounding that were linear scrapes that were vertical in orientation. So that is an injury pattern. And then you have to think, well, what could cause that injury pattern? And so then you go from there.
Did you also, in addition to looking at, by the way, how did you make that assessment about the injury? Was it photographs?
Yes.
Is that a normal way for a forensic pathologist to make an assessment? Is that an acceptable methodology to make an assessment of a wound pattern by the use of anatomical photographs?
Oh, absolutely.
Have you done it before?
Oh, hundreds of times.
What is a coup contra coup injury?
Oh, it's a very interesting, peculiar injury to the head. When you have a blow to the head, the blow can either be the stationary head and there's a blow to it, or you can have the head that's moving and gets the blow. So looking at a pattern of coup contra coup helps the forensic pathologist differentiate that. A coup contra coup injury examines the coup, which is where the impact occurred, and then we look at what's 180 degrees opposite that impact, and that's called the contra coup, or like opposite the coup. And that injury pattern helps us determine whether a person was just having a fixed head and somebody hit it, or whether the head was just standing and went down to the ground. The coup contra coup of a falling or being pushed backward has injury patterns where the impact occurred, but then there's also injury patterns 180 degrees opposite from that. And that happens because the brain is floating in cerebral spinal fluid, and when the head comes down, the brain is a little bit behind, so you get the bang on the back of the head, but then because the brain is floating, it hits the inside of the opposite side of the head. And so that makes the contra-coup pattern, and that tells us that there's been a fall backwards and hitting the head.
Is that consistent, a coup contra, just in general, a coup contra coup injury, consistent with a linear acceleration of the head by a fall, an unbroken fall straight back?
Correct. There's also some angular force in that as well.
Understood. In order to determine whether or not Mr. O'Keefe suffered from a coup contra coup injury, can that be done by a gross examination, or does it have to be surgical?
We would look at, well, first we look at the outside, but then we have to look at injuries to the scalp, and we look at the skull, see where the skull fractures are, and in particular to look at the brain and see where the damage is to the brain. And there's, in a fall backwards, you have damage to the brain at the site of impact, but you also have damage to the brain 180 degrees opposite from that. And that tells you it's a fall backwards.
In the case before us, dealing with John O'Keefe, were you able to look at the scalp and the injuries associated with the scalp from a gross perspective?
Yes.
Were you also able to look at the skull and possible fractures that Mr. O'Keefe suffered on his skull?
Yes.
And what about the brain? Did you have evidence of a dissection such that you could see the brain and determine whether or not there was a coup contra coup injury associated with the brain?
Yes, I had a full examination of the brain available.
Were Mr. O'Keefe's head injuries consistent with a coup contra coup injury?
Yes.
Could you describe that, specifically his head injuries, to the jurors, please?
Well, as we say, he has a pattern head injury on the back of his scalp, where there is a tearing of the scalp, and then vertically above that, there is some little areas of scraping to the skin. So that tells me that Mr. O'Keefe went backwards onto something that had a little ridge, but it also had some irregularity to it to cause the different scrapes before you get to the tearing of the scalp. Then when we look at the skull, he had massive skull fractures that started in the back of his head. They came around to the front. They went under the base of his brain, under the skull, under the base of the brain, and it came into the front of the skull at the orbital plates and fractured that, and that caused some bleeding in his upper eyelids. When the brain was examined inside the brain, I could see that the brain had become swollen and parts of it had herniated or moved down the area where the spinal cord is, and that's called brainstem herniation, and that is why the brain stops functioning and why your body stops functioning when you have a severe head injury.
You indicated that the wound pattern suggested a ridge or ledged surface.
Yes.
Could you explain that in more detail, please?
Yes. So if I were looking at it, I would see the break in the scalp. Then I would see several sort of irregularly placed scrapes of the skin that kind of look like pencil marks. And so that means that something with granularity he hit first, then it moved up a little, broke the scalp, and then moved on a little bit above that.
Would you expect to see that if Mr. O'Keefe had fallen backward onto a perfectly flat surface?
No, it has to be a surface that has some small ridges in it to make those little vertical patterns.
Dr. Laposata, what is ecchymosis?
Ecchymosis is a medical term for bruise.
Did you see any ecchymosis on Mr. O'Keefe that he suffered as a result of the coup contra coup injury to the back of his head?
He had a bruise on his brain at the back of the brain and at the front of the brain.
What would the outer let me rephrase that. What would you see around his eyes regarding ecchymosis?
Yes, when you have when the brain it slaps forcefully against the base of the skull, the delicate bones above the eye break, and that's again the coup contra coup, where the brain slaps forward. And when those delicate bones are broken, there's bleeding, and that bleeding then goes right down into the upper eyelids. So it kind of looks like you have black eyes, but there's not been any punch to the face. It's only come from the skull fracture. That's sometimes called raccoon eyes, because you look like a little raccoon.
Did you see any skin injury to either one of Mr. O'Keefe's upper eyelids?
Yes, he had a small kind of slit-like defect horizontal on his right upper eyelid.
Would the ecchymosis on its own produce that type of injury, that laceration over his right eye?
No, the blood seeping down into his upper eyelids was from the skull fractures.
Was the laceration above his eyelid on the right side a separate injury altogether?
Yes, it was.
Based on your training experience, do you have an opinion as to whether or not what that eyelid laceration might be consistent with?
Some application of force which broke the skin.
Could that be from an object?
Possible.
Could it be from a fist?
Possible.
Sustained us to the floor, Mr. Jackson.
Give me some possibilities of what might cause that laceration above his right eyelid.
So it's not possibilities.
Give me, in your opinion, what you believe could have caused or produced the injury to the upper right eyelid.
So I'm going to see you at sidebar here.
Doesn't get to go into the possible causes. We can't say what it possibly is, whether she can say, exactly what it is or not. Now, remember, the entirety of Judd Welcher's testimony was all based on possibilities, because we can't know anything, right? We can't know. We don't have enough data. It all depends. If he's loaded like this, if there's a minor movement, it can affect it. So we know nothing. So all we can deal with are possibilities when it comes to Judd Welcher. But now I guess it's going to be a problem to lay out what some of the options might be for how you'd get a cut on your eyelid. I guess unless she's prepared to say definitively, what you can't say to medical certainty, which is that the blunt object, what blunt object delivered the force, then she doesn't get to identify any possible things that could have caused that. This is just kind of par for the course today, isn't it? We got to get in the way of Dr. Laposata being able to say anything other than the stuff that agrees with the Commonwealth, the coup contra coup injury. She's totally qualified, right? Commonwealth has no problem with that. As long as she comes out and agrees with their conclusions, it's absolutely totally fine. But the ones where she has any area of difference, that's where we got a problem with her qualifications and her methodology. It's not going to matter because at this point the jury has already heard maybe a fist. Yes, they already understand. Application of force that broke the skin. It could be an object. That's all that they need to know. They don't need anything more specific.
May I inquire?
Yes.
Thank you. Dr. Laposata, you just mentioned that the laceration above the right eyelid was consistent with the application of force, correct?
Correct.
You said it could come from some object, is that right?
Correct. It was fairly small. It's some sort of object.
Is it also consistent with a fist?
Sure, a fist is an object.
Okay. Your Honor, at this point, I hate to do this again, may we approach? This is probably a good time. We talked about it at sidebar.
Can you do anything to fill up the jury's time for the next 10 minutes, and then we can do this?
Not
Oh, God.
What we discussed.
I'm adding that to the list.
come on up for a minute, okay? Both of you, come on up quickly.
Can you do anything to fill up the jury's time for the next 10 minutes? Okay. Hank killed a whole half a day because he didn't have any witnesses lined up. No, isn't there anything you can do, Mr. Brennan, to fill up the jury's time while we wait for the next half a day? No, we just came back completely, totally sunny. Guys, jury, guess what? We're ahead of track, so it's totally fine. You're just going to have an unexpected afternoon off.
I'm told that we're still on track. We will start. I'm going to have you show up a half hour later than we normally do because I expect to have 10 minutes with the lawyers, but we see sometimes with 10 minutes naturally in the course of any case can turn into. So I don't want you to be waiting as much as you've waited today. So if you take a half an hour more to get in here, whatever time we normally meet, the court officers will tell you. We'll see you tomorrow morning. Tomorrow will be a full day, and we will make every effort that it's filled with as much time here in court for you without sidebar conferences, without delays for us to have hearings. So tomorrow, plan on a full day. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Be careful again with your social media use, and we'll see you tomorrow. So Dr. Laposata,
Yes.
you can step right out, please follow the jury, and we'll see you tomorrow morning. If you will be here, make sure you're ready to go at 9.
I'll be here. Thank you, Your Honor.
So that wasn't a how long is this going to take you, but it was a comment on how long it's taking you. Can't you fill up these last 10 minutes? So I'm putting it on the list. I think it counts. We're up to 4, 3 of those today.
Maybe seated.
All right, so can you argue the Commonwealth's motion that I received this morning regarding Dr. Rentschler? Can we just do that now? Okay.
It doesn't matter anyway.
No, that's fine. So we'll do that first thing at 9 o'clock tomorrow morning. The basis of the Commonwealth's, I've read the motion. I think the motion is clear. I'll hear you both tomorrow on it. All right. And you'll take care of the photographs, whatever photographs in her report you intend to put in.
The court hasn't made a order yet, but it seemed like the court was leaning toward not allowing any text on the photographs.
So that was just at a quick review. I had not I just read the content, the text part for the arguments for today, the arguments that were brought up today. I wasn't anticipating everything that we heard today on this, so it took a while. I did not get to look at specifically those. But to the extent that it's hearsay, whether it considers anything about dogs, clearly the dog things that have been excluded have to come out of the photographs. All right.
The other photos deal with gastric mucosa.
I think those have been shown, and I know the Wisniewski spots one is in evidence. The brain photographs are not coming in. The brain photographs that are different than what's already, the brain photographs in her report.
Understood.
They're
the stomach lining is a bigger issue, and then some photographs dealing with blood is like the car is probably already in, things of that nature.
So tell me what you think is more of an issue, more of what you want. So I don't think the photographs on pages 4 or 5 they don't add anything, and they are extremely inflammatory.
I'm not looking to enter the I'm not looking to enter those.
All right, the photos on page 6, I believe, are already in evidence. So this is
that's a Lucas machine.
right, just a textbook photo of a Lucas machine.
Correct.
Is there an objection to that, Mr. Brennan?
No, thank you.
Okay. So do you want all of that in or just the photograph that's got color to it?
I'd actually like all of it in. She will explain what effect it has on the pancreas and stomach lining. It's in it to reduce the spots for lack of.
Okay.
Page 14, I think these are all in evidence otherwise, but I would like this particular, it's all in one spot.
Hold on 1 second. Okay, so 1 is in. Point number 1, that was in evidence, and those 2 photographs. This is all for number 1. What was?
These are all close-ups of the same photo that is already in evidence.
Okay.
The right sleeve. So I'd like to use this because it speaks to her evaluation of these particular.
All right. How does she know it's blood staining on the fabric around the puncture? I'm just curious.
The blood stain on fabric around the puncture?
Yes.
I'm assuming she's getting that from the lab. They tested it.
Okay. I don't recall testimony regarding. Doesn't mean it didn't happen. I just don't recall it. So I just need to know the source. All right.
Pull that out.
I have no objections to the photos. I do have an objection to the captions that go with the photos.
Okay. 13A and 13B?
Yes.
Yep, so 13B's out because of the dog bite. Let me see. All right. So if we keep out the blood staining, Mr. Brennan, is there an objection? Oh, puncture. What's the objection for the Commonwealth on 13A?
The opinion outward tearing, the opinion blood staining.
I have no issue with blood stain coming out. Outward tearing that is her opinion of what it looks like.
Okay, so we're going to have to see if she's qualified to do that, to testify to that.
Can she testify to
All right.
her?
What's the next page?
Page 53 in the report.
What page?
I don't have page number, Judge. Hold it up.
Page 5.
Page 5. It shows the cross-section of the brainstem.
Yeah, that's what I was saying. I didn't see how that was coming in.
I certainly don't want the one in that is installed. Highly graphic. This is no more graphic than the second one.
I disagree, but why does she have to use this photograph?
In furtherance of her determination of the coup contra coup injury, it supports that. I didn't put it in during that conversation.
Okay. There's no contention that coup contra coup is the cause of the brain injury, correct?
There is contention that the coup contra coup is. Yes, that is the contention. I don't think there's any controversy. Yeah, that's what the.
I thought that's what Dr. Wolfe testified to, no?
Consistent. I don't think there's any disagreement.
Right. So I don't know why we need this photograph.
Because this shows, at least for her, this shows a bleeding of the brainstem, which talks about whether or not he's immediately incapacitated or not immediately incapacitated.
Okay.
Issue.
No, I understand that's an issue. Okay.
It is an issue.
Yeah. Okay. What else, Mr. Jackson?
I think you've seen this, Your Honor, and I'm looking at this figure 5. So the news spots.
Yeah, I think that's already in evidence, isn't it?
It is, but not the. Mr. Alessi saying it's only a chop at this point, is that right?
I recall it was up, and I usually don't put up chalks, but okay. Excuse me?
Mr. Alessi. If you're not paying attention, Judge, we can just stop the argument.
There's only one person who can talk at a time. I'm told it's Exhibit 164.
Yes, Your Honor, my understanding is it marked as an exhibit only. It was used as chalk, but not in evidence.
Okay, so if it's marked as an exhibit, it means it's in evidence.
Sorry, marked for identification.
I'm told I think it's an exhibit. We can find out. If it's an exhibit, everybody's fine with it. It's in. 164, I think. We'll know. Okay. What are those? All right, so we'll have to see what's in and what's not. I'm just trying to make the best use of the time here.
The next is figure 9. Just attended to these 2 photographs. Attended to the Lucas machine.
So you're saying 9 in evidence or 9 on the form? 9A and B. Is there an objection to these, Mr. Brennan? Going to the Lucas compression device? There's one on someone who's not John O'Keefe, and then this is on Mr. O'Keefe.
No objection.
Okay, so those will come in.
That's it.
Okay. All right. How much longer, and I'm not curbing you in any way, how much longer do you think? It seems like after the very lengthy qualifications, we're now moving along quicker with Dr. Laposata.
I would guess I probably am going to finish under an hour.
Okay. Any idea, Mr. Brennan?
I guess it'll probably be about a half hour.
Okay. So we should finish with Dr. Laposata's testimony either by the morning break or shortly thereafter. So we'll discuss Dr. Rentschler's testimony, the objections to it. Why don't you just tell me briefly, Mr. Brennan, what the objections are?
There are a number of slides that attempt to frame what the contested issues are in the case. It's improper opinions, it assumes facts, not evidence, and it improperly summarizes the Commonwealth position. There are a number of slides that provide credibility determinations about Dr. Welcher, and there are a number of slides that summarize opinions by this expert. So the improper summaries, the credibility determinations, trying to frame issues to the jury, none of that should be admissible as part of the PowerPoint. So we've articulated each slide and what our objections are.
Or you could just cross on it about why you think it's unfair.
All right, so I'll look through that tonight, but the same restrictions will be you don't criticize the person, it's the data, what you saw, what you didn't see. So if it's different than that in the slides, it's going to have to come out.
Understood. I'll take a closer look at it. I just haven't had a chance.
Yeah, no, I understand. I haven't read it either.
If we're done.
Okay.
She just said she did read it.
Documents that are attended to Dr. Laposata's opinion.
She literally said at the beginning here she read it.
The dog bites.
Okay, so
I'd like to have those identified for the record.
yes. So we'll make that part of the record. I need a clean copy of Dr. Laposata's report and her resume for the same purpose.
And the resume.
Yes.
Yes. Okay. I'll have those 2 by now.
Okay.
Just finally, the redacted version of the 34 Fairview post is not marked. Could I have that marked as an exhibit now?
Okay. There was no objection, Mr. Brennan?
This was never marked as an exhibit. That's all.
Why don't we do that right now?
Okay.
Exhibit 224.
So I would like us to be as efficient for these jurors as possible tomorrow. I'm not suggesting that today was a waste of time. Everything we did was important, but it's very difficult for the jurors to spend so much time back there. It seems that they're just about ready to get this case, and everything that we hear now is very important. So I don't think anybody wants the jurors to tune out at this point. So let's try and keep things moving along. Mr. Jackson, how long do you expect to be with Dr. Rentschler?
Hour and a half. 2 hours. I'm being corrected. 3 hours. 4. She has a better pace than I do. I don't watch my watch run directly, but maybe it's going to be a whole thing. I mean, between us and cross-examination.
All right. So I told you all the other day I thought I might be in a position to regret giving you last Thursday off, and that's where we're at. So let's be as efficient as we can possibly be.
I promise you we are. It's a murder trial, right?
I understand. All right.
I have one more item when Your Honor is ready.
Okay. So, Mr. Jackson, do you expect that Dr. Rentschler will be the last witness that you call?
That's my expectation.
Okay. On rebuttal, any idea how long that will be, Mr. Brennan?
I'd like to keep it to 2 hours.
Okay. All right, that would be for everything, including Dr. Wrench,
Sorry.
Dr. Welcher?
Dr. Welcher, and then the DNA, all those 2 witnesses. I think it should be done in less than an hour.
All right, so will Dr. Welcher be called after the DNA people?
Trying to schedule that. I would expect to call him last, but it all depends on when we can get the DNA people. And Dr. Welcher will be here tomorrow or tonight, so he'll be here. So whoever's, if they're available, I'd like to get the DNA people in first. But we haven't had confirmation on the flight.
We knew she wanted evidence done
because
this
I told
week.
Mr. Alessi that he could excuse himself from this testimony if there were other witnesses first, so that he can prepare once he gets the discovery from Dr.
Still
Welcher.
doesn't have Welcher's discovery.
Thank you, Your Honor. Could we understand from the Commonwealth the names of the rebuttal witnesses we're talking about?
They were in the motion, right?
Well, we heard some different things at some. If something happened with Dr. Laposata, they were going to be different. We heard that at Sidebar.
Oh, okay, so the motion that I allowed was Ms. Kuhn. I believe Dr. Gillespie's name was in there.
Hartnett.
And Ms. Hartnett. Okay.
So that's the excessive scope of Dr. Welcher, or the scope of the rebuttal witnesses for the cop.
Yes, I allowed the motion. Mr. Brennan says he's not calling Dr. Gillespie. Mr. Gillespie, right?
Correct.
Okay.
And nor Dr. Crosby, as I understand.
Or Dr. Crosby. Right.
That's what
Yeah.
I think there's,
Sorry, I know.
well, it's important, you know.
You're not calling their dog expert or your own, correct?
Not calling Dr. Crosby.
Okay.
The other item, Your Honor, we want to alert you to, we will come tomorrow with a suggestion with regard to the period of instruction that was given to the court today. We're going to come tomorrow with an ask to be heard on that further. And so we're going to come in with that. What happened, what was discussed before, I'm not so sure.
You asked me to change it, was my recollection, Mr. Alessi.
We looked at it at lunch, Your Honor, and appreciate the opportunity to confer with you on it. Don't want to keep the staff later today. But
And I don't want to keep the jury waiting, so file something with me and I'll take a look at it. All right. All right, so that's it. We expect to be ready to go when the jury's here tomorrow morning, probably no later than 9:15, 9:20, right?
Oh, sure.
Yes.
Okay,
Sure.
and we'll use a full day, as much of it as we can.
Yes.
Yes?
Yes, Your Honor.
Okay, all right, thank you.
All rise to the court, please.
So now we're just plain old starting late tomorrow. No business to go over? No, right? Because we still got to deal with this Rentschler. This Rentschler motion. She's such a train wreck. She can't even remember. She can't even remember. Okay. As soon as she sends the jury out and she says, we'll do the Rentschler motion the first thing tomorrow. And she says, it's clear what is at issue. I've read it. And then not 10 minutes later, I haven't read it. I didn't read it either. You just said you read it. You just said you read it. Do you not even remember whether you read it or not? I understand you don't remember that you said you read it, which is bad enough because you just said that like within the last 10 minutes. But do you even remember if you read it or not? Because if you said you did, but now you didn't, good Lord. Oh. What did we get? What did we get after lunch? Oh, we got a ruling. The ruling was the same thing as she was already thinking this morning, meaning that voir dire, waste of time, didn't move the needle. 5 autopsies, 50s, don't matter. She's not qualified. Not just based on her experience, but the reliability of her methodology is in question. Her methodology is pattern recognition and differential diagnosis. Exactly the same methodologies that were identified as Dr. Russell. But Dr. Russell is an expert mainly because of her ER experience. Oh, really? Oh, really? If we go back and we look at your order on Daubert Lanigan pertaining to Dr. Russell, is that going to say it's mainly because of her ER experience that she's qualified? So if I'm understanding this correctly as well, no pathologist is going to be able to testify about whether an injury was a dog bite or not. We need to bring in an ER physician to testify to that in this courtroom. That seems to be the logic, such as it is. That seems to be the logic, because if this forensic pathologist isn't qualified, very hard to imagine one that is. Very hard to imagine one that is doing 50 autopsies of your own and supervising another 75 involving dog bites, being qualified as an expert on dog bite injuries in federal court. Those aren't good enough. Then I don't see how any forensic pathologist is ever going to be qualified to come into this court and say, these wounds, those were dog bites. We have to call an ER doc. It doesn't make any sense. It makes no sense. It's just becoming increasingly clear that the problem here is that there's no law and increasingly no logic that supports her desired outcome. So we're just kind of making it up on the fly. If you don't have the expertise to testify that something is a dog bite, then by extension, seems like you're not going to have expertise to testify that something is not a dog bite, to have that kind of an opinion. Schrodinger's dog bite in all of this. Likewise, exceeds the scope of her expertise to say that these injuries are not consistent with the motor vehicle collision. Never mind that she's seen thousands, at least hundreds. Motor vehicle pedestrian injuries. Not enough. She can say the pattern injuries on the right ham are not consistent with pieces of plastic, but she can't say tail light. I mean, just make it make sense. Is there some other pieces of plastic that are involved in this case that we should be concerned about? The pieces of plastic and the tail light, Bev, just in case you missed this over the last 7 weeks, they're the same thing. They're the same thing. See, there's no allegation of any plastic coming from anywhere else that would have caused those injuries. So I realize that details are not your strong suit, but kind of important point here, the plastic pieces and the taillight are the same thing. So by saying the pieces of plastic aren't consistent with the injuries, she's already saying it's not consistent with the taillight. But she's got to micromanage the words. There's no logic behind this. What's the logic behind it? They're the same thing. What's the logic behind, you can say not consistent with the plastic, but you can't say not consistent with the taillight? They're the same thing. There's no logic. But the desired outcome here is to make it harder and harder. There's no law that she can point to and rely on and say, well, that makes sense. So she's just stuck with her own brain work when it comes to thinking up, how do I justify this outcome? And the reason why it's looking increasingly illogical is because it is. Because, Bev, we've officially reached the point where your desired outcome is inconsistent with logic. So that's why you sound illogical and ridiculous making these rulings, because they are. Sometimes the simplest explanation is, in fact, the right one. The reason why you sound like you don't make any sense is because you don't. The reason why you can't articulate a standard is because there isn't one. You don't have a standard, you don't have a principle, you don't have a rule, you have nothing except you want it to be hard for Karen Reed to defend herself. That's it. And you're not going to find a citation to that in any of your case law that supports what you're doing here. Not going to find that in the case law. Then we observe that we've wasted an awful lot of the jurors' time today. No kidding. No kidding. Who did that? Who did that? I very much appreciate the defense bringing out the point and making the record. Commonwealth waited till June 5th to file this motion. They were supposed to file their discovery, their motions in limine by March. Sorry, June 5th. They filed it. Supposed to file their motions in limine by March the 7th, and they didn't do that. And it's not based on anything new, anything they didn't already have. No explanation for the delay. Hank just says, I'm allowed to do that. And in Bev's courtroom, she is, because rules aren't rules. Deadlines aren't deadlines. They don't matter when you're applying them to the Commonwealth. They only matter when they promote the desired outcome of making it harder for Karen Reed to defend herself. That's the only time deadlines matter. And the wasting of the jury's time today, it's not because the Commonwealth sat on their hands and played the sandbagging game where they blow past the deadline to challenge the testimony and file it 3 months late and get entertained by the judge notwithstanding that. That's not why we delayed. It's because the defense wanted to put on a case. That's the problem. They didn't just roll over. We had to have this whole voir dire that clearly in retrospect didn't matter at all because 5 autopsies, 50 autopsies, no difference. She's not qualified, doesn't have the experience to recognize a dog bite. You can tell just by looking at the jury that they're fed up. I fucking hope so. That would be about the best news that we've heard all day. The jury is all of us right now. Yeah, we're all pretty fed up with this. Jurors, you've been extraordinarily patient with us today. Extraordinarily patient with us today. It's not your fault. Just because we're in the defense case now, you should expect a lot of your time is going to be wasted. We'll need to have all of these sidebars because the defense is calling witnesses, you see, and we just can't have that. We can't have defense witnesses saying things that would be detrimental to the Commonwealth's position, jurors. So we're sorry that's such a waste of your time. We finished with John Tedeman. I never did quite catch how we pronounce his name. The substitute investigator. Not a whole lot to establish, just that we did get to see the photo, and apparently seeing the garage doors was just so prejudicial that can't be allowed. That has to be redacted from the photo. So prejudicial to see those garage doors. They have to be cut. Like the Commonwealth hasn't already put in a picture of this house with the garage doors in it. But no, no, no. Part of why the juror has had to be extraordinarily patient today is because we can't let them see the garage doors on the defense photo, you see. Is there a logic to it? Well, there is a certain logic if your objective is to simply make it harder for the defense to defend, then of course there's a logic because we're going to nitpick everything. But is there a big picture logic in the sense of, I don't know, the jury already frickin' knows that there's garage doors right there and the Commonwealth put that photo into evidence themselves? No, I can't say there is. What, it's suddenly more prejudicial than probative to have a second photo of the garage doors put into evidence? It's ridiculous. Can't possibly hear that there is a concrete floor in that garage. Objected to, sustained. So what we established is that the direction from the street to the house is westerly, and from the front door to the garage is north. The garage is north of the rest of the house. All of the different measurements to the different doors, all coming from the mailbox, 65 feet 9 inches, 70 foot 1 inch, and 78 feet 3 inches over to the side door. And this is following, you know, specifically on the path, not like cutting part of the path, not going through the yard, anything like that. Cross-examination, yes, it would be the same amount of time back to the car. Oh, suddenly there's not an issue with facts not being in evidence. There's no evidence he ever went in the house. There's also no evidence he ever went back to the car, Hank. Also no evidence he ever went back to the car. But yes, if he had, that would double the distance to go there and to go back. Then if you take all the measurements from the flagpole, all we know is that it's over 80 feet. The flagpole's over 80 feet. But there's no witness that says Karen was up by the flagpole when John got out of the car. To the contrary, the witnesses who were present, Heather Maxon, Ryan Nagel, say it was more like in front of the front door. So closer to the mailbox, and then he was, they came in and parked behind the driveway. So Elizabeth Laposata, then, we heard tons and tons and tons and tons about her qualifications, most of which are not going to matter because she's not actually qualified, you see. It took like 45 minutes to get through all of her qualifications. But she's not, in fact, qualified. So looked at the different things in this particular case, what's important to look at, the different findings, the difference between the manner of death and the cause of death. A lot of this stuff is familiar now. You use wound pattern recognition all the time. That's part of how you're taught as a medical examiner to recognize things like blunt force injury, sharp force injury, gunshots. They have specific patterns to them that you learn to identify. So in John's case, there's evidence of the blunt force trauma to the back of the head. It has a pattern with the laceration and the linear scrapes that are kind of vertical are above it. The contra coup injury, she agrees with that, based on the skull fracture, the ecchymosis, etc. But the wound pattern, she says, suggested a raised or a ridged surface, and that's because of the pattern of the abrasion. If it just fell back onto a flat surface, you would not expect to see those irregular scrapes. The raccoon eyes themselves came from the skull fracture, not from a punch. But the laceration on his eyelid is a separate injury. It was produced by the application of force that broke the skin. It could be an object. It could be a fist. Bev tells us in front of the jury yet again, we're not talking about possibilities here. So we go to sidebar and then we come back. And guess what? We're going to go ahead and revisit whether they're consistent because that's okay. Yes, it's consistent with being hit by a fist on your eyelid. So at this point, we're 10 minutes from the end of court, but we're done with Laposata because we're not going to be able to get anything into anything consistent, and you've cut off at the knees what she's able to testify to anyway. So then again, in front of the jury, can you do anything to fill up the jurors' time for the next 10 minutes? Really? Should we just sit here and shoot the shit with the doctor about what's your favorite Great White song? Does anybody even know a Great White song off the top of their head? Yeah, everybody knows the one freaking song. One song was on repeat like way too much in, I don't know, 92, 93, maybe thereabouts, maybe earlier. Awful song. Now it's going to be my earworm for the rest of the day. Yep, once bitten, twice shy. Ugh. Blech. Should we chat about whether anybody has ever heard of another Great White song? We're not going to speak ill of the dead. We are just going to question who goes to a Great White concert anyway. Was there nothing else going on that night? My understanding, by the way, from what I remember of that, they have a pyrotechnics show as part of their show. And if I remember right, there were a bunch of violations of the fire code vis-a-vis exits, exits being marked, potentially exits being accessible is kind of how I remember it. So just basically too many people on the premises for the number of exits they had. Anyway, the pyrotechnics show went bad. The place lit on fire very, very quickly. And a lot of people were killed as a result of that. No, nothing we can do for the next 10 minutes, Judge. So instead, I'm told we're still on track. So suddenly, for weeks we've been assuring the juries, I assure you we're ahead of time. But now suddenly she's told. Now suddenly she's told we're ahead of time. Now we got to emphasize it's coming from the parties and not from her. She's just the mouthpiece. Now that we're in the defense case, she's not accountable for how the time is being spent, whether it is on track or not. Now she's just passing on what she's told. So the jury is going to come in a half an hour late tomorrow, but we're going to do our full day. And guys, we're going to do our best not to have sidebars tomorrow. We're going to do our best. And guess what? I got a pretty good idea whose fault it's going to be if we do. Because I have a pretty good idea who's going to be getting sustained and overruled when they shouldn't be. And so who's going to be requesting the sidebar? I got a pretty good idea how that's going to go, just based on the 7-week pattern that we can all recognize, having sat here and watched this unfold again and again and again. I got a pretty good idea that we're going to have some sidebars tomorrow. And I got a pretty good idea who's going to be requesting them. We're going to try not to have them. These comments in front of the jury. Not prudent. Not prudent. So tomorrow morning, we're going to come back in. We're going to do the Rentschler motion first thing because she's read it, but she hasn't. But she has. So we'll do it first thing tomorrow. A lot of talk about Laposata's photos. What can come in, what can't come in. If Brennan doesn't want it in, it won't come in. So photos of the brain, can't add those. It's inflammatory. Apparently has to do with whether he was immediately incapacitated or not, but not entirely clear. They're making their argument. Bev turns and has a chat with the clerk about stuff while they're arguing, and then admonishes the defense because only one person can talk at the same time while you're talking to your freaking clerk. They know only one person can talk at the same time. They were talking, you weren't listening. And that was a major, major, major problem when Mr. Alessi did that just a couple hours ago. Or Mr. Jackson did that just a couple hours ago. Major problem for you. And it took no time at all for you to turn that around. And yet, once again, it's the defense's problem that you turned away from their argument and ignored it to have a little chit chat with your clerk so that you can get then chastised about how only one person can talk at the same time. Some details about what's coming. Expecting under an hour for Laposata. Yeah, because they have nothing that they're really going to be able to ask her about. Half an hour for Hank. What do they have left? They're going to have left no hypothermia. And I mean, what else? No hypothermia. Oh, immediately incapacitated. I guess we'll probably get that. Immediately incapacitated, no hypothermia. If that's all she gets to say, then yeah, that probably will take very little time. Half an hour for Hank is all he'll need to, belittle her. Ask her if she's got, some health problems that affect her memory or thinking or anything like that. Because, guys, we only get to criticize the person when we're the Commonwealth. Then we get to raise issues about, did Dr. Wolfe, did your wife make some FKR friends over there on social media? Just the data. That was the standard that was set by that cross-examination of Dr. Wolfe about his wife. So the general outline of the objection to Rentschler, guys, we can look at the motion and we will once I wrap up here because it's like 2 pages. How long is it going to take you to read that, Bev? Did you read it or not read it? Oh, she wants us to be efficient for the jurors tomorrow. Yeah, now that we're in the defense case, we need to be efficient. I said I'd regret giving you last Thursday off. Isn't that rich? We all know who needed Thursday off was Bev. We all know Bev doesn't have the stamina to do an entire full week. And that's why she's so irritated about her anticipated schedule being off. She is going to be done this week, period. She is getting the case to the jury this week. She doesn't care who she has to cut off. She doesn't care who gets shorted on their ability to present stuff. That's what she wants. And so that's why she's annoyed and irritated. She's probably sitting there hoping to herself, wondering, can we get another day off too? Still get the case to the jury this week? Oh, I guess not. But then we did get the confirmation Rentschler is going to be the last witness. So that's it. Laposata, then Rentschler, and the defense is done. Don't know what I think about that. And then Brennan is going to call Terry Kuhn and Welcher. Should take a few hours. Oh, by the way, Alessi, he still doesn't have the discovery from Welcher. Welcher is going to be on the stand in maybe a couple days and still hasn't produced what he's going to say, what his rebuttal is of ARCA. But it's okay because she's going to, give Mr. Alessi a break from the courtroom to be able to prepare for that. That seems reasonable, doesn't it? That an attorney should get like maybe 2 hours in the morning to review an expert rebuttal on accident reconstruction and biomechanical engineering and be prepared for a full and vigorous cross-examination that you're entitled to. Just step outside the courtroom. It'll be fine. It'll be fine. You know, the thing about this, and the point that it's reached is it really just has gotten undeniable. I mean, that is kind of the one upside about where we're at in this case, is that the double standard, it's become undeniable. It's become undeniable. When the Commonwealth is annoyed because they've had a month with the ARCA report, that's so egregious that we get to, bend the rules, make some special rules to call in a rebuttal witness that we don't normally allow. Okay, Dr. Wolfe just finished today. Just finished. A month. They've had a month. A month with the case, and Rentschler hasn't even testified yet. They've had a month with it. And yet that was such a problem with the lack of notice that we're going to bend the rules. Let the Commonwealth call rebuttal. How much notice is the defense going to get? Maybe a couple hours. Maybe a couple hours. That's totally fine. He's a smart guy, that Mr. Alessi. The double standard has become undeniable. There's simply no way to look at this case and conclude that the same standards are being applied. We have to have yet another limited voir dire, I guess, of Laposata. Depends on her qualifications to be able to talk about holes in the clothes. Might have to have a whole voir dire about her qualification to opine about holes in the clothes. Meanwhile, Crosby, the non-doctor, doesn't even need a Daubert hearing. The forensic pathologist with 50 autopsies of dog bite wounds, not qualified. Ex-cop with 0 autopsies of dog bite wounds, qualified. Qualified facially without even the need for a voir dire. If that double standard doesn't smack you in the face, then you're just not willing to see it. You'll just make any excuse, rather like Bev is doing, to justify the outcome you want. We've reached the point where I don't see any chance. I really don't. Even with the pessimism that I have about the appeal process, how limited it is, how disinclined appellate courts are to reverse convictions. Even, in Massachusetts, the research I did into Bev's prior rulings and how she gets reversed and so forth, and they do not appear to be a particularly defense-friendly jurisdiction in Massachusetts. Taking all that into account, I don't see a way that even if they manage to convict her, that it survives an appeal. I don't see it. The restrictions have gone way too far, and they're not based on sound reasons. If you don't have consistent logic for who is qualified and who is not and why, then it's not just you exercising your discretion to admit or deny certain things. It is, in fact, you being arbitrary. And when you are arbitrary, just deciding things ad hoc without applying consistent standards to both sides, that is an abuse of discretion. It just, it's unfortunate, but I just don't see how, even if they, this whole, you want to respect the jury's time, Bev, then why don't you run a trial that's clean, that has a chance of surviving any kind of review? That would be probably the best way to not waste the jurors' time, is to make sure that whatever outcome they reach is going to stick. But you can't do that. She's so determined to get the outcome she wants. Even if it comes at the cost of getting reversed. Hey, you know what? They got their pound of flesh in the meantime. Welcome to criminal justice, folks. Welcome to criminal justice. See people wanting to know all the time, how can this be allowed? Isn't there a way to stop it? Can't somebody do something about her? Welcome to criminal justice, guys. The remedy is to appeal. And the pound of flesh that you lose, all of the money you had to spend, the time that you lose, you might have to sit in jail while that's going on. For no good reason, because the outcome isn't going to stick. But it's okay. They got their pound of flesh. Welcome to criminal justice, guys. Hate to be that jaded, but that's the system. That's the system. And is anything going to happen to her? Any consequences to her? Not a single one. Not a single one. Nothing. Nope. She could get reversed five ways from Sunday. All kinds of different reasons. She could get reversed on multiple grounds. Nothing will happen. Nothing. Welcome to criminal justice. Let's take a look real quick at that Commonwealth motion here, the one that they'll be taking up first thing tomorrow. Let me get it shared. All right, here we go. Can you guys see that? Okay, it's kind of small, huh? If I make myself smaller, it's a little bit better. Motion to exclude opinions of defense expert Andrew Rentschler. On Thursday evening, June 5th, 2025, the defense sent the Commonwealth a PowerPoint presentation comprising 86 slides that Dr. Rentschler apparently intends to use during his testimony. Upon reviewing this presentation, the Commonwealth discovered several slides that contain diagrams, measurements, and further analysis concerning the injuries to Mr. O'Keefe's arm and the defects in his clothing that were not previously disclosed to the Commonwealth. Okay, we're gonna pause right here, because Andrew Rentschler did not have access to John or John's body, so measurements would have come from the discovery. So it would have been in the possession of the Commonwealth. Nevertheless, in addition, Dr. Rentschler now offers a new opinion comparing those injuries and defects, which is not discussed in his May 7th, 2025 report. Oh, you want to be more specific? No, of course he doesn't. Doesn't want us in the record exactly what Rentschler thinks about the injuries and the holes. Pursuant to the court's prior orders, this information should have been produced to the Commonwealth no later than May 7th, 2025, which was the deadline for ARCA to turn over its reports and related data materials. Here we go. Here we go. This is the gift that just keeps on giving, that she gave him from nowhere, right? Nowhere. In light of the multiple deliberate Rule 14 violations already committed by the defense in connection with ARCA, they should not be permitted to use this information at trial. Remember, when we go back, we came up with, at best, there's a duty of candor problem, because they didn't correct that issue about not paying ARCA. They paid him for appearing to testify after the fact, but didn't pay him for any of their initial research. Somehow that's turned into multiple deliberate Rule 14 violations, and now Hank is going to wave that flag every single opportunity that he gets. The specific slides at issue are 12 through 33. The Commonwealth requests that these slides be removed from the presentation and that Dr. Rentschler not be permitted to testify to what is allegedly shown or demonstrated in those slides. Then he should also be precluded from expressing the opinion or conclusions that are listed on pages 6 to 8 in his report that are numbered. And here, I guess, is the basis. It's kind of weird how it, did we miss a page? It looks like we missed a page because it's going from the very first page to page 3. So I think we missed a page in the middle of this one. If we get it tomorrow before court starts, we'll go ahead and take a look at the rest of this. But this just basically looks like, this is a listing of general evidentiary objections to the content of the slides. Again, just continues to be deeply, deeply ironic. Comment on credibility. The horror. So that will be taken up first thing tomorrow. If by then Bev can remember whether she has actually read it or not. So, yeah, getting closer and closer and closer to the defense case. And remember how Brennan, his behavior, his treatment of the witnesses, berating them, insulting them, being rude to them, displaying no decorum that you would normally require in the courtroom. Any sensible judge would require in the courtroom. Remember how we talked about all of these things? Their incentives is what they are. They are, it's attrition. It's there to punish the defense for calling witnesses. Hey, if you didn't call witnesses, I wouldn't have to get up and abuse them like this. Be a shame if I had to abuse any more defense witnesses unfairly, wouldn't it? That's the purpose of it. This is attrition. You might be able to look at Bev's ruling in the same way. You just might. Defense, you keep calling these experts, keep calling these witnesses, and I'm going to keep having to find ways they're not qualified. So you can keep trying, but I'm going to go ahead and cut your case off at the knees the day that your witness is showing up to testify. Might be able to look at that the same way. Ask ourselves, is this an incentive that's being communicated? Maybe if you didn't call these witnesses, wouldn't have to make these findings, wouldn't have to revisit the multiple, repeated, willful violations of Rule 14 that kind of materialized out of nowhere. Might be. Might be. Let's see what you guys think. What's been, I guess I see Sleuthy, our good girl Sleuthy, also has the motion with the missing page. So let me go ahead and pull that up and we can take a look at that. Page 2. Here it is. Okay, can we see this? Okay, it is pretty small once again. There, it's a little bit bigger. I can make it slightly bigger. There we go. How's that? That looks okay. Let me be small again. All right. So we already read this page, the first page. Limit him from being able to state these conclusions. They are his commentary on the reliability or credibility of Dr. Welcher's analysis. Such commentary is improper and should not be elicited, really, because reliability and credibility of the analysis is precisely what's at issue in the case. Nobody gets to say, Dr. Welcher is a dumbass, no matter how obvious that is to everybody. You don't get to go in and impeach the Commonwealth. Your witness is a dumbass. But you do get to say your witness's methodology is retarded. You do. That's the whole point. That's the whole point. So yeah, he does get to comment on the reliability or the credibility of the analysis. If it's the project, if it's the product of bullshit, they get to elicit that. But not apparently in this courtroom. We don't get to say, this isn't even science. Finally, a number of the slides in the presentation contain improper and inadmissible statements. These slides and the bases for the Commonwealth's objections are summarized below. So yeah, these are just going to be these basic, general objections. He doesn't like the wording of the slides. He wants to word it hearsay, 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 hearsay. Now, once again, remember, what all did Dr. Welcher rely on? How much hearsay did Dr. Welcher rely on in presenting his presentation? That would be somewhere. Let's not argue about units. I think we can settle on a fuck ton as being pretty much in the universe of how much hearsay was the basis for Dr. Welcher's opinions. All of the vehicle data, etc., the reports, witness statements, DNA on the taillight, all of that hearsay. It's all hearsay. That's why we've spent like 2 weeks going back and repeatedly looking at Rule 703 and trying to make sense out of how on earth is that being applied here. The way that the rule is written is that the expert isn't supposed to be able to rely on that at all. If it's not otherwise admissible hearsay. But yet they did. But then when we go to ask them about it, that's not allowed. Hearsay, 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 assumes facts not in evidence. Credibility. Bolstering. Don't even know what that means in this context. Bolstering. He's saying somebody else is right. Based on his analysis, another person is right. Hank doesn't think he should be allowed to say that. Improper opinion and commentary on ultimate issue. That one's ironic too. I don't even know specifically what it is, but I guarantee you Dr. Rentschler has not put on his slide, Karen Reed is not guilty of murder in the second degree. Karen Reed is not guilty of voluntary manslaughter. That's the ultimate issue. Like he just argued like a week ago. The fact of the collision, not an ultimate issue. When they were arguing about it like a week ago. And Bev even agreed back then. Remember? It's not an ultimate issue. Not an ultimate issue problem, she said. We'll see if it's an ultimate issue problem tomorrow, won't we? Because she probably doesn't remember. Probably doesn't remember having that argument and having that reasoning. So that's it for the motion, and we'll be dealing with that tomorrow. All right, guys. Let's talk through it. Let's see how you guys have been dealing with today. The rural juror, part 1 of 2. How directly can the defense say in closing that they don't have the burden to prove anything? They can say it exactly that directly if they want. It will be in the instructions, and a real common way to do that is to just reread that part of the instructions to the jury. Defense has no burden whatsoever to present anything. You can draw no inference from anything that the defense does not present. No burden. Entire burden rests exclusively on the Commonwealth. They can say that extremely explicitly. The rural juror, part 2 of 2. The Commonwealth would have you believe that we haven't proven it didn't happen. Don't let them fool you. They are the ones who have to prove it did happen, and it happened how they say it happened. Something along those lines. Yep. Very appropriate. Very appropriate. Remember, too, they're going to be in the responsive position. The Commonwealth is going first. So the Commonwealth is going to make their argument first. Anything in that argument whatsoever hints at defense hasn't proven anything, number one, you're going to be getting an objection and probably another motion for a mistrial because misconduct is becoming cumulative. So just go ahead and make your record every time it happens. Hank knows perfectly well, don't get to burden shift in closing. Does that mean he won't do it? Of course not. Of course not. So they'll have the opportunity to see what he says and exactly how the Commonwealth pitches this idea that the defense has a burden to convince the jury of something. And something very much along these lines, yes, absolutely in bounds to frame that correctly in terms of who has the burden and what the burden is. It's on the Commonwealth, no question. And I think this is insightful in that, yeah, that's a good approach to the case. The focus on the reasonable doubt. Who is the one that has the burden of proving what happened? The Commonwealth. But who got their expert up here to say, we'll never know? Also the Commonwealth. That's a problem. Those things are not consistent. Coffee Cake. Does Dr. Andrew Rentschler look like Troy Aikman? He does look a little bit like Troy Aikman. Yeah, he does look a little bit like Troy Aikman. I think you're right about that. The Marilyn Manson cases. I'm wondering if they simplified the defense based on what they learned from the new attorney that was on the jury. It's a good question. We haven't seen Victoria George since the very, very beginning when she was in the courtroom for jury selection. We haven't heard anything about her since. Really don't know what her role or contribution is. To the extent that she's only been present for the jury selection, it definitely suggests that her role on the defense team has to do with the jury. And so choosing the right jury, certainly a part of that, but could very well be that she's in a little bit of the role of the consultant. She's like a one-woman focus group about how's the jury going to react to this type of thing. So it's possible. Now, had she been involved in deliberations, it would be a lot more useful because she would know what the jury made of any of this. But if the jury followed the instructions not to discuss the case until they got into deliberations because she wasn't chosen for the jury, she was an alternate. Not clear that she would necessarily know, other than her own reaction to what she saw. She's not necessarily going to know what kind of reaction the other jurors had. But it's definitely possible. And it does make some sense that that's the value that she brings is having that insight. AK, could they wait for Bev's ruling on the missing witness instructions, and if denied, they call them? Not really. I mean, so number one, it seems like Bev has already ruled on this from the bench, and we don't know what it is. I mean, she said all these motions have been resolved. We don't know how this one has been resolved. No idea why this would need to be addressed at sidebar and not in open court. Other than, we got to also make it difficult for the public to know what the basis of anything going on is. But as we've seen today, she's kind of putting them on the spot in terms of who their witnesses are going to be. And they're not going to call Higgins, not going to call Proctor, not going to call Albert. They probably already have the ruling on that. But even if they didn't, I mean, they could ask. They could ask if she's ruled on it. And yeah, they can always say we're making our final decisions as we get guidance from the court on what's allowed and what's not allowed. That's generally fine. It just doesn't seem like that's what they are actually doing in this case. Brussels sprout. Why does Commonwealth get the last word for closings? Isn't the point of defense to defend against what the Commonwealth says? It doesn't make sense to me. Yeah, this is a good point. If you're supposed to defend against what the Commonwealth says, then you don't get to defend against the last thing that they say. So why do they get the last word? They get the last word because they have the burden of proof, and that's just the convention. That's it. Traditionally, that's how it's done. Because they have the burden of proof, they get the last word. So that's why they're doing it here. Sabina D, question, not being able to bring up relevant evidence, doesn't that inflict of her right to a fair trial? Yes, indeed it does. Very much so. Because the bar for evidence to be relevant is very low, and the rules are very clear. If it's relevant and its probative value is not substantially outweighed by the potential of prejudice, then it is admissible. It can be put into evidence by either party. And so if you, the defense, are precluded from being able to present evidence that is relevant and not unduly prejudicial, yeah, that's the definition of depriving you of your right to present a defense. That's the definition of it. And so that's why the justification for keeping it out can be so critically important. Very relevant to present evidence on investigative standards and so forth. What's the unfair prejudice? Not helpful to the jury. All common sense stuff, according to Bev. All common sense stuff. I would bet that most average lay people wouldn't be able to give you a working definition of probable cause. Just for example, is one of the issues that's kind of been in dispute here. Ability to get a search warrant to go inside 34 Fairview. Many people wouldn't even know that the standard is probable cause. But knowing that it's probable cause, lay people going to be able to give us a working definition of probable cause? See, it's a little bit of a trick question because professional probable cause student here, having had to brief this many cases, even courts have a real hard time articulating exactly what the probable cause standard is. There's lots of cases out there with a bunch of language in it about how hard it is to say exactly what probable cause is. And why is it hard? Why is it hard? Well, I'll tell you guys, welcome to the criminal justice system. The reason it's hard is because it's hard to come up with a standard that you can apply to every situation that allows you to get the outcome you want. See, if you apply, if you go and you adopt a real firm, bright line rule that applies to every circumstance before the court, then that means you're going to have to hold the police to that standard. And then what do you do when you don't want to? So that's why it's hard. That's why it's very hard to define probable cause. See, because you want it to be strict when you need it to be strict, but you want it to be lenient when you need it to be lenient. So you got all kinds of articulations of what the probable cause standard is in the highest courts of this country. But, you know, within the realm of knowledge of the average layperson, according to Bev. Yeah, that is the textbook example of depriving her of a right to a fair trial. The rural juror, it bothers me that Hank Brennan is allowed to misstate the evidence about taillight pieces in the arm of the shirt. It was clear that she didn't know where each piece came from on the shirt, just the shirt in general, just the shirts. And not only that, she acknowledged debris in the bag. In the bag. So all she knows is that they were in her scrapings from the shirt. But how they got there? How they got there, very much still in question. So that's what I'm going to expect the defense to rely on in their closing. Just go back to the improper chain of custody and the provenance and what's in the evidence about these tiny little pieces of what you're saying are taillight fragments. Yeah, there might have been debris in the bag, she said. Maybe emphasize that when they call her in for redirect. Or rebuttal, I mean. A. Willie, 35, is in a Bowden defense. Who is allowed to talk about the investigation? Can't call Easter. No one else is allowed to opine. Vince Vaughn is Yanetti. Vince Vaughn is a good pick. I saw somebody else come up with that pick, I think last night. That is a good one. I do like it. It's not really about the Bowden defense. It's just much more about this court and who is this court going to qualify to say anything at all on behalf of the defense. We have Michael Easter isn't qualified. We have Laposata isn't qualified. We have Dr. Russell is only barely qualified. That's what the issue is. On a Bowden defense, any relevant evidence that's not unduly, unfairly prejudicial, more prejudicial than probative, they get to present, but not apparently in this court. Apparently in this court, you don't actually get to present evidence. You only get to cross-examine the police officers who have every incentive to deny what you're asking and just harp on what a great job that they did. But there's definitely nothing in the case law that says Bowden is only established through cross-examination. So that one, you know, potentially really big error. I just don't love the record that they have of it so far. Now, again, I have to assume there is more in the record than we have been able to see. With the stuff that they did actually bother to raise and litigate pre-trial, typically have like exhibits and attachments and things like that. And that's my big concern here, is establishing what would Mr. Easter have said? Because we haven't heard that real specifically in the arguments. We didn't see it real specifically in the defense briefing. We just saw these generalities. He would testify about proper law enforcement procedures. Okay, but specifically, what is that? And apply it to this case. What procedure? How was it violated? Give me details, because that's what I'm going to need. Appellate attorney taking this issue up to the Court of Appeals to say, you know, this was an incorrect ruling. I don't think that part is going to be hard to establish at all. Very easy, I think, to establish that this is an improper ruling. The issue is going to be, what was the effect of it? And that's where we need a really good offer of proof from Michael Easter about what exactly were you going to say. So I'm taking it a little bit on faith that that's in some of the pretrial briefing, because we haven't heard it in the arguments and you know, the motion for reconsideration. We do not have the kind of record that I as an appellate attorney would need to be able to go and show the court. Would have been a different outcome, because here's what the jury would have heard. Here's how it would have affected their consideration. Robin Lane, has anyone asked where all the blood from John's head wound went? No. No. Surely if the ground was frozen enough to cause the injury, the blood would have spread out and not absorbed right away. Correct. Frozen ground doesn't absorb liquid. So which way do we have it? If the ground is not frozen, then I think we have the possibility of, you know, the blood just seeped into the ground. Still a little bit hard for me to believe. There wouldn't be any indication of that, like when they went through and did the leaf blowing and so forth. There wouldn't be an indication of a you know, puddle of blood and mud on the ground. Hard for me to believe. But if that's the situation, the blood is gone, it seeped away. The ground isn't hard enough to, you know, cause this head injury. So take it the other way around if that's what you want. The ground is so hard it could cause his head injury because it's frozen. Lot of qualifications on that, of course. Are you talking about grass? Said Dr. Wolfe. Are you talking about frozen grass? Yeah, he was. He was. I know. Ridiculous, but let's just roll with it. He is talking about frozen grass. If it's frozen enough for it to be solid, it is not absorbing liquid. So where is all the blood? I've had this question since the first trial. Where's all the blood? Nobody's asking. Maybe that's because there is an answer to it that we simply don't know. Maybe it doesn't matter for some reason. I don't know. But it's definitely a question that I have. Marivi Sands. Didn't a witness, a McCabe perhaps, say in the first trial that Colin was not in the house when John was there? Did I misunderstand that? No, you did not. I think multiple witnesses said that Colin had already left before John got there, that Colin was leaving just as Brian and Nicole Albert were arriving into the house. He said basically hi to them and then left. And so they got to the house before everybody else did. Don't recall if the McCabes were already there, but basically they set it up in the first trial where he was heading out the door as those first people were already arriving. So the implication was, well, there wouldn't have been overlap. There wouldn't have been overlap with John. Of course, the timelines all shifted around so much, that it's hard to keep track of any of it, what the timelines were. But did he say he was home by 12:20? I remember it being like, that's strangely specific. He had a very strangely specific time. So no, you're correct in your memory. They all said that Colin had already left by the time the SUV got there. Ellie Dimitrova, can the defense keep asking for justifications on her motion rulings? It's ridiculous. She may not entertain them, but it'll be on the record she refuses. Yeah, they can. They can, and she'll be snotty about it. I've given you my reasons, Mr. Jackson. You haven't explained them. Haven't explained what any of this means. You haven't explained what would be. Is there a forensic pathologist anywhere in the country that would be qualified to opine on an injury being a dog bite under this standard? If so, how? What's the magical number of autopsies of dog bites you have to perform, and how do you reach that? And what methodology besides differential diagnosis and pattern recognition would need to be applied to be reliable? Yeah, they could. They could. Kyle Wells, I found the pictures of Rescue Randy's mangled body to be unnecessary, gratuitous, and more prejudicial than probative. That man, Nikin, had a family. Did he? Did he now? I don't know. I feel like that Rescue Randy, bit of a lone wolf, a desperado even. Out on his own, walking those fences. Did he have a family? That would shake. That would very much shake my vision. Rescue Randy, the desperado. Gary Bernat, Andrea, do you think Bev's rulings have been her way of leveling the playing field for the Commonwealth, as case law and her grave concerns were not enough to sanction ARCA? It's beyond leveling the playing field at this point. It's straight up impeding the defense. It's just straight up preventing them from being able to defend while you're letting the Commonwealth, you're holding the door open for the Commonwealth to put junk science on the stand and unsubstantiated, unscientific opinions on the stand. Perfectly prepared for Crosby to get up there and testify about, dog odontology. Oh, no, wait. She did actually limit that. Can't say it's Chloe. But no problem with him testifying about what's a dog bite and what's not a dog bite. Not being a medical guy. Complete reversal from the first trial with no explanation for why we're suddenly changing the standard and why the medical people are suddenly the only ones not qualified to testify about whether it's a dog bite or not. So it's much more than leveling the playing field. It really is impeding the defense. It's not letting them defend. And yeah, it's because the Commonwealth needs that. They need that interference if they're going to have any chance of getting anywhere here. All they have at best is the hint of a possibility that maybe there was a collision. Their own case, their own expert. We'll never know. Just too much. Just too much. But I'll tell you, but there definitely was an accident because of all the non-scientific things. She's just straight up impeding them. And I don't think it's necessarily related to ARCA at all. It goes way beyond that. You know, this goes back to the first trial, and no, you can't argue third party culprit and all of that type of thing. She's been limiting the defense since, you know, long before this trial. It's just becoming far more obvious and far more explicit this time. I mean, what possible justification do you have from first trial, can't testify to injury causation because you're not a medical person, to now this trial? The medical person doesn't get to testify about the injury causation, but the dog trainer does. Explain the rationale to me. There isn't one. There isn't one. She set a standard of it's got to be a medical person. So the defense went out and got the best medical people in the country. So now the standard's got to change. This very much predates ARCA. This has been a problem since before the first trial. Danielle C., I have enjoyed the comedy you bring, albeit a serious matter, but this level of the bias corruption, even with phenomenal lawyers and experts, is daunting as we're getting closer to the end. Well, and if you think about it through that attrition kind of lens, that's the point, it makes sense. That the closer that you get to the end, the more obnoxious and difficult all this is going to be, because we got to punish the defense for defending. The more you defend, the more we're going to have to punish you. As soon as you stop defending, you won't get punished. Makes a lot of sense through that lens. We do have to try to have humor, guys. Black humor is fine. Totally fine. Probably healthy in many ways. Have a healthy sense of black humor about what we're witnessing here. Ocean Beach, love you, Andrea. Fun fact: did you know Alessi is a boxer and has had his nose broken at least 7 times? Ted Daniels told to Peter Tragos. Yikes! I did know he was a boxer. I've seen there was, like, I think it was one of the documentaries maybe had some clip of him shadow boxing. I don't know. I've seen the clip of him shadow boxing. Saw a photo his daughter posted. They both know their way around a heavy bag. So I did see that. Nose broken at least 7 times. I gotta tell, it's a lot of times having your nose broken. Okay, it's a lot of times having your nose broken. I've never had my nose broken. Sparred thousands of rounds easily. Never had my nose broken. I do bleed a lot, though. I'm a bleeder. You just look at me too hard and my nose will start to bleed. It's really, really annoying. The really annoying thing is that you can hit me square on in the nose and I won't bleed. But if you catch me with, like, the kind of hook, you know, that will like throw your head around, that'll make my nose bleed. It's crazy. It's wild stuff. That's a lot of broken noses. Hopefully he's learned to move his head. okay. Just move your head. It's all good. Keep it off the center line. Makes it a lot harder to break your nose. Alex Trev 006. Andrea briefly met you and Lee back in Delphi. I was sad to hear you think HJ again, even though defense case hung jury seems stronger to most analysts and Commonwealth's weaker. Is there no way you can ever see 12 not guilties as long as Bev's judge? Bev is going to definitely do what she can to assist anybody that is going back into that jury room with even slight leanings in favor of the Commonwealth. She's going to do everything she can to give them an assist. I understand a lot of folks do not trust the process of selecting the foreman or selecting the alternates. And I would agree that the process we witnessed during the first trial was not exactly transparent. Transparency left quite a bit to be desired as to how exactly that happened. So I understand some folks remain suspicious about that process. And I can't fault anybody. That's why you have transparency, is so that there's no need for suspicions to arise. So when you aren't transparent, show me you putting the juror numbers in your little bingo wheel. Show me all the numbers. Show me you turning the wheel. Show me you selecting, and show me the number that comes out. That's transparent. And that's how it's done in most courtrooms. Right out there in the open and in open court, so that there are no questions about how did the alternates get selected. Some reason that's asking too much in this courtroom. So you're not willing to be transparent, you're going to get the questions. That's the consequence. And it's natural and it's predictable and it's justified, because there's no reason not to be transparent about it. So, I have some concerns about that too. Is this going to be a transparent process to decide which of these 18 people actually end up back there with the power to make the decision? I'd be a lot more confident in a more impartial courtroom. I'd be a lot more confident there's plenty of transparency in the process. If the person who is sitting in chair number 1 is not instantly made foreperson again, then I'm going to question, why did we do that in the first trial? And what's the basis for choosing a foreman in this trial? And I'm sure I won't be alone in that. I think, just a big part of the problem here is the fact that the case is so polarized publicly. And we've reached the point where we've exceeded the tipping point as far as the jury knowing about it. We already know the jury knows about it. There was no realistic way, given the type of knowledge that the prospective jurors were coming in and acknowledging that they had about the case. There was just not going to be a way to pick a jury of people who haven't heard of it. And if you've heard of it, then you've probably heard opinions about it, and you've probably heard that there are strong opinions on both sides. Not necessarily because that's justified, but because, there's always some work to be done to carry water for the prosecution in the media. So, I'd love to say, if we were just going on the merits of the case, it should be an easy not guilty, very easy not guilty. But here we are. We're in this courtroom. We got, these impediments being placed on the defense. And we have a lack of transparency about who ends up in the actual jury room. How can I be confident with all of those other considerations? I just can't. And I would love to be back in a place where we can trust the court We can trust the process, and all we have to worry about is the weight of the evidence. And now you know a jury can always go anywhere. You never know what's going to matter, et cetera, et cetera. But you can usually get a lot closer, you know, a lot closer to predicting what the outcome is going to be. But we're not in that court. We're just not in that court. Thanks for coming to Delphi. It was awesome meeting everybody. All those people that were interested in that case. People traveled from really far to come and see and pay attention and stuff. It was great to meet everybody. Tanya D. If the prosecution brings in the dog DNA expert, will the defense be able to ask her about the keratinized tissue? Yeah, I would think they could. I would think they could. Don't know if they will, but I don't see why not. That was the result of her testing. DNA, keratinized tissue. AK, Andrea, I'm sure you're used to working with lots of different lawyers and you seem calm on the streams, but does your blood ever boil inside and your head almost explode from hearing Brennan? Yeah, guys, he irritates me just as much as he irritates all of you. I just have coping skills dealing with assholes for decades, you know. You just have coping skills, and that's part of why the dark humor is a big part of it. Doesn't do anybody any good to get so frustrated you go and bash your head against the wall, even though you might like to, but all that hurts is you. Doesn't hurt the other side, doesn't hurt the judge that's allowing all this to happen. I just have coping skills. He irritates me as much as everybody else. Everage, funny you mentioned Judge B. I was thinking about that in the first trial, she also seemed over it and couldn't keep up presence. What's so funny, Miss Reed? I remember that. That point just seems to have come up earlier this trial and more obvious. Yeah, I remember that. That was right at the end of the trial. Can't even remember what the context was. It might have been like jury instructions even. It was right at the end. Something funny, Miss Reed? That snapped at her. That wasn't too long after. Mr. Yanetti, you're making your argument to me, Mr. Yanetti, not these cameras here. Don't forget who you're trying to persuade here, Mr. Yanetti. Yeah, the longer it goes on and the better it goes for the defense, the more irritated she gets. And then when she gets irritated, she gets snappy and she makes bad rulings. Bad knee-jerk emotional rulings that she doesn't even try to justify the rationale for it. Just falling back on her favorite thing ever, her own authority. What if I order you? If I order you. AK, do you think Hank did it on purpose or a mistake? 100 bazillion% on purpose. 100 bazillion% on purpose. Of course he did it on purpose. Of course he did it on purpose for all the reasons that Mr. Alessi pointed out. It's in the record a whole bunch of different times. Your argument is based on trying to prove that there was an accident here. You've gone over all of this with a fine-tooth comb to be able to challenge all of the experts, give little hints to your own about the types of things he should look at and find and so forth. He knew perfectly well that the holes in the back of the sweatshirt had nothing to do with road rash. He knew that perfectly well. Despite that look on my face, you're still talking. Didn't Dr. Spaceship say he wasn't allowed on the property to take measurements? Funny how homeowners didn't have a problem with the defense investigator. Great minds, great minds. We both caught that. Hey, the homeowner is free Karen Reed. That gives me definitely a new opinion, new thought about who left that rock out on the front yard for the jury view. Don't think it was the homeowner. Don't think it was the homeowner because they're not fans They're not fans of the Commonwealth. They're not fans of the Alberts. Totally fine with the defense investigator coming in to do measurements. Surprise, show up last week. No problem. Make yourself at home. Voir Noir. Has it been offered at the grass stains on the jeans and lack of grass stains on hoodie, along with the rip pocket, could be from being dragged across the lawn post-mortem, perhaps from under his arms? Well, I don't think they have, because they do not agree that there are any grass stains on the pants. That is something that Buchanan, I said it again, excuse me, Yuri Buchanan. That's something he came up with about it being grass stains. There's no evidence of it being grass stains. It's a reddish brown stain. According to Maureen Hartnett, all of the reddish brown stains that she tested positive for blood. So there's no evidence that it is a grass stain. It's just something that Yuri made up. So I don't think that they are really focusing on that. Same thing with the tear to the back pocket. We went back and forth about this in the chat. Didn't come out, hasn't come out at all in the trial testimony, but a number of folks in the chat were indicating that that is routine for first responders to cut open the pocket to get the wallet, so that you can identify the person, get the wallet out. And that seemed to be consistent with what we were saying. So possible that that's an explanation for the pocket, the back pocket being torn. The grass stains are just not focusing on, because I think they dispute that there are any grass stains at all. Infoneurs, at what point would re-prosecution amount to harassment? If it were one and done, they may be more selective of what cases to move forward. If state can't prove case, it seems quite unfair to keep putting someone through this. Well, I agree completely. And the answer to your question about at what point would it amount to harassment? At no point. They could do it infinitely. They could do it until she's dead, basically. Once she's dead, you can't try a dead person. If they kept getting hung juries and mistrials, theoretically, absolutely nothing preventing them from continuing to retry her until she dies. That's what the rules allow. Double jeopardy not implicated unless there's a verdict. So if there's no verdict, get to keep doing it over and over and over again. I agree with you as a matter of policy. Yeah, it should be one and done. You got your bite at the apple. You did not convict the defendant. That should be that. But having a rule like that would be inconsistent, you see, with the desire of prosecutors and far too many judges to put accused people in jail. So you can't have a rule like that. Can't be double jeopardy based. You would need a legislature to actually adopt a rule like that. You would need a legislature to adopt a rule like that. Duncan, Idaho. Whoa, remember the prince that Princess Vespa was supposed to marry in Spaceballs? The one with the blonde hair and always yawning, casting for Bev. Guys, Spaceballs is a lot of years in my rear view mirror. I don't know that I remember this character off the top of my head. Let's see if I can find this real quick. Prince in Spaceballs. Prince Valium. Okay, here he is. Here he is. We'll go ahead and share him. This guy, Prince Valium. I don't know. This Bob looks a little too smooth, structured. A little too nice, I think, honestly. A little too put together. Just my take, but, you know, we can have differences of opinion about that. Transparency. How did the last mistrial happen? I never watched the original trial. The last mistrial happened because the jury was unable to reach a verdict. The jury hung. The jury hung. And there was then a whole big post-trial dispute over whether they had in fact hung on all of the charges, or if, as 5 of the 12, I believe, came back and gave affidavits attesting to, they actually did unanimously acquit her of murder and of leaving the scene of the crime, leaving the scene of an accident, but they hadn't filled out the form, so it didn't matter. Wasn't considered a verdict for any sort of legally enforceable reason. But the reason for the original mistrial was a hung jury. Robin Hall, I picked up some Milani mascara over the weekend per your rec and had a Daubert flashback. Every time I get Milani, I do. In fact, I sometimes, go straight to Milani check, see if they have what I'm looking for. But I like their stuff anyway. It's pretty good quality. I got some Milani shadow today. I don't know. I particularly like it, but hey, you know how to market. You know how to market. Young Black economist Ian doesn't have published studies on frozen phones. Excellent observation. Clearly not qualified. He's never even published a study on putting a phone in a freezer. In fact, there's no body of evidence, no body of literature on putting phones in freezers either. He's like, I wasn't even able to make sense out of this because I didn't really know what I was doing. I just stuck it in a freezer. It wasn't controlled or anything. Yeah. Yep. If it wasn't double standards, there wouldn't be any standards in this trial. The whole truth. Can defense use Hank Brennan misleading jurors and witnesses about the holes in their clothing in their closing? Nope. Hank misleading them is not a fact and evidence. Now they can point out that, they asked Dr. Wolfe about the holes as if they were road rash, and jury's been instructed that it's not, that those are cuttings. They can call attention to the facts. But, I suspect an argument that Hank crossed the line, misled the jurors by presenting that information in that way. No, that would be sustained. It shouldn't be. Should be fair game. I want to be clear about that. Should be fair game. Judge had to give you an instruction to correct that because they don't even know. They can't even be bothered to keep track of what their own experts have done with the clothing. They can't be careful enough to make sure that they're not misleading about the nature of the evidence. So much so you had to get an instruction to correct the record after that series of questions. Should be allowed, but it won't be. Vicky McNamara, appreciate you, Andrea, and the mods. Thank you, Vicky. I appreciate all you guys, and I definitely appreciate the mods. Very, very much. Do some great work around here. Sometimes I know it's a little difficult to entertain contrary opinions, contrary viewpoints, and things like that. But we are in favor of that. We favor debate here. And so if people behave, people aren't rude, people aren't being jerks, people are allowed to have different opinions. And everyone else is allowed to tell them how wrong they are and why. So that's the nature of the chat that we have. It can be difficult, for the mods to have to kind of navigate that, and we're not trying to shut people up by any stretch of the imagination. We're not a keep things on topic channel. Talk about whatever you want. Talk about whatever you want in the chat. Like, we're here to chat. We're hanging out. It's all cool. But understand, you know, people have different ways of expressing things and so forth. And some people like to flame and all that. So it's a very important job that the mods do to keep everything in order, keep everybody behaving well while still, you know, providing us with an environment where we can have rich debate. So I really appreciate everything that they do to help us with that. Ms. Real Lou, can the defense bring up that Brennan has lied to the jury in closing? Nope, not as such. Not as such. I don't think they can. April Michelle, I'm sure you answered before, but if there is a not guilty, is there any consequences for judges' bad rulings and obvious bias? No. Nope. Nothing. Nothing. There'll be nothing. She will move on. She will continue to be a judge for as long as she wants to and gets to be a judge in the state of Massachusetts. She'll keep doing exactly what she's doing. There will be no consequences. Kate E., sorry if you've answered this already, but in what ways can AJ ask this witness open questions and let the jury watch objections to her answers? Well, so the objection would have to be to the question. You can't really object to the answer unless it's non-responsive. By and large, it's a question that's improper. And so that's the main reason that Hank has been able to, you know, get anywhere with objections. A lot of these objections is because AJ does tend to be leading. And so you're in a little bit of a tricky situation with somebody like an expert, because you do need to direct them to what you want them to talk about, but you can't be so focused on what you're trying to elicit that you put it in their mouths. Now, Bev is taking a very restrictive approach to what constitutes a leading question in this context. So let's have a refresher on this. A leading question is one that assumes the answer in the question. It's one where you're telling the witness what I want your answer to be. So something like, isn't it true, Kate E., that you paid $4.99 for this super chat? That's leading. I'm telling you, I know what answer I want. The answer I want is it's true. And I'm telling you that in my question itself. But if I just say, Kate, did you pay $4.99 for the super chat? That's not leading, because you can answer it however you want. You can say no, you can say yes. But Bev is taking this very restrictive view of what the defense is allowed to do when it comes to, you know, asking these types of questions, and she's broadening the leading question, where just basically if it incorporates too much of where you're going, it's going to become leading, even if it doesn't actually cross that bar of telling the witness what you want the decision to be, what you want the testimony to be. So that's a little bit unpredictable as well, that they have to deal with. So the ways that you generally ask open questions, you know, what your who, what, when, where, why, how. Your general way of asking those types of questions. What did you observe? What did you do? What did you rely on? What methodology did you use? Did you ask any? What if any? That's how you know. That's how you know that you're not using a right definition of leading questions. If your solution to a did something happen question is being leading, you can solve that by saying what if any did. That's how you know, because did is open-ended. You get to say yes or no. It doesn't change that structure by suddenly turning it into a what if any. But that's that has been repeatedly a little bit of a cure to this. But that's a general answer to your question. What sorts of studies have you reviewed? So let's say she gives a list of studies and she forgets one that's really, really important. And Bev isn't allowing the kind of reorientation of the witness where you say something like, are you familiar with any studies on contra coup injuries? Just for example. Leading, objection. What they're doing, what AJ's doing is he's just going back after he's given the leading question and gotten objected to it. He's just going back and saying, are there any other areas that you looked for studies about? She's already heard, oh yeah, contra coup injuries. I didn't mention that. Other ways you might be able to highlight them. Are you forgetting? Did you forget any? Is that everything that you relied on? Would it refresh your recollection to see your report? Takes a little bit more time. It's not a particularly efficient use of the jury's time for you to be all nitpicky about questions that aren't really leading, but you don't like how much direction it's giving the witness about where you're going as the lawyer. But it can be done. It just makes it a little bit more complicated sometimes if you aren't on the same page about where you're going. Teresa Kaufman, so tired of Bev referencing time in defense case. Time in court? Seriously, when Karen could spend every minute of her life in prison. So aggravating. P.S. Alessi is a boxer, so is his dad. Yeah, seen that a couple times. It takes the time that it takes. And the representations to the jury about the time are nobody's fault but yours, Bev. They're nobody's fault but yours. You're not a brand new judge. You've done trials before. You know that things are unpredictable. So your commentary to the jury about the time, it's particularly inappropriate where for 7 weeks everything has been fine and hunky-dory. I should say for 6 weeks, while the Commonwealth is doing its case, everything's fine. We're not only on track, we're ahead of schedule. But now we're on what, like day 6 of the defense getting to present witnesses, maybe day 5. Have to go back and count. Now we're real concerned about the time, and I think we're still on. I don't know if we're still on. We're going to be very respectful of your time. It's in very poor taste, Judge, because the only reason that the jury has any expectations about the time at all is because of what you told them. But everybody seems to be allergic to accountability in this courtroom. She can't be responsible for what she told the jury, who she relied on, her own assumptions. You know perfectly well things happen all the time, and that a lot of how long things take is outside of the defense's control. Because if the other side is just going to berate your witnesses for no reason for several hours over nothing, and you're going to allow it, then it's going to take more time. Guess what? That's not the defense's fault either. But we're just allergic to accountability in this courtroom. Guys, if you don't mind, I am going to pause real quick again so that I can run and top off my tea while we finish getting through the rest of your comments and questions. Suck this one dry. I don't want to be slurping into the mic more than I have to. So just a moment. Hang tight. I will be right back. All right, guys. Thank you so much for your patience, accommodating me getting a little second to get refreshed. Bullshit is really dehydrating, guys. I'm just here to tell you, when you got a lot of bullshit to have to tolerate, it sure does make a person thirsty. Everyone needs a drink. It's just that mine don't have the same kind of soporific kind of effect as a lot of the drinks that many other people need to cope with a case like this. Let's get back to your thoughts, guys. Bird, are comments in front of the jury, late motions, limiting the doc's opinion, and Hank's dirtbag stunt good appellate issues? Comments in front of the jury, potentially. It would help. It would help if a record was being made that these comments were being challenged and that she's, being asked to not do that, correct them, give a curative instruction, something like that. We saw she had to do it once already early on in the case when she had some, knee-jerk comment that she made that was highly inappropriate. And she went back and told the jurors, "Oh, jurors, I shouldn't get frustrated. So if I've said anything that implies that, disregard it." She had to do that once already, but we haven't seen them making a record of that since then. So if they are doing it at Sidebar, yeah, they can preserve that. They can make that an issue, but I would want to see that happening for that to be really viable as something to raise. Late motions, discretionary. It's just, you know, part of the total picture of the case and the lack of fairness. In and of itself, like as a standalone, it's not going to be an issue because she can decide to hear late motions if she wants to. It's just going to be, how does that contribute to the overall picture of what happened in this case? When you bent over backwards to let the Commonwealth break the rules and you relax deadlines for them and so forth. Meanwhile, the defense doesn't get to defend because you applied the rules differently in their circumstance. Limiting the doctor's opinion, yes, appeal issue. That's an appeal issue. That goes straight to the right to present a defense. A lot of times these types of issues, they are evidentiary. They are not your strongest issue to work with. So what you're typically looking for in that type of situation, I mean, you can always go with no reasonable judge would reach this conclusion. And frankly, these are bad enough decisions that she might be in that ballpark. It's hard to get there, but she might be there. Because I don't know how you get to the pathologist can't testify about injury causation, but the dog trainer can. Less than a year after you insisted that only the medical people could testify about a dog bite, there's no rationale that's articulated. That's what makes it look arbitrary. So she might very well be in that ballpark of no reasonable judge would reach the same decision on this one. But typically what you're going to be looking for is misunderstanding or misarticulating the standard, the legal standard, the medical standard, whatever. So it's a little hard to do that when you don't actually have an articulated standard, right? Just she's not qualified. She doesn't have the experience. Well, that's where you just go in on your appellate brief. She's done 50 autopsies of dog bites. She's taught classes on dog bites, recognizing dog bites, and she's been qualified in federal court as an expert on identifying dog bites. So absent some sort of explanation as to how that's insufficient or what the standard would need to be for Bev to say you've got enough experience, no reasonable judge is going to agree with that. And she doesn't have something to point to where she can say, here's what the standard is, and this falls short of it. So she's just kind of making it up on the fly. Hank's dirtbag stunt, they'll say cured. They'll say cured. The instruction cured it. Shouldn't have happened. Bad stuff, but they were able to fix it. The issue in that respect is going to be, we've already had a motion to dismiss this case for cumulative, repeated prosecutorial state misconduct on the part of Mr. Lally, on the part of Trooper Proctor, on the part of Yuri Buchanek. Everybody who was involved with the shenanigans with the Sallyport video. So that's where I see this fitting in, is if there's some kind of perhaps renewal of that sort of motion, we can just add to the list now of the prosecutorial misconduct. That one is still, it's a long shot. That one's a long shot on appeal. Because at what point do you say, you know, there's no other possible remedy here? It's going to be differ. It's going to differ in the opinion of different judges. You and I have probably already crossed that point, probably a long time ago. But judges look at it from a standpoint of how can we save the process? How can we save the time and the energy and everything that's already been invested? So how can we uphold it? And with that attitude, just be like, well, it was cured. No big deal. Kristen from Manhattan, can Karen Reed present a rebuttal? If so, what would this look like? It seems unfair that the Commonwealth will continually get the last word. Doesn't appear that she gets to present a rebuttal. And they're certainly not talking at all as if that's contemplated. And, you know, if the Commonwealth if they're supposed to be limited in their rebuttal anyway, then it would make sense, that her sur rebuttal would be limited if she got any at all. So no, I don't think it's going to be allowed. If it was going to be allowed, it would be limited to rebuttal, right? So Hank says he's going to call Dr. Welcher. Hank says he's going to call Terry Kuhn. He had said before Maureen Hartnett. It's not clear to me whether he still wants to call Maureen Hartnett back or not. But those three. So if she got to do sur rebuttal, it would be limited to just responding to what those three said. But it doesn't look like she's going to get that opportunity. Guys, the remedy, remember, never forget the remedy for the repeated violations of Rule 14 that happened at some unspecified point with ARCA. The remedy for that is supposed to be remedial, put the parties back on the footing they would have been on had there not been, delays in disclosure and so forth. But that only goes one way. Apparently that only goes one way. Because when Mr. Welcher is going to do rebuttal, the remedy is to go ahead and let Mr. Alessi leave the courtroom for a little bit and prepare once he finally gets that discovery. In a normal courtroom, it would look like responding to the rebuttal case. Unfortunately, that's the best guidance I can give you. I love Kitty 73. Today was crazy. Did I miss Judge saying to Crash Daddy, you are all set because of what happened after? I didn't catch it either. I've kind of, it's just in the background now, background noise. It's so routine. I didn't notice her saying it. I didn't notice her not saying it. I just took it on faith, I guess, that she did say, Dr. Wolfe, you're all set. But I couldn't actually swear to it that happened. Katie did. If she is found guilty, how long do you think the appeal will be? They have so many issues here. Appeals never are less than a year. And 2 is realistic. 2 is realistic. Guys, I'm still getting decisions on cases I filed briefs on like a year and a half ago. Appeals take a long time. Say 1.5 to 2 years minimum is how long the appeal process takes. The Squid, I'm betting Aperture is having a hard time testing for rebuttal without making it obvious they are lying. I doubt the dude who has been pursuing his degree for 17 years knows enough big words. Well, the irony would just be, oh, so now you can show up in court and do testing? You couldn't do that before, but once somebody else did, now suddenly you can? Didn't occur to you to maybe do that before? I don't know what testing they could think of that's going to rebut this. You going to hit a dummy that you don't suspend? I don't know. I wait with great anticipation to see what Aperture has finally been able to get around to doing for $350,000. Kate E., with everything we're seeing, why should people assume the jury is pure and uncompromised? It's a taboo notion to even wonder, but realistically, we're supposed to be shamed by there's no evidence. There's no evidence. So we're supposed to trust the process. We're supposed to trust the process. See, this is why it's so important. This is why it's so important for the institution to have credibility, for it to have and continue to earn our trust. Because we're supposed to just take it for granted, hey, if there's no evidence of any type of interference, any kind of plant on the jury, any sort of subterfuge to make sure people with certain leanings end up in the deliberation room, perhaps even guiding the conversation as the foreperson. Supposed to be able to take it on faith if we have faith in the institutions. So then what happens when we don't? Yeah, then people get suspicious. Those things go hand in hand. You don't trust the institution, then you don't trust the processes that they put in place when they aren't transparent with it. We're supposed to be shamed into saying you can't say that, there's no evidence. But we have no reason to trust this institution. It's shown itself to be untrustworthy. Carolyn Smith, Colin Miller has some really good sites on his Twitter for letting Laposata talk about dog bites. I'm going to write that down because I don't know who Colin Miller is. Sounds like maybe a good follow. So I'll go check that out. I don't know how you get to she's not qualified to testify about dog bites. 10 times more autopsies than you thought. When you were like, that's not going to be enough. Oh, 10 times more? Nope, still not good enough because she already had her mind made up before we had the voir dire. D-Kit, the case has gone beyond any possibility of surviving appeal. Hank knows it, so nothing short of criminal conduct is off limits to him. Lawyer gone bad. It's clearly a Hail Mary type of stuff. I mean, that does seem pretty clear. He doesn't care if he poisons the well. Why not? Why not? If that's the only way, that's the only way for him to win. He's not going to win if he doesn't. So he might as well, because he already knows no consequences in this court. He's running the show. She's not. Frankly, I don't think criminal conduct is probably off limit to him. Wasn't off limit to his favorite famous client, was it? Amerigator, looks like you got some sun over the weekend. Looks good on you. Well, thank you so much. I got to go out and paddleboard yesterday. It was awesome. First time this season. Got to go spend a few hours on the water. It's fantastic. Do you think Bev would have had grave concerns if AJ would have pulled HB's stunt with the holes in the sweatshirt? Oh, can you imagine the lecture we'd get about the grave concerns and the candor, and I have to be able to trust what the attorneys are saying, and yeah, because we've already seen it. We've already seen this double standard in effect. When she's concerned about what the defense misrepresents, it's a cause for grave concern. When the Commonwealth lies for like a year and a half about Sallyport evidence, we don't even get they really shouldn't have done that. Mr. Lally really should have inquired more diligently before he signed a certificate saying that he did, when in fact there's other stuff out there. And in fact, case law that I myself cited maybe a week before this supports that the false certification by the prosecutor, it's misconduct, grounds for sanctions, etc. We've already seen the double standard, so of course it would have been a different situation. CSI Junkie, can the defense amplify jury instructions on letting them know that they do not have to find guilty on all counts, since Bev left that out on trial 1? Anything that is in the jury instructions, they can repeat, they can focus on, they can discuss, they can bring it to the jury's attention. Now, I would fully expect Hank Brennan to be on objection mode if that were to happen. He'll be objecting. Your Honor, they're not allowed to instruct the jury on the law. The instructions are the law instructions, and they're misstating the law, and et cetera, et cetera. And because it's Hank, she'd probably give it to him. So I don't know how far they'd be able to go with that. But just at the very basic level, you can reread the instructions to the jury. Any part of them that you want them to focus on, you can just read it to them. And it's going to be very hard to find a basis to object to that. It's once you try to explain what that means to somebody like Hank, he'll start objecting. And somebody like Bev, she won't just be like, it's argument. You get to make your argument. She'll just give Hank what he wants. So they can try, and that might be prudent. but I don't know how far they'll be allowed to go with that. Duchess of Dissent. So is the no sidebar comment a green light? A green light for Brennan to cheat? It sure does seem to be a little bit of a dog whistle, doesn't it? We're not going to have sidebars anymore, so run rampant. We won't be doing anything about it if it happens. We've already seen her decline sidebars a couple of times. Is that what's going to happen tomorrow? The defense requests sidebars. Is she going to deny them? Just let Hank run wild? She might. Which is a good insight. If we're not going to have sidebars, that means we're not going to have any sort of discussion of the rules or enforcement of them. No bringing everybody together onto the same page. We're just gonna stick around in mind reading mode where we're all supposed to know what Bev's standard is. When she's not good at articulating standards, and to the extent you have normal expectations of courtroom civility and decorum and rules and so forth, and Hank Brennan routinely rides roughshod over those, we'll just ignore that. No need for a sidebar. Very good insight here. Ashton, one of two. I just want whoever crosses Welcher on rebuttal to ask if there is a study specifically saying that the blue paint test is the approved method to test injury pattern of this specific scenario. Give them back some of what they're dishing out, right? Not a single study you can point to, not a textbook, no class that you went to. The difference, see, here's the thing though, the difference between the Commonwealth's witnesses and the defense witnesses, we've talked about this before. Defense witnesses are honest. They're honest. And that's why you'll get a Dr. Russell admitting, yes, I did ride over to court with the defense team. And it was suggested I could ask for a transcript. I could ask to see a transcript if you're presenting me with a testimony. She's honest, so she admitted that. Are we going to get honest answers from these Commonwealth witnesses? Or is he going to make some shit up on the fly? Make up some study? Because how are you gonna impeach him? Do you trust this guy to give an honest answer to a question like that? You're going to do it. You got to be very careful. You got to hem him into like what's in his report, what's in his presentation, what's his disclosed basis for his opinion. Nothing in there about some blue paint study that says this would be okay. Got to be careful about it. But I generally like this idea. I do like that. Ashton, so the jury can see him condescendingly balk at the stupidity of the question and therefore the standard being set by Hank. Yeah, you have more confidence than I do that he wouldn't just lie and make something up on the fly. Just make up a study on the fly. Oh, there's tons of them. Oh, I don't remember exactly maybe what the names are, the authors, but yeah, I've relied on them many times before. I can see him just making some random shit up like that. You have more faith than I do if you think that issue is going to stop him from advocating for his position. Linda BP with a super sticker. Thank you so much for that, Linda BP. Appreciate your support. Daniel Boone, I think the jury is fed up with Bev and Hank. I sure hope so. I'm sure fed up with them. I sure hope the jury is fed up with them, but we don't know. We don't know. Jury's had enough. They're ready for the case. Kind of hope so. Is that tells me about where they're at with their thinking. Gypsy Girl, Tobias Menzies as Yanetti, Henry Thomas as Alessi. Okay, I gotta look these names up now. Tobias Matthias. Who is this? Oh, Menzies. Sorry, I got it wrong. Tobias Menzies. Okay, that's this guy. Let's go ahead and take a look. As Yanetti. Yeah, I could see that. What have I seen this guy in? I got to look at his IMDb now. What has this guy been in? I recognize him from something. Oh, from Rome. I recognize him from Rome. That's where I would recognize him, guys. That's a good series. The Rome series, HBO, many, many years ago. That was a great series. I really enjoyed it. Yeah, have to flip through, see if there's anything else I remember. Not off the top of my head. Yeah, I vaguely remember him from being in Game of Thrones. Some other things there. Okay, I could see that. I could see that for Yanetti. Who else do we have? Who else do we have? Henry Thomas as Alessi. Maybe. Let's pull him up, see what you guys think. I don't think I recognize this actor. He does not ring any bells for me, but there is a little bit of a vague resemblance there, isn't there? I could see him maybe pulling that off. I gotta look at his IMDb real quick, see if he's been in anything I remember. He's been in a lot of stuff that I recognize, but I don't remember him at all. I don't remember him at all. But Gangs of New York. I vaguely remember that movie. I don't remember him at all. Legends of the Fall. I do not remember him in Legends of the Fall at all. I don't remember that at all. E.T., like the old original E.T. Definitely don't remember that. Yeah, I could see it. I could see it. I wish I had a better perspective on his body of work so I could get a sense of his vibe. But appreciate your suggestions there. Opto Poppet. If we end up hung again, can defense appeal for a writ of mandamus to force Bev out based on her awful rulings? They can try. It already didn't work. Relying on her rulings is very, very difficult because there is just a presumption that a judge acting as a judge, you have to rule against parties sometimes. Anytime the judge is asked to rule, somebody is not getting what they want. Somebody is getting ruled against. So it's hard to establish that. So you have to establish, best case scenario, a large pattern of wrongful rulings, and not just wrongful rulings, but probably like obviously wrongful rulings. And even then, it's just not clear that they're going to take that and raise that to the level of bias. I mean, typically when they're looking for bias, they're looking for very specific things. They're looking for a personal relationship with somebody involved in the case. They're looking for a financial interest in the outcome. You would think a pattern of I'm making a lot of bad rulings against you would be enough to create an inference that I'm doing that because I don't like you. But it's just not real clear that it is. So they can try. They can try, and maybe they would. Maybe at that point, what do you have to lose? But it's not clear to me that that would go anywhere. Also not sure that the writ of mandamus would be the avenue to do that. It might be. I mean, the first thing you'd have to do is ask her to disqualify herself. See, the issue with the writ of mandamus is that it has to be your only available remedy. It's extraordinary relief. So you have to have no other way to get what you want. There are other ways that they could get this relief. They'd have to exhaust those first. And so that means they would likely have to ask Bev herself, once again, disqualify yourself. Here's all our reasons why. She'll say no. I've made perfectly good rulings and I stand by all of them. And your next remedy is to appeal that. You don't have a right to interlocutory review, discretionary review before the whole case is done, but you can ask. Probably have to go through the process of asking. In all likelihood, we're pretty much stuck with her. I'll tell you, the only time I had an appeal where we were successful at getting the judge booted on remand was a case where there were, actually, I take it back because there have been three. There have been three that I remember, but only one was at my request. It was, the case had already been appealed, not with me. The Court of Appeals decided there was a thing that the trial court got wrong, sent it back down to for the trial court to do that thing. So it gets sent back down, and the trial court proceeds to talk about how stupid the Court of Appeals and the judges are, and how they don't know anything, and how if they wanted to know something, they could run for Superior Court judge and do that, and then proceeded to do the same thing that he did the first time that got him reversed. So I got that appeal. Remember the pound of flesh, guys? Remember the pound of flesh? Yeah, the client's in prison the whole time. So, you know, through 2 appeals now. Goes back up on appeal, and judges are not impressed with this, and the court's trial court's inability to put its own feelings about the law aside and do its job, which is follow the orders the Court of Appeals has given you, because that's what they are. They are orders. So in that particular case, we were successful at getting the judge booted off. That's the kind of thing that it took. You gotta disparage the Court of Appeals judges by name, and then they might pay attention. I had another case where the judge ended up getting removed, but I can't remember too much of the details because it was very similar. It was a case that had been up and down on appeal multiple times, went up to the Supreme Court, went back down, messed it up, comes back up on appeal, goes back down, comes back up on appeal again. Now I have it. Like, the whole thing is a mess. And at some point, the Court of Appeals decided, look, this judge can't just listen to what we're saying to do and do it. The judge is going to continue to fight and argue and disagree, and that's not the trial court's job. The Court of Appeals is the final arbiter on what the legal requirements are, unless the Supreme Court takes it up. In this particular case, the Supreme Court had taken it up, and the judge is still going to argue with the Supreme Court about what the right thing to do is. So it takes that kind of situation in my experience with my cases. Just the judge has made terrible rulings and is clearly pro-prosecution, is just not even thinking about these things, is just knee-jerk giving the prosecution what they want. They don't really care. Sad, but they don't really care. Colette Keenan, horrified at the conduct today. Are you worried for Karen Reed? Definitely. Definitely. The big concern in all of this is knowing how much juries tend to respect the judge. They look up to the judge. They think the judge is in charge. They think the judge is, you know, the most professional, laudable person in the courtroom, highest status, highest authority, earned their role, all that stuff. They think very highly of the judge. And so if they think very highly of Judge Canoni, just by virtue of the fact that she's the judge, they don't know her rulings are shit. They don't know that. And if you go in thinking Judge Canoni is great because she's the judge, and you're looking at what she does through that lens, then you infer what she does is right. And if she's having to do things that are detrimental to the defense, it's because the defense is wrong. It's a big risk. I'm very concerned about it. Ghost Horse, you do the best Bev impersonation and your channel is awesome. So glad I found it. Well, I'm glad you're here with us. I don't have the accent down. I know I can't. I don't. I don't know the Massachusetts. Mr. Jackson. You know, if she's gonna give us all this ammo, we're gonna use it. We're gonna use it, ladies and gentlemen. You've been so patient with us today. We're gonna try not to waste your time anymore with more of a defense case. Okay, I just want to give you my assurance that we're gonna wrap up this whole putting on a defense as soon as possible. Michelle, Bev might think she was a better defense lawyer than Karen's team. She might be siding with the Commonwealth when the defense doesn't do it like she would. Definitely gotten that impression. We got that impression from back when she said Michael Easter can't come in because you can achieve all this through robust cross-examination. And that just screams to me, you haven't cross-examined many cops. Look at Buchanan. Look at Yuri on the stand. And look at how he handled authenticating. That's exactly what cops do. You're the defense. You're not on their side. So they don't recognize anything that you hand them. They've never seen it before. They don't know if it's true and accurate. They've never heard of the rule that you're talking about, etc. As soon as she said that, I knew instantly you have a very inflated perspective on how good a defense attorney you were. Because I guarantee you, no, you're not having success impeaching police officers with their policies as the defense lawyer. It's not going to happen. Anybody who's crossed a cop knows that. So yeah, she's got an imaginary counterfactual going on in her head about not only I would do it differently, but here's how much better it would go if I did it like that. And it's so common. It's so common for people to have a movie going in their minds about, you know, how this cross would go and stuff like that. I remember back when Elaine was cross-examining Isaac Baruch and she had a script and you could tell. In fact, I remain to this day of the opinion that script was written by Amber Heard, because it's written by somebody who is like seen movies of how cross-examination works and so thinks they can write a movie, because you think you can script what the answer is going to be, but you can't. And that's why it blows up in your face in spectacular fashion when it turns out it's not actually a movie and it doesn't actually go according to script. So it's a very common thing to do. Just imagine, because how do you disprove that? Nobody can compete with a dream. With your idealized in your mind version of how you would do it and how much better it would be, that's never going to be reality. So nobody can ever compete with that. It's a standard that can never be satisfied. I suspect you might be onto something with that, Michelle. CC Agility. Did you see that DUI guy was in court a week ago and felt the jury was pro Karen Reed based on what they seemed interested in? It improved my outlook. I did see he was there. I am always extremely skeptical of any kind of observations about the jury that purports to analyze what they are thinking, what they're doing, how they're leaning. We don't know. You can observe behavior and you can guess things based on behavior, but they are guesses. We watched the jury during Delphi, and we saw all kinds of signs that suggested what they were thinking and what they were feeling. When we watched, or I should say when the jury watched the videos of Richard Allen's treatment while he was detained in the solitary confinement wing of the Westville Correctional Facility, We in the audience are not allowed to watch that. So we had nothing to do but to watch the jurors watch it. And we saw their reactions. And a lot of those reactions look an awful lot like horror, disgust. Turns out they weren't that disgusted. So I'm skeptical. I'm skeptical of any kind of effort to mind read the jury. I enjoy, like Sue and Jessica in particular are very good about just describing physical things. Who's writing, who's looking up, who's talking to who, because these things are observable and verifiable. But what they're thinking, that's just a guess. It's just a guess. I would like to think that they're pro Karen Reed, but I'm just not confident that we know that or will know that until we get a verdict. Jen Lux, thank you for being our brave leader in this fucked up trial. Hey, I'm glad I can be your guide on this journey through the criminal justice system. And as awful as it is to see stuff like this happening, I just can't tell you how validating it is to see so many people also seeing it and getting it. I've mentioned before, it felt like probably the first 10 years I was in practice, it just felt like nobody saw it, nobody cared. These things are routine and it's just the way the system is. And then like over the last decade or so, it feels like there's been this big shift in the ether. And that there's suddenly a lot more attention to and concern about the justice system getting it wrong. And about the justice system abusing people's rights. Like people actually care about that now. Maybe they always did and, you know, just wasn't coming across my radar. And that's just my perspective. Either way, it's very, very validating to see so many people recognize, yeah, this is a problem. This isn't how it should be. And maybe people will disagree about whether this is normal or like within the realm of what's normal to see in courtrooms all over the country. Maybe people will disagree about that. But as long as we all agree, it shouldn't be like this. It shouldn't be like this. Then we're getting somewhere. Then we're getting closer to, so then what would justice actually look like? Occiput boner. Bev requires a killer dog doctor doing autopsies. Yeah, I mean, can you even opine about injuries from a pedestrian motor vehicle collision if you haven't personally run down, I don't know, 50 or more pedestrians? I mean, 50 autopsies isn't enough, so maybe we need to make it 100. If you haven't personally mowed down 100 pedestrians in your SUV, are you even qualified to have an opinion? Gotta wonder. Ms. Pronounced name. How many times do you think we'll hear the word objection during closing arguments? I know it'd be considered bad form, but gestures that entire trial. This is very insightful of you, Ms. Pronounced name, because yeah, it is considered bad form, but you got to do it. You actually got to do it more in closing than you have to do in opening. So the opening is an argument. The closing has got your argument in it. And so common for there to be misstatements of fact, misstatements of law, and so forth. And if you do not object to things like that in closing when they happen, then you often get stuck with a standard of review on appeal that is very, very difficult to meet. We saw it, we looked at it last week, the unpreserved error issue in Massachusetts. If you have a constitutional error that you didn't preserve at the time, you can still raise it on appeal, but you have to meet a manifest injustice type of standard. You know, it just obviously undermines the whole fairness of the entire trial. Not just did it happen, was it wrong, and did it have effects, which is your kind of normal standard, you know, for harmless error. So you do have to object a little bit more in closing. That's kind of understood. But also, yes, it does constitute bad form. And it's really more of an issue for the defense than for the prosecution. The defense is the one who has to preserve error for appeal. The prosecution doesn't get to appeal an acquittal. They don't get to appeal a conviction. Why would they? I mean, they won, so. Yeah. Maybe we'll do a poll on that. Maybe we'll have somebody set the over under. Maybe we'll put that out to the great chat mind. What do you think the over under is on the number of objections that we hear during closing, and how many are going to come from the defense versus how many are going to come from the prosecution? Maybe we'll put that out to the chat mind to set, because I think we're going to hear a lot. I think Brennan is going to object a lot. Skippy1, as a non-American observer, are Americans proud of their judicial system? Bev would be shut down by other judges and lawyers very quickly in the UK. You're going to have mixed reactions. A lot of Americans are not proud of the justice system at all. That's why we've got a lot of, protest activity. We've got a lot of organizations. That's why we had the whole, Black Lives Matter thing was kind of big for a few years, at least. A lot of people who are not proud of the justice system. So that comes out, in a lot of different contexts pretty often. I think, to personalize this, I would like to be proud of the justice system. I would like to think when it's done well, it works. When you can have faith in the people, you have good people, responsible people, ethical people with integrity, all doing their part in the system, then it works pretty well. It's just that's such a big if. And we have so few checks against bad influences getting integrated into that process. So I think it's just one of these things where aspirationally, I think it's good, but in practice, we're all human. We have failings, and our system is not prepared to deal with failings like dishonesty, malice, bias. The system is made to protect itself. The system is made to protect the process and the participants. Probably it shouldn't be. But yeah, it's a very imperfect system as it is carried out in courtrooms around the country. Sandra, I know we are all so nervous about the verdict, but I just remind myself that the defense has a lot to work with for their closing, trying to stay positive. They do. They do have a lot to work with. And again, I think, I go back and forth on, because we always do, and it's normal. And the defense team, guys, is going to be doing this too. You're going to have, it's such a huge responsibility making the decisions about what are we going to do with this trial? What are we going to present strategically? What matters? What doesn't? What's our theme? What are we going to emphasize? What are we not going to pay attention to? So they're doing all of this too. I do. I wonder, like, just the things that have been left on the table. Hard call. But I also recognize a lot of wisdom in keeping it very simple and keeping it very tight. Keeping it very focused. If all that matters was John O'Keefe hit with a car? If we can convince the jury reasonable doubt that John O'Keefe was hit with the car, we're done. We go home. You don't get any of the convictions if John O'Keefe wasn't hit by a car. And that's what makes it such a good thing to focus on. Do you have confidence beyond a reasonable doubt that John O'Keefe was hit by a car? How could you? Because even Welcher doesn't. Even Welcher points out, well, all this data, it's not really anything but all this unscientific stuff. All the unscientific stuff that the medical examiner considered and came up with undetermined. The guy who got paid nearly $500,000. Great, he's convinced. Wonder why. They're going to have a lot to work with in closing. And I think it's not just that they have, you know, a lot of material to work with. It's that the material is good, because it does focus in on reasonable doubt, who has the burden of proof, and why they failed to meet it. And so it's can be an uncomfortable place to sit, being like, you didn't bring up the, where's the blood? You didn't bring up the John's phone and the problems with the chain of custody. You didn't bring up they had the password to Karen's phone the whole time. You know, all these things that are out there. There's so much that's out there that they could be going into. But the advantage of not going down that road, you keep it very, very simple. Very simple. The bottom line is, if there is reasonable doubt that there was a car accident here, we're done. We're going home. So I think there's good reason to be positive, because it's a strong position to be in. You don't always get to go in front of the jury and argue. Based on the evidence that's been presented, you have very good, very significant reasons to doubt a fundamental requirement of each and every one of these charges. You don't often get handed that case in a jury trial. Skippy 1, UK judges are self-policing. They deal with bad apples behind closed doors, and judges very often retire early for no apparent reason, usually push. Yeah, I noticed how early Judge Nickel retired. Like almost instantly after that Jeff v. Heard opinion. Sure, there was no relationship between those things. I think you might have some folks that would say ostensibly we do the same thing in the US. That there's policing behind closed doors, that there's pressure, you know, from the community as a whole. I don't really buy that. There's really no way to keep a judge in line who doesn't want to be kept in line. You got judicial ethics commissions that are extremely disinclined to do anything about problem judges, unless their hand is really forced, like it's so crystal clear that this person is abusing their authority that you just can't avoid it. But if you can avoid it, you will. It's one thing they don't want to do, rock the boat with the other judges. I think if we had a little bit more recourse when it comes to, hello, us peons over here that the system is supposed to be serving, for our opinions about this to actually matter, there was a little more opportunity for that, then maybe it would be a more responsive system. But it's hard to say. It's hard to say. Over here in my state, where we have elected judges, it's one way to be accountable to the public, right? But gotta tell you, most people just don't pay that much attention. Don't pay attention to the judges. Don't pay attention to the courts. Don't pay attention to what's going on. Don't pay attention to the problems. So even if you, incorporated something in Massachusetts where there's like a referendum, voter referendum on judges or something like that, not real clear to me that would accomplish a lot, but might be better than nothing. Alex, if this is another mistrial, can the appeal process start before the next trial date? Thanks for all the education. I'm a computer geek, not at all smat about law. No, the answer is no, because if there's a mistrial, that means there's no verdict. That means there's no sentence. That means the case is not done. And you don't have your right to appeal until the case is final. The decision is final. So it would be an interlocutory appeal, meaning, unfinal, and you need special permission from the Court of Appeals to be able to raise issues before the case is over. And one of the things you have to show, there's no, that the regular appeal process wouldn't provide an adequate remedy. Most of the time it will. That was Bev's whole justification for, denying the motion to dismiss. All these things are remedied by a new trial, and you're getting that anyway. So the Commonwealth's misconduct is remedied by the Commonwealth getting a second bite. Second bite at convicting Karen Reed. That's the world we live in, guys. That's the standard. So no, the appeal process is not going to start if there is another mistrial. Got to wait until the whole thing is over. And then there's a possibility of an appeal. They can ask for interlocutory review, but they're unlikely to get it. And even if they do, it would be probably very limited in scope. They might, though, but it would be something they would have to pursue, like, specially. It's not anything they would be entitled to at that stage. Kate E, clarifying my first question. Can AJ ask this witness, what types of wounds and causes of death are John's injuries consistent with and not consistent with based on your expertise? And then she says dog bite, not car crash. Along these lines, potentially. This particular question is compound, and so that would be the opening for Brennan if he wants to object. The form, ask it differently. Ask it differently, Mr. Jackson. It would be compound. So, but something along these lines. Have you seen injuries like this before? What sort of cause of death were they associated with? We already know she's not going to let the doctor say, I've seen thousands of motor vehicle injuries and these aren't consistent with that. So might as well not go down that road. But no, because Bev has said you don't get to talk about dog bites and you don't get to talk about consistency with car crashes. And so it's Mr. Jackson's responsibility to make sure that the witness knows these are the limits on your testimony that the judge has imposed. So if she goes and volunteers it anyway, that blame is going to fall on Mr. Jackson. And it will, even though Hank doesn't get in trouble for eliciting stuff that's not admissible, FBI, the agents, etc. AJ would. AJ would. She would hold that against him. So no, he can't try to work around the restriction by getting the witness to volunteer it. He's responsible for the witness saying it when the witness isn't supposed to. Lula Bella, who was the lady closest to the attorney podium today? Her eye rolling during Alessi's move for a mistrial was really awful. I didn't see. It looked like you're talking about the lady who was sitting next to, what's his name? Schillinger? Is that his name? The guy who's the appellate attorney for the Commonwealth. He's been the one that's kind of there in the camera view. There's a lady sitting next to him. I didn't pay attention to her during it, but can't answer that for you. Weird how the expressions in court too, that's fallen off. Early first couple weeks of the trial, didn't we have all kinds of concern? The jury, apparently. The jury is getting chastised for making faces. Then we had that conference, that weird Chambers conference with the family that we never heard exactly what that was about. But we came out and Paul, who's been staring down Karen and making faces and so forth, he's now moved to the back row. It's been weeks since that's been an issue. Since we pointed out, you're really not supposed to be making faces in court. Guess it doesn't matter anymore this far in. Michigan Farm Boy, one and done. If the legislature did adopt a rule like that, the court may ignore anyway. Congress passed law to allow suits against the federal government, and courts still say it doesn't apply in many cases because we don't like it. Courts do have a lot of ways of fighting legislative acts that they don't necessarily agree with. Where I think they have an advantage in this particular area is because it's related to double jeopardy. And the jurisprudence on double jeopardy has made it clear, double jeopardy, the scope of the protection you get's up to the legislature. And it's as simple as the legislature chooses to look at the same act and call it 8 different crimes with 8 different sets of elements and penalize it 8 different ways. It doesn't violate double jeopardy to convict you of all 8. As long as there's not a lesser included, as long as like you don't necessarily prove one of those by proving another one, the legislature has the power to define the scope of your protection under the double jeopardy clause by defining what crimes are. And so there's no limit on the legislature's ability to define crimes and create new crimes. And suddenly this thing that, 50 years ago was one crime, you walk into court today, maybe it's 20, and you can be charged with all of them. So we already have quite a bit of jurisprudential backing for the idea that the constitutional double jeopardy protection is extremely slim. That it's basically just a way of saying, as long as you don't get charged with exactly like 2 counts of the same thing for one act, it's fine. But if the legislature has defined different crimes, you can be charged with all of them. Oh, and different legislatures too, by the way, different sovereigns, they can charge you too. They can charge you for the same thing. You can be charged for murder in state court, convicted, taken over to federal court, charged for murder and convicted there too. And it's not a double jeopardy problem, because they're different governments. So it gives them a little bit of an advantage there, might make it a little trickier to find a reason, but courts find a way. Courts find a way. As soon as courts want to not do something the legislature wants them to do, separation of powers is a real obvious one they can go to. That's not your scope to decide. That's for the courts to decide. And then you got to litigate what the courts have the authority to decide. And who's the arbiter of the court's authority? Oh yeah, it's the court. So who's going to win that argument? I know. It's a mess. I hear you. I do. Ryan Cheek, what was Alessi saying re her instructions on the sweatshirt at the end of the day? Also, they saw garage at viewing. Yeah, they did see the garage. That was a good point. I don't think that, at least I didn't get the impression that Alessi was talking about the curative instruction that she had given. It could have been, because it was a little, it wasn't like real clear what they were talking about. I thought he was saying that they are, they're proposing an alternative instruction. It's not clear to me that that is an alternative instruction to the cautionary that she gave, or if we're just talking about some other instructional issue, like maybe we're negotiating the parameters of a missing witness instruction or something like that. It's just really not clear. But what I heard him say was that tomorrow they would propose an alternative instruction. So I guess tomorrow we'll find out exactly what that was about. E-Ray, this day makes me sad for defendants who don't have great representation. No defendant should have to fight this hard for fairness, and no victim should be denied justice by the very system whose job it is to ensure it. Oh, and if only this weren't, by design, if only this were a bug and not a feature. But all you have to do is look around the country and look at public defense funding, look at public defense caseloads. Look at how many people have no time to do anything at all, but meet their client in court for the very first time when you are telling them to take a plea deal. That is reality in so many jurisdictions around this country. It's a feature, not a bug. If it wasn't, defense would be properly funded, and everyone would have good representation, quality representation, be able to present their defense. But systemically, that's not what we have. It's made this way. It's made to just roll people over, roll them through. They said the quiet part out loud on the text chain. She pleads it's over. That's where all this is heading. That's where the majority of criminal justice pressure is placed on towards getting that plea deal. Then you don't have to try it. If you make the public defenders too busy to go to trial, they'll encourage more plea deals. You make them too busy to investigate the case, to meet with the client, to find out what other kind of information is out there. Oh, and also, by the way, put conditions, put time limits on your plea offers that are unreasonable, can't be met, can't possibly do an investigation before you make a recommendation on the plea. You do that too, that's allowed. This is all by design, guys. It's by design for convictions to be easy. It shouldn't be that way. Agree with you 100 billion% there. It should not be that way. This is not the system we should have. We're not meant to be warehousing people, and just because, depriving them of their freedom and putting them in a box, putting them in a cage, just because there's an elected government official and their staff that want to. But the whole system is pretty well designed to make it so that as soon as that prosecutor decides, I want this person in jail, you'll end up in jail. If it wasn't designed that way, we'd have defense funded, we'd have accountability for prosecution, we'd have accountability for judges, we'd have funding for defense experts, we'd have standards and rules that apply evenly to both sides. But we don't have that. It's by design, guys. Mrs. Debreefield, aka Hannah A. How's Welcher, who said he took one anatomy class, allowed to opine on John O'Keefe wounds, but the medically qualified Dr. Laposata cannot? Her rulings are inconsistent. It's because there's no standard. It's because there's no standard. No possibilities, she said today. We're not doing possibilities, really, because I'm pretty sure that Welcher testified explicitly. We can't know what any of these things are. This is just like one possibility with his blue paint. Not qualified to opine about a dog bite, but the guy who's supposed to be here to talk about force calculations and physics can rely on no physics whatsoever to suggest, oh, well, he just kind of rolled across the tail light and it broke his skin and caused the injuries like that. Great. So then we'll test that and we'll see that that's not possible. There's no consistent standard. It's just that's become evidently clear. Bino, poor Randy being dragged through all of this. Poor Randy. Poor Randy. Randy just wanted to, be out riding fences, man. So long. Oh, poor Randy, his feet getting cold in the wintertime. Who's going to play Randy? Who have we casted to play Randy? Anybody? Anybody got a suggestion for Randy? Debbie W. Fred Savage for Alessi, clearly. I totally forgot about Fred Savage, and I was trying to think of like dark-haired, curly-haired people. Should have been first in my mind, of course. Princess Bride, baby. Should have thought of that, but I didn't. I don't know why I went to Adam Brody instead, but I did. It's not even my era, the OC. I just remember it was on, so for some reason that stuck with me. That guy's got black curly hair. Fred Savage, good call. Kitty Carey, think they're making a mistake. The collective shadiness of McAlbert's convinced me first trial, not experts. Demeanor, actions of the whole house group. Yeah, I don't know. I mean, it does. It does. It's a gamble. There's no question about it. It's a gamble. And we're not going to know if it's a good one or not until we see if it pays off. There is always a risk that experts just get tuned out. The people assume, hey, they're hired guns. Of course, they're going to say whatever that party wants them to say. We can just rule it out. There's always the possibility. It's just too technical. I can't really follow it. I don't get it. So I'm not gonna pay that much attention to it. I personally, yeah, also very heavily influenced by the shadiness of the McAlberts. The shadiness of the McAlberts was, for me, in and of itself, reasonable doubt. You're covering up something. Maybe it wasn't this. Maybe it's something else that's got you scurrying to get rid of your phones and get your story straight and stuff like that. And maybe it's not hucking the guy out onto the front lawn at, 5 a.m, waiting for Karen to show up to blame her. Maybe it's not that. Maybe it's, maybe it's something relatively unrelated. Maybe you had drugs in the house. Maybe there was just other shady shit going on that you want to cover it up. I don't know. I don't know what your motivation was for acting so shady, but I know you did. And so I know when you don't come clean about it, for me, that's reasonable doubt. If you're not going to tell me why you're being so shady or even acknowledge that you're being shady, that's reasonable doubt. I feel you, Kitty Carey. It makes me nervous too. And I see both sides of this one. I really do. I really do. It is smart to make it simple. It's smart to make it tailored, focused, reasonable doubt, no collision. That's it. It does make the decision very easy, but it does leave a lot on the table. And we're not going to know if that's a good idea until we get a jury decision. Ms. Debreefield, aka Hannah A, buying a wig since I ripped out all my hair today. Get a better one than Bev's. No, I'm kidding. I don't think that would be a wig. You would just go ahead and toss that wig and get a new wig. M. Monge, 1967, the defense would like to recall Randy. What if Morrissey loses? Can his replacement take her seat since they are not voted on? Morrissey doesn't have any influence over the judge's position. The judge in Massachusetts is appointed by the governor. The governor has a council of, non-elected people that the governor appoints to help him make the decisions about who should be appointed to the bench. And then once they're appointed, they're pretty much on, unless the legislature decides to impeach them. The governor has some kind of authority to remove the judge, although it's a little bit unclear what the full scope of that is. Could they do it independently, or do they have to have buy-in from the legislature to pull it off? Not real clear. Or the Commission on Judicial Conduct boots her. Those are the only ways to get rid of the judge. So Morrissey has no role to play in any of it. I think the only thing that Morrissey getting voted out of office would achieve is, if there is yet another hung jury, you might get a new prosecutor who decides enough is enough. And it's time to focus some attention on some more important things. Like, I don't know, maybe we should go ahead and get around to charging Matt Farwell with a crime. Let's put that out there. Carrie Mache, Bev is not sighing. Medical professional here. I am begging you to look up why her breathing is labored and her mouth is open. She should not be a judge. I can't tell. I don't want to judge too much on the breathing, but she does seem to have if she was asleep, it would be like an apnea kind of heaviness. Is the impression that I get to it. It's like a gasping. It's like she's out of breath. She's got shortness of breath. Just sitting there at the bench, like talking alone is enough to wear her out. So I don't know what would cause that. I mean, I can imagine heart issues, lung issues, a few different things could cause that. I'm not prepared to diagnose her based on a breathing pattern, but I'm not really, prepared to diagnose people anyway. I'm not medical. I think some of them are size. They're just too well timed. Too well timed. But maybe some of them are more like heavy labored breathing through her open mouth. Maybe it's both. I'm not sure. Truth and transparency. Maybe it was asked, but can the defense put in for an interlocutory appeal for Bev's ruling today? They can. They will never get a decision in time. Just the Laposata limitation. They would never get a decision in time for it to matter. So you wouldn't bother. You wouldn't bother. You have too much else going on that's a higher priority than filing a motion that, even if it were, well positioned, there's not going to be enough time for it to do anything for you. Bev's made it clear this case is going to the jury by the end of the week. Court of Appeals isn't deciding anything before then. So there's no way for them to get it done fast enough. Their remedy will be, if she were convicted, to bring it up on direct appeal. Serena Blossom, should defense be asking for Bev's in-session decisions to be written rulings? Also, is her conduct heinous enough yet to form grounds for an appeal? Defense can ask, but they're not entitled to a written ruling. The law doesn't necessarily compel a written ruling. And if her handling of the objections is anything to go by, she doesn't want to do written rulings because she'd have to articulate her reasoning. And then she can be held to that. If you just say off the cuff, I'm denying it because she's not qualified, you don't have to spell out, okay, so what is the standard for qualification of a witness like this? You would be expected to be thorough like that in a written decision. Then you can be pinned down to it. And then they can point out if your standard is wrong. So it benefits her for all of this to be murky. Never to have to explain or justify anything any more than the bare minimum necessary. So they can ask, but they're not entitled to it, and they're probably not going to get it. So it doesn't necessarily do them any good. As far as her conduct, talked about this a little bit already. Very, very difficult to make any headway on an argument for bias based on the judge's rulings in the case, because it's just presumed the judge is going to have to rule against you from time to time. Ruling against you in and of itself doesn't mean she's biased. Now, if she rules incorrectly, repeatedly, over and over and over again, we might be getting closer, but it's tough. It's tough. So no, I don't think today gets us particularly closer on a bias argument. I think it's given us another potential issue for, reversible error. And it would come right back down to this judge. Do it all over again. Debbie J, I thoroughly enjoy your coverage and legal mindset. Thanks so much for all you do for us. Well, Debbie J, thank you so much for that. I really appreciate your kind words, your support. I really appreciate having all of you here with me to help go through this experience. It really is better to go through things like this with a group, not have to be alone. When we watched the trial the first time, that was a big comfort because of the gaslighting. There was just so much gaslighting coming from the Commonwealth. And I mean, there still is, but it's just, maybe it's not standing out as much because the case itself is shorter, fewer witnesses, etc. But it was a really helpful thing to have the group that helps us be gaslight resistant. When it's just you and you think you're alone, It might be easier to question your reality. You might be more inclined to wonder, like, gosh, he said he saw her take 9 drinks and I didn't see that, but maybe I just didn't know what to look for. Maybe I don't have the experience of watching surveillance videos. Maybe he saw stuff I didn't have. But when there's a whole group of you watching it and we're all realizing we didn't see her take all those drinks, it's not on the video, it makes you gaslight resistant. And that's been a very helpful part of having the group of folks watching the trial is you get to check. You get to check your inclinations like that against other people. Am I really crazy, or is that legit? So it's good to have that support, and we really appreciate you being part of that too, Debbie J. OG Kush, Joe Paul for Randy. Good old Trooper Joe Paul can be our dummy. Sorry, our mannequin. Our mannequin. We don't want to inflate his credentials. Definitely don't want to do that. Hannah A, original ET rescue Randy. That would be fun. That would be fun. The original ET was like 3'4", maybe. Small. Small guy. Are we gonna stretch him out? ET. Occiput Boner. In closing, can AJ read transcript of Welcher? He should be able to. You can definitely talk about the testimony and the evidence that's been presented. It's part of the purpose of the closing. Explain how that supports your theory of the case. Explain how the law applies to the evidence that's been presented. Explain how the evidence conflicts and how you think the jury should resolve it. So yeah, he should be able to read portions of the testimony. I don't see any reason why not. It's just calling their attention to something that is in evidence. That's perfectly proper in a closing argument. Ellison Metcalf Palumbo. I think the McAlberts were going to try to blame the snowplow until Karen Reed came back to the house. Lucky indeed. Yeah, I've said many times, because this has been, again, going back to before the first trial. It's just one of those common talking points, I guess. Oh, you'd have to have so many people involved in a cover up and a conspiracy, and all these people decided and got on the same page and so forth. Like, no, you don't have to. This could very easily just be opportunistic. That things went bad in the house, and all anybody in the house knew at that point in time was that they needed to do something to avoid police suspicion coming down on them. But they don't have to decide what it is until push comes to shove. Karen's going to be driving to the house now if John's not out there. It's always seemed opportunistic to me, and so it wouldn't surprise me at all. Wouldn't surprise me at all. He was going to be lucky. Might not even charge him. Might not even charge him, just it was a terrible accident. Nothing he did wrong, just didn't see. It was dark, it was stormy. Really unfortunate. John was drunk. John was on the ground. He didn't even know. It could happen to anybody. Terrible tragedy. He might not even be charged with anything. All it done. Off we go. Whatever the story was doesn't matter, and it didn't matter as long as it brought some law enforcement attention, the focus of that. Asking questions about what happened to John, as long as the focus went elsewhere, that's all that mattered. Zach Butson, any chance the holes on the back of the sweatshirt was going to be Welcher's big rebuttal point? Yeah, maybe. Maybe. No, I have a feeling it was the 26% reduction in the speed. I feel like maybe that was coming from Welcher. We'll see. We'll see. We'll see what that is. The holes in the sweatshirt, possible. Possible. Josh H., why did Bev let Dr. R get crossed on Dr. L's opinion about dog bites, but preclude Dr. L even present her opinion? The ref is trying to fix the game. You know, there's no rules, no standard. This was a late filed motion. This motion wasn't even filed when Dr. Russell is being questioned and being cross-examined. So how could she possibly anticipate that she'd be expected to apply a different standard down the road? She couldn't know that at the time. Only once the necessity of the moment compels it does she recognize what the standard is. Debbie J., Karen's dad was my professor at Bentley and was amazing. Your strategic thoughts about this case gives me hope. Well, thank you for that. That's a good connection. You know, Karen's dad and Karen's relationship with her dad and her dad's support for her, it's one of the bright lights in all of this to me. It's such a nice thing to see a loving and supportive father. See somebody who stands by his daughter and shows up day after day after day. He's there for her. I think sometimes we forget like what healthy families look like and what healthy relationships look like. I can tell you, I did a lot of trials. You don't have a parent there showing support, let alone day after day after day after day. A lot of trials, there's no parent there supporting that defendant. It's sad. Very sad, but it's also kind of the norm. Kind of the norm when you're talking about the bulk volume of criminal justice. You don't see dads like this. You don't see dads like this. So it stands out to me. It's definitely something to pay attention to. It's significant. It's good to see a good relationship with a parent. I guess I might have missed. It looks like I might have missed one from Michael Muddragon, and I don't have it to pull it up. But it was sent to me, so I'll read it out. Hank's argument that nobody took a dog bite and nothing but dog bites class, but not spelling it out because he doesn't want to tip his hand. Nobody's taken a class on just dog bites. That's his point. That's what he's got for his cross. Laposata is pointing out foundational to being a pathologist. It's in your textbook. It's on the board exam. It's just part of what you do to recognize patterned injuries. It's a pattern. You're taught to recognize it. But seemingly, according to Mr. Brennan, if you weren't taught it in a single standalone class, doesn't count. Where does that come from? I don't know. It's not a real standard anywhere, and does that even make sense? I think at least we see why there's such a convergence between the thinking of Judge Bev and the thinking of Hank Brennan. They don't demand logic. in their propositions. They both have a very flexible understanding of logic, and so that allows them to see each other's positions very easily. It doesn't even make any sense that where's the requirement that you have to have a specialized dog bite class? What if you just do 50 autopsies? No, that's not enough. Okay, 51. What's the magic number? None of it makes sense. There's no logic to it, but it doesn't matter. It doesn't matter because all that matters is the outcome that we're trying to achieve here. And the outcome we're trying to achieve here is make it extremely difficult for Karen Reed to defend herself. It's sad, but it's just becoming increasingly evident. That's what all this is about. Well, once again, edging closer and closer towards the end. We originally anticipated tomorrow based on the defense estimate, but, you know, obviously the defense is over here putting on a defense, and so we're having to deal with all of these distractions and wasted time. So it's probably not going to happen tomorrow because we'll finish up with Laposata, then we'll call Rentschler. Rentschler is not going to finish in just one day. So he'll carry over onto Wednesday. Bev is really nervous about that because that's making it more and more difficult for her to meet her mental deadline, which, guys, she hasn't announced, but I told you at the beginning of this, I already knew. Mentally, she is done. She is checked out. She's giving the jury the case this week. Now she's projecting that on the jury. Guys, they're done. They're ready to get the case. Now she's the mind reader about the jury. So we're risking her schedule, and that's maybe part of why she's a little pissy today. Just give it up and don't fight and don't make it so difficult. We don't have to have all these sidebars. If you just would ease up on the defending your client, we could get things done a lot faster. It's really important that the jury get this case by Friday because I'm ready to be done. So we already knew. We already knew that was going to happen. But so we're close to on track, but just enough to be suggesting to the jury that after 7 weeks of being on, if not ahead of schedule, now we might be slipping a little. Got up to 5. How much longer? How much longer are you going to be? 4 of them today. 4 today comments about the amount of time the defense is spending. Not cutting you off in any way, but Dr. Rentschler you're going to be done after him, right? And you're not going to spend too long with him. Okay. So we get ever closer, and we know apparently now that it's Laposata and Rentschler, then we're done with the defense case, and then we'll go to the Commonwealth's rebuttal, and we'll get Welcher, and we'll get Kuhn, and we may or may not get Hartnett, because that is now unclear. Not sure what she's rebutting or why, but she just kind of fell off the radar after that whole little problem with the holes in the shirt that she cut. Suddenly after that, we didn't talk about Maureen Hartnett anymore, but that's not clear to me at all whether that means she's off the table or just we're not talking about her. Shh, don't talk about her right now. So I do think that's where we're at timing-wise. I think to wrap up the defense case in the next couple days, finish the rebuttal, and her goal is we are going to have closing arguments and instruct the jury on Friday. We're going to give them the case. That's her goal. I'm pretty confident in that. So we'll see if she gets it. Means at some point they need to have a conference on the jury instructions. Waiting for that to happen. That'll have to be worked in sometime this week. Big waste of time for the jury, that jury instructions conference. Yeah. Needs to be done though. Pretty important step. And of course, we don't know the answers to some of those questions like, are they going to get a missing witness instruction? We can guess. I got a pretty solid odds I'm putting on no, she's not letting them have that instruction. But we'll see. We'll see. So one day closer, guys, one day closer. Monday we can check it off. Jury's coming in late tomorrow. We apparently are going to deal with Rentschler's motion, but is she going to be in court to deal with it earlier than the 15 to 20 minutes late that she sort of promised the jury to get started? I kind of doubt that. That would not be par for the course. That would not be routine to start promptly at 9 o'clock, litigate the motion, bring the jury in at 20 after. Nevertheless, that's what we have been led to expect. So I will be back. I will be back at 8:45 Eastern tomorrow. See if we get to have that hearing on Dr. Rentschler, or if we're just going to sit around and twiddle our thumbs and wait for the jury to show up. We'll have to see. Probably some of that depends on are they able to agree on some of the revisions to the slides. The issue seems to be the PowerPoint. One of the big takeaways from this, if I'm a practitioner in this area, one of my big takeaways is I'm not having my experts do PowerPoints. I'll tell you what, they're just going to go up on the stand and testify, because I'm not going to alert the Commonwealth to, things that they can go and try to nitpick. Try to get me, tripping on the hurdle at the beginning of the race before we've even really gotten started. I think I'm just not having any expert PowerPoints in my case, because all it seems to do is just invite a whole bunch of challenges to them. But it is what it is at this point. He's proposed it, so now we got to litigate it. Michael O'Houlihan, shirt holes and rash on Randy should be 26% larger. Hey, if we're just adjusting things by 20%, John's injuries should be 20% more pronounced, 26% more pronounced. I mean, you name it, all of it. It all gets offset. Good observation. So guys, we'll call it a day. A little under 11 hours today. It's just what it takes when you have a particularly obnoxious one, a particularly frustrating one. I get it. I really get it. I understand the reaction to this and the kind of horror that I see a lot of people expressing now. This is the system? Yeah, guys, it is. Yep. Yep. And the unforgivable sin that Karen has committed here, there's a couple of them. One, not just lying down and taking it, not just lying down and taking that plea. Sin number one. Sin number two, having the resources to be able to defend herself, to be able to hire this team, to be able to hire these experts, to be able to present this evidence. Major sin on her part, having those resources available to be able to defend herself. So she's going to be punished for that. And that's probably in large part why we are seeing the experts limited. Oh, you're going to spend all these money on the experts? Huh. I'm going to cut them off at the knees, not let them testify to stuff. Not going to give you a reason why, not going to establish a standard. Just say they're not qualified, because why not? It is frustrating, it's unjust, and I'm glad that a lot of you see that. I'm glad that so many of you see that. Because, yeah. Yes, it is. Yes, it is. Love to tell you this is the first time this has ever happened. Love to tell you it's super unusual that you got a judge putting their whole whole hand, whole arm, their whole 11.8 pounds. Bev's probably 216, don't you think? Putting your whole 11.8 pounds on the scale of justice. Love to tell you this is the exception, but it's just not that uncommon, guys. We're just seeing it. We're just seeing it here because this is a case people care about. But there are so many cases that go through the court day after day after day after day, where all these tricks, if not worse, are pulled, and it just doesn't get the attention because people don't care. People don't care about those cases. So I'm so glad to see this getting attention and getting recognition. You're absolutely right. This is not how it's supposed to work. It's not right. It's not fair. Now let's take that and look at the rest of our court's business. See how it's doing. And we're almost done with this case, so soon we'll have a chance to do that. We'll have all this time left, 11 hours today. We'll have 11 hours where we can go to other courtrooms, look at all the cases that nobody cares about, see what kind of tricks are being pulled in those, guys. I'd love to tell you this is rare and it never happens. It's just not consistent with my experience. So I'm glad that you see it because it is a problem and it shouldn't happen and it's not fair and it's not just. It's not. And seeing it is the first step towards fixing it, doing something about it, saying our government serves us, not vice versa, and we do not tolerate this. Not in our names. Not going to happen. Guys, thanks for joining us again today. Thank you for contributing to the chat. Thank you for all of your wonderful support. Thank you for your comments, your input, your insight, your jokes, your great usernames, all of those things. Your links to, other information, other sources, other things that are out there, the documents. It's a great resource, this chat, the brain power that we have collectively. Really, really value and appreciate that. Thank you to the mods for everything you do to make it be a place where we can share ideas and information and be a place where we're focused on getting it right. That's our goal. We're not here to cheerlead one side, cheerlead the other side. We just really want to get it right. And so when the process is working and helping us, we'll call that out. And the process is not working and it's getting in the way, we'll call that out too. Share what we know, what we bring to the table. It's such a wonderful resource. Thank you to the mods for helping it be the kind of place where that sort of information sharing is allowed and normal. We love it. We love that type of thing. We'll get through it, guys. We'll get through it. Do your deep breaths, not heavy labor through your mouth, not those kinds of deep sighs. The long in through your nose. Long breath in through your nose, guys. It's scientifically proven to help regulate your heartbeat. Something to do with the vasovagal response, pretty sure, but not 100%. Don't quote me on that. But I do know. Lower your heart rate, deep breath in through your nose. Really does help. Really does help. If you're finding that this is this trial, this process, this unfairness, this injustice, if this is bringing you anxiety and discomfort, those aren't bad things. It should. But we got to have our coping mechanisms. We've laughed, we've joked, we've made fun of people. We've done all of those good old standbys. But don't forget, sometimes just a very basic thing to do, stop. Take that nice deep breath. It really does help you feel a lot better. So bright and early tomorrow, guys. 5:45 Pacific. I'll be back. We'll see what Judge Cannoni has for us, what the day brings. I'm looking forward to Dr. Rentschler. They really are building up to a grand finale with him. Very different from the last trial where Rentschler really didn't get to say much material at all. So he kind of fell by the radar, fell, by the wayside compared to Dr. Wolfe. But this time it's really being set up for Dr. Rentschler to shine. So I'm really intrigued to see what he has to say. I think we should, fingers crossed, be getting to some of that tomorrow. So look forward to seeing you guys there. Get some good sleep, get some good rest. Take care of yourselves. It's another day tomorrow. We're getting ever and ever closer to the verdict. And hopefully, we can trust that the people that are sitting on that jury, that are like you and me watching this, are having a similar reaction, similar questions about how exactly is this fair? How exactly is this even-handed? We got to hope. That's all we got at this point. So I continue to have faith. It's hard. It's hard. I don't trust this institution. But I have faith in the idea of 12 ordinary people just looking at the evidence and deciding, has the Commonwealth proved beyond a reasonable doubt what they say happened here? And I think if they follow that obligation, it's very easy not guilty. So we'll see. Getting closer and closer every day, guys. I look forward to seeing you all tomorrow. Get some rest. Take care of yourselves. And look forward to it. Look forward to it bright and early tomorrow, guys. See you then. Take care.